I'd like to invite to preside this session my colleague, Justice Paulo Sérgio Domingues, who I'll be presenting shortly. We have as speakers the Judge Matthew Palmer, the Appeals Court of New Zealand, and President of Kawa Judicial Studies Institute. I'd like to also invite the executive coordinator of the Indigenous Peoples Articulation, which is APIB, the most well-known indigenous institution of Brazil, Kleber Caripuno, as well as Kokona Metuktile, who was with us yesterday. He's also here today. He's the vice president of the Haone Institute.
O cacique Raoni esteve conosco no primeiro simpósio internacional. Quem precisar de fones de ouvido, os fones estão lá fora.
Interpretation phones, they are up on the upper level of the auditorium, so we'll give you a couple of minutes to get your interpretation equipment. This event is transmitted live on YouTube, as well will also be part of the
televisão do Superior Tribunal de Justiça.
Of the schedule of the TV station of the STJ. All interventions will be available. Actually, some are already uploaded to YouTube. My colleague, Justice Paulo Sérgio Domingues, to my left, is Justice of the National High Court, STJ, who came from the federal justice system. He was a federal judge. Many years afterwards, he was a judge of the Federal Regional Appeals Court for the Third Circuit. He has a master's and a PhD in Germany and in the University of São Paulo, and he is one of the specialists in environmental justice in our court. Above all, he is a very dear friend of mine, friend of decades. The good thing about this court is that we oftentimes arrive here and find good friends that we know for a long time. Other times, we receive friends, colleagues from a variety of various institutions, state justice systems, federal justice systems, the Office of the Attorney General, from law work. So, we have a large diversity of members of our court. Justice Paulo Sérgio Domingues is a member of the first session of the National High Court. For those of you who don't know the structure of the court is divided into three large divisions, the main chambers: public law, private law, and penal law. Each of these have 10 members. In public law, we have evidently everything that has to do with this theme, as well as administrative law, tributary law, urbanistic law, environmental law, Indigenous Peoples Law, cultural heritage law, what would represent in other countries, for instance in Europe, the administrative Supreme Court. So we have these 10 justices that are part of the first session. The second session on private law and the third Grand Court penal law would correspond to the well, we have something like two large courts that would be independent in other countries that are part of the National High Court. Indigenous issues are actually dealt with in all three grand chambers, but mostly in the public law grand chamber. And so we have a QR code in which the library and the jurisprudence sector separated the leading cases, and you have in this leaflet a summary of some of these most important cases, or that were deemed the most important. Pass the floor to my colleague, Justice Paulo Sérgio Domingues. Good morning. For me, it's a great honor to be able to participate in this panel this morning. I'd like to thank my dear friend, Chief Justice Herman Benjamin, who, well, in fact, it's wonderful to be able to find friends of decades when we come to work in this court, as well as it's a joy to make new wonderful friends like Justice Teodoro, who's here with us. I'd like to greet him and so many others. The opening of the event yesterday night was a wonderful success. The opening of the exhibit was also amazing, and I'm sure that today we will also have extremely interesting panels and productive panels. So, first, in this panel on the universe of indigenous rights, we'll listen to Justice Matthew Palmer from the New Zealand Court of Appeals and the president of Tekura Kaiwakawa Judicial Studies Institute. We'll listen to Federal Congresswoman Celia Shakriaba.
Senhora
Kokona Metuktitire, as president of the Hauni Institute, and Tejo, indigenous leader. Well, Justice Matthew Palmer was a judge from the Supreme Court from 2015 to 2024. He was a lawyer, later counselor of the Queen and Toronto Chambers, specialized in public law from 2012 to 2015, vice or deputy prosecutor, and he was international researcher from 2006 to 2008, vice dean and director of the Public Law Institute of New Zealand, adjunct secretary of justice in the Ministry of Justice, analyst of the Treasury. He was also a solicitor in 87 and Association. He has a degree in economy and politics, and he has a graduation in law and has a master's and PhD in Yale. It's a great honor to receive you here in this panel, and now I'd like to give you the floor immediately. Thank you so much for being here.
Te rangatira Antonio tēnā koe, te rangatira Ministro Dominguez tēnā koe, e ngā mana, e ngā waka, e ngā reo, tēnā koutou, tēnā koutou katoa. I greet you in Te Reo Māori, the language of Māori, the indigenous peoples of New Zealand. My ancestors came to New Zealand from England, Scotland, and Ireland. So I am known in New Zealand as a Pakeha, which is a Māori word. It is my great pleasure to be here in Brasilia and my great honor to participate in this wonderful conference. Yesterday's opening was a spectacular event and the photographic exhibition was so impressive. I thank you so much, and it's a great honor to be able to participate in such a distinguished panel today. The topic that we are asked to consider today is very ambitious: the universe of Indigenous rights. That title reminds me of one of the books of The Hitchhiker's Guide to the Universe, Life, the Universe, and Everything. Or the movie, Everything, Everywhere, All at Once. I suspect that our panel will not approach the surreal nature of either of those, but the topic does have the advantage that each panel member can make of it what we wish. I wish to address three aspects of the universe of Indigenous rights. First, I will make a few general observations about the basis of Indigenous rights in legal theory. Second, I will make some brief general observations about the ways in which Indigenous rights manifest in the constitutional arrangements of some common law countries. And third, I will leave you with one single normative point about constitutional design and Indigenous peoples. These are subjects which I taught and wrote about as an academic over the past 25 years in a formal life, as well as a barrister. I was Dean, as was mentioned, Dean of Law at Victoria University of Wellington, and I wrote a book on the Treaty of Waitangi in New Zealand. Interestingly, I wrote that at Cambridge and at Yale, where I gained a more distant perspective of my own jurisdiction. I think comparisons are always helpful. But I am now a judge of the Court of Appeal of New Zealand, and Indigenous rights, as in many countries, is probably the hottest constitutional and political topic going around at the moment. So I will be suitably judicious and avoid political controversy in my remarks. Because claims to Indigenous rights can challenge in fundamental ways national constitutions, international law, and even Western jurisprudential notions of what is constitutional and what is law. But Indigenous rights are given explicitly labeled chapters in very few authoritative texts on comparative constitutional law. That treatment parallels how Indigenous peoples feel that their rights are treated in practice, particularly by national constitutions. So first, legal theory. Who is an Indigenous person? What is an Indigenous people? Is it people or peoples? Indigenous peoples themselves know the answers to these questions very well. But Indigenous rights pose a fundamental jurisprudential challenge to Western legal theory. The challenge is not just that of other minorities. Indigenous peoples are often minorities in nation states today, though not always, as Fiji and South Africa show. Indigenous peoples usually share the characteristics of other minorities being exploited by majorities. Professor Benedict Kingsbury suggests that claims to Indigenous rights appeal to one, several, or all of 5 different conceptual bases: human rights, non-discrimination; minority rights; historic sovereignty; the international law of self-determination; and Indigenous peoples' own law and policy. The last category recognizes that there is an additional moral claim to legitimacy by Indigenous peoples, a claim to historical connection to specific areas and to a distinctive worldview, which other minorities usually lack. For the Indigenous, theirs is literally an existential struggle. Unlike other minorities, if an Indigenous people does not exist as a group in its homeland, it does not exist anywhere. International human rights instruments were conceived in a Western liberal paradigm that has tended to locate human rights in individuals and to separate human rights from environmental rights and from spiritual concerns. Indigenous peoples conceive of their rights and obligations more holistically, as subsisting in collective groups. They conceive of the world in terms of integrated relationships among a community and its members, but also between a people and their physical environment and spiritual environment. The relationship with land, mountains, rivers, lakes, seas, wildlife. Some people define themselves as Indigenous, emphasize these characteristics of worldview more than being first to occupy an area. Translating between such perspectives and the atomistic language of individual rights requires a mind shift. The rights of a group to exist and to exercise autonomy and self-determination as a group are inherently collective, and that poses challenges to Western liberal philosophy of rights. There is a substantial but still evolving international literature on the conceptual underpinnings of claims to rights by Indigenous peoples. Some of this work is related to debates on the rights of minorities and jurisprudential status of culture. But the pragmatic political dynamics that lead to recognition of Indigenous rights are not always conceptually coherent. I do not delve deeply into these debates, but I do suggest that the distinctive moral and political claims of Indigenous peoples can test traditional Western legal concepts in ways that can make them grow. A number of scholars, particularly in Canada, have given us a richer understanding of the relationship between the theory of Indigenous rights and the practicalities of constitutional arrangements. Jim Tully, John Burroughs, Patrick Macklem have all offered views of the relationship between Indigenous peoples and the constitutional arrangements in a state. New Zealanders are also prominent in confronting these issues. Jeremy Waldron, Ben Kingsbury, Nicole Rowan questions whether Indigenous rights are best seen as overlapping constitutional authorities. The New Zealand Law Commission, with the help of one of my colleagues, Justice Christian Fata, has published recently a significant treatise on Māori customary law, tikanga, and its intersection with New Zealand state law, which is another very significant constitutional issue in New Zealand at present. So second, I want to move on to constitutional arrangements. There has been an increasing appreciation of rights of Indigenous peoples worldwide, from the Sami in Scandinavia, the Tuareg in the Sahara, the Assyrians in Iraq, the Ainu in Japan, the Saramaka in Suriname, the Mapuche in Chile, and we all know about the Indigenous peoples of Brazil. Almost every nation state has a group within its borders that has a claim to being there first and or being Indigenous. Many have more than one such group. In some states, such as Finland, Norway, Sweden, these groups enjoy separate political representation and enforceable legal rights. Some provide explicit constitutional protection in theory, but little in practice. Other states do not even recognize the claims or even the existence of the people as a collective group. I think that is likely to change over time, given the pressure of evolution of international law. Internationally, the claims of Indigenous peoples emerged particularly in the context of decolonization after the Second World War, in the context of the primacy of international human rights instruments. In general, the international dimension of Indigenous rights has been a fruitful source of assistance to Indigenous peoples against the power of sovereign states. The International Labour Organization developed conventions concerning Indigenous peoples in 1957, 1989, continues to monitor state compliance with them. And in 2000, the UN Economic and Social Council established a permanent forum on Indigenous issues, which included Indigenous peoples, to advise it. UN human rights institutions appoint special rapporteurs to investigate and report on specific Indigenous rights issues. Decisions of regional courts, such as the Inter-American Court of Human Rights, particularly relevant here, have also upheld Indigenous rights. Perhaps of most generic international significance, the United Nations established in the 1980s the Working Group of Indigenous Populations, where hundreds of representatives of Indigenous peoples and states met. I was involved in some of those discussions in the New Zealand government. And after 25 years of negotiations through the efforts of the Working Group, a declaration on the rights of Indigenous peoples was drafted and adopted by the United Nations General Assembly in September 2007. As an academic then, I was privileged to attend the General Assembly on the day the declaration was adopted. I brought my class down from Yale Law School to New York for the day. The declaration is often aspirational, but it is a striking example of non-national groups which span national boundaries, contributing directly to the development of international law. I note that Canada, Australia, New Zealand, and the United States, known as Kansas, were the only 4 nations to vote against the declaration, but they have since all declared their support for it. Rich developments of Western political and constitutional theory regarding Indigenous rights have come from those 4 former British colonies, where settler governments coexist as the majority with Indigenous peoples. These legal systems have had to struggle to digest Indigenous moral and political claims to land, resources, and political representation that have attained legal recognition at different times on the basis of different sources of authority and in different contexts. In the United States, you've got Chief Justice Marshall's trilogy of court cases. You've got the Indian Claims Commission. In Canada, you've got Aboriginal title rights. You've got the Constitutional Protection, Section 35 Constitution. In Australia, you've got the existence of Aboriginal title rights in 1982. In New Zealand, you have separate Māori electoral seats established in 1867 and from 1975 at the Waitangi Tribunal to investigate alleged breaches of the Treaty of Waitangi between the Crown and Māori. On the basis of that, the New Zealand Crown has negotiated a large number of settlements of breaches of the Treaty of Waitangi with Māori since the mid-1990s. It has also instituted a separate mechanism for negotiating customary rights or litigating them to the foreshore and seabed, which is still controversial in New Zealand, as a Supreme Court decision last week illustrated in recognising customary rights to riverbeds. The changing interpretation and legal status of the Treaty of Waitangi in New Zealand illustrates broader aspects of how Indigenous rights challenge and manifest in a national constitution. I won't talk in detail about the Treaty of Waitangi in New Zealand. Oh, okay. But what I will say is that in each of the 4 jurisdictions I have mentioned, Indigenous claims to existence have bubbled up through the legal system, through the particular legal mechanisms that exist in those jurisdictions. And this is the single point that I want to leave with you. My fundamental point is that these issues are not about doctrinal law or constitutional provisions. They come down fundamentally to relationships. The design of a state's constitution in relation to Indigenous peoples depends crucially on one question: how healthy does the state and the Indigenous peoples want their relationship to be? Because, as I said, if an Indigenous people does not exist as a people in their own land, they will ultimately cease to exist, and the world would lose the richness of that cultural diversity, which is so important to humanity. As long as an Indigenous people does exist within a state, the question is not whether they have a relationship, because neither the Indigenous people nor the state are going anywhere else. The question is whether they each want to have a healthy relationship. Ultimately, if the relationship between an Indigenous people and a state becomes toxic, the potential extreme scenario can be seen, for example, in Palestine today. So the key question for both the Indigenous people and the state is: how healthy do they want their relationship to be? How honest? How fair? How one-sided? And in relation to which issues? Once that is decided, then you can examine what particular legal and constitutional mechanisms which give expression to that relationship in the particular path-dependent history of that state should be created to maintain and enhance those relationships. You can decide what values should guide the state, and also recognize the great importance of the interests that go to the fundamental existence of Indigenous peoples. These, I suggest, are the fundamental questions of state constitutional design in relation to Indigenous peoples, and that is the question that we should start with: relationships, in examining the place of Indigenous peoples within the law and constitution of a state. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa.
I thank and greet Justice Matthew Palmer for the fantastic exposition and for the instigating question that he leaves us to think on in regards of the values that should guide the relationship between the state and Indigenous people. So I will immediately hand over to Madam Kokona Metoktiri, who is the Vice President of the Hauni Institute. She is a mother of 3 and a grandchildren of 2. She lives in the same village as her father, Chief Hauni Metoktiri, one of the main communities of the Xingu, and came out as a leader for interceding for the feminine, the women's requests and demands on a daily basis and participating in mobilizations outside of her territory. So I hand over immediately, thanking her for her presence and manifesting the joy of having her here with us this morning.
Mukroto nyule nyulukwa mabawaja. Mukroto nyule nyulukwa mabawaja. Ja ja ja. Ja 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 ja. Kati me temo ya kamera mono joy. Ibene kukuna me tukie. Ibambe romni. Bakam apeja pute me kaju me apeja ole hari. Kam tekre kami be visi. Bakam akatiakam yakam aminine. Nami bam amrebe abataimo umarija meikaju umarija ni pecho te marote ba puka ngo mini umarime yakaju mru umarime yakaju umarija marote ne arep ay akatiten nam arep kubengeten kanen klimbe amikaneo no me inyo kukraja kun bonyo pijo amikaneo no ba yakam amini me amo ikaben me amo ayane.
Bom dia a todos e a todas. Eu me chamo.
Good morning, everyone. My name is Kokuma Metutire, and I am the Vice President of an institution founded and created by my father, which is the Kauni Institute. My father has been defending life that is in nature for a very long time, as well as defending those of us who live in nature. This work my father has been undertaking is very important for us. Through his fight where he defends nature and the life of us indigenous peoples, is in virtue of this that we are living here in our own style, lifestyle, in our own territories. I'm here to be able to represent my father and also my peoples. So I can talk about the territory, our rights in regards to the demarcation of indigenous territories. And so what my father has been defending and doing, we are also here to give continuity to that and to his fight. Today, he is having health treatments of our own medicine and traditions, and because of this treatment, he was unable to be here in person to this event. But I see the important authorities here that deal on subject regarding indigenous people, especially on indigenous rights. Well, we are here to be able to contribute as well, to speak of our idea and conception regards to that, and so that you may understand us.
Taniba ialenya mala yakanega me apun haye muya kamali joy haminine ba nyanya menina bajo ikaben kaju me amine ikabene me nyombo me nyompuka me nyi ngo me mau mari me me nyi kaju ket kaju kali kwange akatinha kam game moyam me bunu maro abat kaju me malikene me bunu ampi ogni peine ho me kajuru ket ho me kangoi ket vome inyombo harek umari me amne kame nyokukura joka me ye kama menine me toro me dere me ba me inyokokren jo ye kukura jo ya o kama menin kaju imobok arek me mo mari me puka me mo me ngo me mo me ba me kaminyun kaju bimo kinyo akatinha kamba me inire ibam aliko tare inire jo ami puka ba me kaju ale kami juyanete ne kam yane game apunha ko ame kajur ame marikene tu me kama ju yane nyobo arene amne be hinyingen hikwatui mono jo tumkam me aye me kuya eko amone me wabikinyo amone kuka kunum me kajoro game are buto nare kam nyu nare kam aja pe kam ge jaga me kam bita aja pe nyonyi ba me ai biri di kaming nu are mi ye amini tia bo buka me ma me ne nono ya kam ikajuru ke ne nyu kaju tani ba katia kam o ale nyawane.
Estamos aqui com várias pessoas, né, que são os importantes
We are
para
here with several people that are important to deal with subjects
aos nossos
geared
direitos.
towards our rights.
Estou ouvindo, estou gostando
I am
muito.
listening to what is being said. I'm liking what I hear a lot
A tratativa de
on
direito de nós indígenas.
the dealings
Muitas vezes,
about our
para
rights
tratar
as indigenous
sobre
people. Very often,
os direitos de
to
nossos
talk about and
indígenas,
deal with our indigenous
acontece que
rights,
muitas vezes não somos ouvidos
we are often not
consultados,
heard, not
informados
consulted,
para
or
estar
informed
junto
to be
na mesa de
together
discussão sobre
at
direitos dos povos
the
indígenas.
negotiating
Muito
table to
Hoje nós
deal
temos
on our own
o
rights.
direito de ser consultado,
Nowadays, we have the right
direito
of
de
being
ser
consulted,
ouvido,
of being heard,
para poder decidir
to be able to
criar uma
decide
lei
and create
que
a
possa
law
nos fortalecer
that
em
may
defesa da nossa
strengthen
vida, em
us
defesa do
in defense of
do
our
nosso
life,
território.
of our territory.
Nós mulheres, Caiapó,
Us Kayapa women
também iniciamos
also
para atuar
started
em defesa da floresta,
acting in
da
defense
cultura,
of the
da
forest,
nossa língua, dos
culture,
nossos
of our
costumes.
language, and of our
Então,
customs
preservamos
and habits. So we
muito as
preserve
nossas tradições
our
cultural,
traditions,
né,
cultural
dos
traditions,
nossos
a lot of our
ancestrais.
ancestors.
Os colonizadores
The
tratam de forma muito
colonizers
violenta os nossos
treated
para
our ancestors in a very violent way in order to occupy our ancestors' space and
recursos
to
naturais
exploit natural resources according to how they
de costume
saw,
dos
understood
colonizadores.
their
Mas
habits
hoje
and
somos,
rights. But nowadays, We are
resistência.
a generation of resistance, and we have been preserving our habits, our customs, and our language, and our traditions a lot. So it is very important to have people such as you to listen to us and understand our relation with nature and also understand our own way of life in our territory with our natural resources. So we need you to understand and listen, to understand our people, our relationship with nature. This is what I ask of you.
Tanaya, kume apoy gali, haye muya kambalo amono, ya, kume aben bapia ne baja baby by marikaji, ne aben kajuruket, ya kaji ne ba, ya kamo ane nyawane. Katinya kan ba me nire harap muya maro. Amine ya ikaben harap kumo klai norte. Kam jagume muya kaji aben man aben wuru boy ne aben kam hachikot katot Mario batem nya kaji. Kam baja pi mei baye mari mei nya kaji niwe moya waben kajuru ne aben bunum ipecho baya ba imokenke mei ben okre ikukla jala on hiye kaben mari da on itoro inyo moya kuti ye mari da on ne kam mei nyo ikukla jala bingro nyo mo yan ba me imokenke Kraye me ye ikukla ja oi bingnoro kete me ka benra me ye amlei tabju mlai koi ma mla nyama ikukla ja ika ben yare na tani ba akati kam ane nyawane ne mala fudai kute me mo puka ba kanoko no tui mononya kalipai me inde iko ulke me aye me iko ulu ne ba mokin kete ba me are kam nye me te me pumoi na on me kot ka ngoi na on ya ka ju pekanoko kone me be me nyobika hapui bajali punyo playa tamia julkin me ame kajut kame waike moka me bengo krenyo hinyinge kwatri me nyopukakana ba me kam ojo hami puka oi no tươi như mày quả tươi mày no khâu mari mày hobi ken ke nya kaju are ne me klai na mi yo ai ke kan ba mi mo kana ko ya jolo ke nya te mo no ko ya jolo ki no one mari no one ge ja tebe no ko tamia jolo ba me kam Hijumbari mei hikukra jako bokam hikukra jako tie hamdo nyulma bokane mei kane jo nyajo mei nyom pukakam bokam honta nyula pute me abe kube hanyo pijo aya mi kane yam pulang nama mei bengu kreju inyom boy inyom pukakam ikane jo kam ne ba me ami puka bob me ya haji mokinde ne me nyongo jo biken ke cam me nhoko kren jo me ba me ye kren ya ka ju mango bi ken kene nyep cam apoi kube bidam ho me ka ju ho me ka ngon ho ane ba me imakin kene ge ari kute me ka ngon nya me wala bone me kukra jab man me nyo moya pumun reb kaju yare nyare niwe mari kri jo kanari kaneta obinalo penyo kri kaneta obinali ka beno kri ne kamio me wala bone ya pumuy me nyo kukra jo ya pumuy ne mari na reb o me kajuru kene hari kini jo kan binari moyo me ka juro kini ne kam hiyo me bolo boy ne me mo hare ne o me ka ngoy ba me ya mi poi kum kami ju ya re nyare nyum ali te marike tani bakati ya kamo ale nyawane ge apunya re me bengo kre me akord o penyo kniya o ga me apia o ge me nyoku kroja me amo yare nyare me kaben ma me o apia o me kajuru ke ne o ane me nire o apia o me kajuru ke nya kajine ba o ale nyawane gume aben no ba apia o nya ne ba o ale nyawane
Atualmente, nós
Currently, we women have also started to discuss about our rights,
as mulheres, né?
women's rights.
E ainda praticamos as nossas
We still
tradições.
practice our traditions as well.
E essas tradições
And these traditions will be passed on from generation to generation.
nós temos os nossos
We have
netos, né, que
our grandchildren
no futuro
who in the future
também vão precisar
will also need
do nosso território,
our territory,
da nossa floresta,
our forest,
viver.
in order to survive.
Sobre a FUNAI,
Regarding FUNAI, the Indigenous Nations Foundation, it's an institution that works with the demarcation of indigenous lands
protege, né,
and also protects
território e nós indígenas
our territories and us indigenous people who
em nosso território. Precisa ser fortalecido.
needs to be strengthened. This institution needs to be strengthened to demarcate more ancestral territories for our relatives, the other indigenous peoples.
Porque nós temos
Because
muitos lugares,
we have a variety of sacred places.
o lugar que vivemos, né,
Place in which we live
o lugar que são
is one, but there are many sacred places for us, like the cemeteries where our great
enterrados, né?
grandparents
E
were buried.
tem muitos desses lugares,
There are many of these places
os nossos ancestrais estão
where our
enterrados,
ancestors are buried.
são destruídos
Many of them are destroyed
no processo de colonização.
by colonization processes.
O lugar que
So the place where we live, well,
é local sagrado,
we have these sacred places that need to be demarcated for us and need to be respected, need to be understood by you
para a gente poder
so that we may live
onde tem esse lugar que são sagrado para nós.
in these spaces that have our sacred places. In the forest,
Plantas
we have medicinal plants.
que a gente, quando a gente adoece,
When we fall ill,
tira esses raízes
we get these roots, these plants,
para curar, né?
and we use them to cure our people.
Isso,
To do this,
estamos protegendo
we protect and defend our forests.
e Muito importante ressaltar aqui para vocês
It's very important to highlight to all of you
vocês, né, que muitas
that
vezes
you who
desconhecem
oftentimes
muito bem
don't know a lot about
nosso modo de pensar
our way
tradicional
of
e viver
thinking, our
nosso
traditional way of living in our territory.
para poder conhecer,
It's important for you to come closer to us to understand,
em nosso território com a natureza.
comprehend how we live in our territories with nature.
O rio
We have
são os lindos
rivers,
em nosso
clean
território.
rivers in our territory
E em volta do nosso território, né,
and around our
o
territories.
desmatamento está cada vez
The
mais
deforestation
tem
is
essa
coming
pressão
closer
do
and closer.
desmatamento em volta
There's
do
a
nosso
pressure of
território.
deforestation
E nos preocupa
coming closer to our territory, and that concerns us
causa mais
because it may cause pollution,
os nossos
more
rios.
pollution to
Então,
come to our
mesmo
rivers.
que preservamos,
So even if we preserve our
mesmo que
forest,
preservamos
even
o
if
nosso
we
costume,
conserve
a nossa
our
língua,
customs, our
em
languages
volta de nós,
around
do nosso
us,
território,
around our territory,
aumentando essa pressão
the
de
pressure is
desmatamento,
ever
de
rising,
poluição.
deforestation
Então,
and pollution of the
os
rivers.
nossos rios,
So our rivers, our forests are at risk
destruído.
of being destroyed.
Preocupação com
That
relação a
is our
isso.
concern.
É, tem pessoas, né, que
There
são
are
os
people,
políticos.
politicians,
Nós temos as leis, né, que está na
we
Constituição,
have laws
né, que
in our
conquistado
constitutions
por
that
muita luta
were
dos nossos
achieved
líderes,
through a lot of struggle from our leaders,
mas está sendo
but
desrespeitado por
they are
políticos.
always being disrespected by
Eles
politicians.
pensam em criar
They
projeto
think of
de lei,
creating a bill of
de
law
qualquer forma, destruir o que
to
temos na
try
Constituição.
by any means to destroy what we have in our
Direitos nossos com
constitution,
relação à língua,
talking about our rights in relation to our languages, our traditions, our territories, and even our traditional way of living and thinking within our territories.
tem pessoas que
There are people
pensando
who are
para
spending a lot of energy
tirar
thinking
esse nosso direito.
of how to take away our rights.
Peço aqui
So I'd like to
para
request
vocês que são as
from all
pessoas
of you,
que estudam
the people who
muito sobre
study a lot about laws,
que compreende nós indígenas,
that you try to understand us indigenous people, to understand our rights, so that we may be respected,
criados
so that these laws may be respected,
na compreensão de
and that laws be created in this understanding.
muitas vezes as pessoas
Oftentimes, people think
criam
of creating bills
que acaba
that
afetando
end up
nós indígenas,
affecting us, indigenous people, our rights in relation to our territories, and our traditions, our languages, and customs.
Então, hoje,
Today, women,
muitas mulheres
many indigenous women
falando em defesa
are speaking up in defense of the forest,
também
in defense of indigenous people.
uma lei
When a law
criada,
is created
sendo
or thought of
discutido,
and is being discussed
essa lei
in Parliament, this law
nós
can directly affect us, indigenous people, and especially
temos a lei,
we indigenous women. We have a law that's in the Constitution.
as pessoas pensam
People
em criar uma
are
lei
thinking of creating laws and bills
afeta diretamente
that can directly affect us indigenous women.
mulheres indígenas
Why? Because indigenous women within our territories, we're the ones who take care of everything.
de crianças,
We take care of the children.
floresta,
We take care of the forest, of the rivers.
uma lei é pensada
So when a bill is proposed that threatens our rights,
se sinta afetado
we
diretamente.
feel directly affected by this.
Peço que vocês
So I'd like to ask you who are here, you important people who are here
trata muito sobre
that deal with our rights,
estar com a gente para
we ask you to stand by us,
ter, né,
stand with us,
de viver
so that we have the right to live
nossa própria forma de
in our own way of living, our traditional way of living within our territories.
Tạm biệt bà, y á lên nhà. cam ja bơ mi mơ mi nhô bự cá cam mê tê kê nó bay mơ kinh kê pi nhị cô đê nhỏ bay mơ kinh kê ngô bị kê nhỏ ba mơ kinh kê mê bê tê pò bị đi dôi tu bị nhị kê cột mê bơ được nghề nha mê mơ kinh kê Kan ba ikakam kali ali makaben ba nya mi ba ma kaneo no kakam ali urboy ne alakaben maro nyun ima alakaben kine ima la jumali jabya kine ala ye mei bengo kre nhompi okia ni pe me nyum arek ba me kuti temala on kami nyunu la on ya kajiba on ika benyale nyawa ne nyiwe on me ika juru ne me kukra jo bingro nyamono ya me ka beno bingro nyamono ya ne ba imakin kin kane ba ala mo ale nyawa ne gijagali aye mali ne Menyo puka no ko ajul kitnya kaju aju mali jo aye mali nyeptebe no ko te ami ajul ba me kami jumali mei ne iku kro joko na leki nyuna kaju ne ba kami kabenya le nyawane hale mara moya bitnyalen mara bulu boy ne baju ala kami kine ala kaben maro nyun Imokine baju ikabenyale nyawane nale malamo yambi chale.
Não aceitamos a
We do
exploração
not
mineral
accept
em nosso território.
mining in our territories.
Não aceitamos
We do not accept
a exploração de extração de
the
madeira
exploitation of timber in our territory,
porque mesmo tendo
because
o nosso território
even if we have our demarcated land recognized officially, there are invasions. There are
essa invasão
invaders come to our territories to carry out these activities, and many people
faz assédio, né,
harass our leaderships,
a exploração de mineração,
harassing them, asking, trying to exploit the wood and to mine within our territories. But we will not accept this.
de falar que
I like to say to all of you
o meu pai foi
that my
convidado
father was invited to this event, but
fazendo tratamento
as I said, he is undergoing a traditional health treatment,
devido
and
ao tratamento.
due to this treatment,
Estou aqui, né, com vocês,
I am here with you,
que vocês
listening
estão falando
to your words and listening to what you are
os direitos
saying
de nós indígenas.
regarding our rights. I have enjoyed
Nós também
this
temos
quite a bit so far, and we also have our own point of view regarding
de nós
how to deal with the rights of our indigenous people, our human rights. So I'm here with you all. I arrived here. I listened to a lot of you speaking, and I really enjoyed it.
Só tenho a agradecer o
I,
convite, né, do
I
ministro,
would really like to thank
e
the
agradeço
Justice's
também,
invitation,
vocês estão aqui
and
nos ouvindo.
I'd like to thank all of you who are here listening to our words.
Gostei, né, e muito
I enjoyed that as well, and thank you so much for your understanding.
essa é a minha fala.
So that's what I would like to say, and I'm wrap up my speech this way. Thank you so much.
Agradeço muito a senhora
I'd really like to thank Kokonam Tuktire for her magnificent speech, as I would also like to thank her for her struggle for indigenous women, her struggle for all indigenous people, for their way of living, for our environment, and for our identity as a nation. It's an important struggle and a fundamental struggle, so that we may find our real identity as a nation. I now like to pass the floor to Chief Justice Herman Benjamin. I'd just like to highlight that Kokona and Cacique Raoni come from the Xingu indigenous land in the Xingu River Basin. And Xingu indigenous land, among all indigenous lands, is one of the largest in our country. It's true that yesterday we had Davi Kopenawa here, and the Yanomami territory is a lot larger than the Xingu, as well as the Raposa Terra do Sol. That's also a much larger indigenous land. But the Xingu indigenous land was created in 1961, and it was an important moment, a very important watershed moment for the organization of indigenous land in our country. It's around the size of Belgium. And as I've said, it is no longer the largest indigenous land in our country. It has around 6,000 indigenous people living there, and it's a growing number. And we have 16 ethnicities. I've had the opportunity of visiting Xingu at the invitation of Cacique Raoni. It's an extraordinary land. And at this point in time, I'd like to celebrate the work of Cacique Raoni. I've already said that he was with us last year here in our event, and he always participates in our events. And I asked Kokona, I'll ask Kokona to bring our hugs, our greetings to Cacique Raoni. She's a wonderful leader of indigenous women, and we at the National High Court feel honored with her presence. Thank you so much. Thank you so much, Chief Justice Herman Benjamin. Now I'd like to pass the floor to Congresswoman Célia Chacriabá, whose presence I'd like to thank. It is a great joy to have you with us this morning. Congresswoman Célia is a indigenous activist and professor from the Chacriabá people. She is a member of the Socialism and Freedom Party. Her struggle is based on the restructuring of the education system and the support of women and young people within the Chacriabá and the geographic struggle to keep their territory. She became the first indigenous woman to be elected a congresswoman in Minas Gerais. It is with much joy that we receive her, and we now like to pass the floor to our Congresswoman Célia.
Nanduan Paraya, Nanduan Ruminishan, Nanduan Paraya, Nanduan Ruminishan, Hey na, na, hey na, hey na, hey na, hey na, na, hey na. Hey na, hey na, hey na, Jacan hita kudayo, Jacan hita kudayo, hey na, hey na, hey na, hey na, hey na, hey na. Sempre que eu tenho oportunidade no Congresso Nacional, começo cantando.
In Congress, I
Cantar,
start by
tocar,
singing.
não é
Sing
para
like using my
provar para os
headdress.
outros que nós somos
Not to prove to
indígenas,
people that we're
mas
indigenous.
porque quando as
No,
pessoas não
it's
conseguem
because when people can't listen to a political voice,
escuta
they
a
will
voz da
listen
ancestralidade.
to the voice of ancestrality. We'll keep on singing. As Conceição Evaristo says, a black writer of importance, we're going to keep on singing to wake up the slaver's house. And the people, don't you people pray before you eat? Well, we like to sing, pray before we speak. And since I'm one of the very few indigenous people, it's me and Juliana Cardoso, that we defend indigenous territories, certainly it is necessary to keep our place is a different place because I come from a territory, I come from the national indigenous movements. I'm not a lawyer, I'm an anthropologist. But the people who taught us to be lawyers, Hauni is a lawyer, Tuidi was a lawyer, Maninha Shukuru was a lawyer, Nega Patashaw was a lawyer, Rosalin Chakreba was a lawyer. And lawyers defend, right? So we're the first lawyers of Brazil. We're defense lawyers of the land. And in the National Congress, a lot of people say how National Congress has become such a contradictory place as far as indigenous and environmental places. And if you look at the movie of the National Federal Constitution of 1988, in the Constituent Assembly, 437 parliamentarians voted in favor of Article 231 and Article 232. Only 4 voted against. And they were not the most passionate about indigenous causes, but there was an emergency. There was diplomacy with indigenous people. When we look at the temporal thesis, the so-called temporal framework, you can see that they really hate indigenous people. They're not just saying, oh, we're going to vote. No, their speeches are extremely aggressive against indigenous people. This is why the symposium here inaugurates an important moment of debate to expand other reflections. I'd like to thank Justice Benjamin because this weekend, Anita, who's the person who's been coming close to the territories, and we always ask people to guide. Well, anyway, the idea is that we shouldn't just speak to our bubble. We need to bring different people to expand our debate. And so I was saying that if the head thinks like your feet are like the land your feet are speaking on, then you will be taking on the struggles what their heart connects to. Well, Minister Benjamin has been to Haoni's territory at least twice, and he was always stepping on that important land. He's a justice that is always connected in thinking of the expansion of the power of justice as a non-monocultural justice. Monoculture, it can be soy, eucalyptus, but also monoculture kills. And justice monoculture also thinks if you just defend only the people who are already powerful, that also kills. So the justice system has the responsibility and the duty of defending minorities' rights. I also like to thank Justice Sebastião from the National High Court, Justice Matthew Palmer from the Court of Appeals of New Zealand. New Zealand is also very strong as far as its indigenous people, and I see that when we talk, often people think that it's aggressive, but I don't think it's aggressive to tear the national constitution as a symbolic means. We also have Paulino, someone very important for APIB, for Indigenous Peoples Movement. We didn't have the right to be inside the National Congress. He would show up together with Sonia Guajajara, who's one of the first coordinators of APIB, Kokoname Tuktire, Mecmoré. She is a voice of indigenous women. It's like Tuiri Kayapó and other important indigenous women, like Oé, as well as many other young people. They are here to defend. Listening to her is listening to a new place. It's the 21st century, is the century of women and indigenous women. I'd like to thank Kari Guajajara, who is one of the indigenous lawyers who has been making important cases, reaching the Supreme Court and saying, you're not listening. Do we need for a white non-indigenous lawyer for you to listen to? We want other people to carry our flags. We want other people to recognize the importance of being present. During my PhD, I was writing based on João Paulo Tucano, an indigenous anthropologist, saying when you reach our bodies you're reaching our thoughts. So it's not enough to have indigenous lawyers. Oh, they say, oh, we don't understand what you're saying. Actually, in National Congress last year, when I had the opportunity of being in the Justice Commission, which is the citizenship and constitutional justice, I was the first woman to be the president of a commission, and everyone said, which was the traditional peoples in Amazon, they said, okay, the presidency of the Amazon and commission, and then I said, I want to be a part of the Justice Commission. And they said, oh, aren't you a member? Don't you want to be a member of the Human Rights or Environmental Commission? I said, no. Listen, we're also prepared to be a part of the Justice Commission, the most important commission in the House, or the Economics Commission. We're prepared to be in any and all places. And when we reach these places in National Congress, oftentimes they say, oh, are you an artisan? Are you a protester? No, we've been protesting here for 500 years. The problem is not I've been a teacher of culture. I've always sold my craft. I've always made my craft, but I'd also like to thank Odina, who is a part of our collective of indigenous anthropologists, because we know that anthropology needs to go through a revision. And the first indigenous anthropologists in Brazil were actually the lawyers who carried out this rule. But after that, there was a need to think of not just a social way of thinking, but also cultural way of thinking. Then our lawyers couldn't cut it. In the justice system, and above all in National Congress, people are against anthropology. Like if anthropology wasn't a science, anthropology is a science. And when done by indigenous people, that doesn't make it smaller. Oh, you're saying, oh, you're an indigenous lawyer, you're an indigenous researcher, you're an indigenous anthropologist. Your research methods haven't worked. People have gone so far from reality that they're far from the land. This is why now we have a huge responsibility of bringing sensibleness to people so that they get closer to the land. So let's think about the memory of Tweety Kayapa, who was an important lawyer. When I'm saying lawyer, people who don't know are probably asking, was she really a law student, a law graduate? Anyone has a right to defense, and indigenous people defend their territories. And when she, even without being a member of the bar, had the courage of struggling in the defense of the territory in Belo Monte and using her knife, and later questioned in National Congress by a variety of members of parliament, and she had the courage of facing head to head Congress people in National Congress. You must understand that these places, before there was indigenous presence in Congress, indigenous lawyers and universities, how many times did we march on Brasilia and various other leaders? Often it took over a month to reach Brasilia, when it seemed like we would never be able to reach our circle, when all of our judicial options were done. Karina will remember this. You remember the period of packet 215 of Constitutional Amendment Proposal 215, and they said, no, we're not going to be able to stop Amendment 215, and we would reach National Congress. In 2017, we had a huge free land camp, which is an annual indigenous camp, and we also put all of those coffins representing the amount of Congress people that were voting in favor of this terrible amendment. They were not able to vote. They started diverging amongst themselves, and still they have not voted on Bill 215, but they turned it into other weapons.
The truth that is, since the 1500s, that weapons have been getting more and more sophisticated, because the intention is the same, is to kill the rights of indigenous peoples. Whenever there have been legal recourses that have been available, it's been the ancestral one, because in an inexplicable manner, up to nowadays even, when we thought there was no way to ensure things anymore, we still mobilized. And the indigenous peoples, what shows and marks most our strength is the way we sing, of connecting, of believing, But we don't do this as if it was something to contribute. We do this because it's part of how and who we are. If there's 5 indigenous in a place, they make a difference. There's one indigenous, they make a difference. It's also important to understand. Brazil is the only country that has the name of a tree. Brazil, during the colonization, took 50 years to bring women to Brazil. And that's why the whole process of mixing that was not Pacific starts with the violation of indigenous women is carried also by big violence, mark of violence. And the Congress took 109 years for there to be women in the Congress. And so I say the National Congress is a portrait of colonial Brazil because it's exactly, it took 1 century to bring women to this, and for indigenous women, 195 years. Jânia Wapichana, who is one of the first Brazilian indigenous lawyers, and Júnior Javante, who was the first elected indigenous to federal Congress. But until then, we didn't manage to elect. It took over 30 years to elect another indigenous. It still hasn't re-elected an indigenous person or had an indigenous caucus. This is why we had a mandate when I was elected and my colleague was elected, and she now occupies as the first minister of the first indigenous ministry, had a consultation at the Superior Electoral Court, and he approved that the candidacy of 2016 would be time for radio. 2026 there was going to be time for radio and TV. 10 seconds. Well, what am I going to say in 10 seconds? He said, well, electoral times, they turn off the TV. So these 10 seconds to put it when in between soap operas and other programs. And I said 1 sentence, and even nowadays they say, look, I've never voted in a progressive party, but I voted for you because of your about my child, my daughter, that saw you and wanted me to and defended you. And that is really incredible for me, and it means a lot because people voted our mandate because our campaign was called The Call for Earth. I was never a candidate for even the local chamber. And so I called the indigenous peoples and I said, let's create the indigenous embassy, since there is an indigenous embassy. So I don't have money, but here together with our supporters, it's food, we can make that happen. And from this result, 153 municipalities, I was elected in 84, but also I challenged being a parliamentary person in Brazil, and I was been in all the Brazilian biomes because there's indigenous peoples in all the biomes. Brazil has the Amazon, but this is the second biggest Brazilian biome, the oldest one of the Caatinga is a biome that only exists in Brazil. In no other place in the world does it exist. The Atlantic forest, Pampa, the Pantanal. And I've been to almost all the Brazilian states. And that's important because if we're good lawyers to defend the territories, we need to broaden this participation in politics. And so when I started indigenous school, my first and second year was under a tree. My first and second year at school were under a tree. And I say that in indigenous territory, we learn at the speed of the fights. In the university, I learned about the speed of letters, the science of the speed of light, in the National Congress, the speed of the laws. It's 4 different L's. It's almost a legal hermeneutics of the speed, but this speed most often is used to accelerate the setbacks of indigenous people's rights. When I say when we use the pen, it's not to murder rights, but to sign rights. People are so perverse that they say, well, these people that speak the indigenous language are getting in the way of Brazil's civilization. Then we go to the university, and we want to speak for ourselves. And they say, look, they're not indigenous anymore. They become a lawyer. They're wearing suits. They're using cell phones. Then they create a category of indigenous, agro-indigenous. It's like, are you really falling for this narrative? Or one day they're going to say you're less agro-indigenous because it's a trap to keep doing this. And then I say, when people used to ask me, they say, well, Celia, when is the first time when are you gonna write your first book? And very often, we're dedicated so often to this space that we don't have time to write our books. Then I said, look, before writing my first book, well, before the book and the law, there is the fight for the fourth power. Because the fight also creates thoughts. And I don't know how everyone connects to writing here, but when I'm really tired to write, very often people also said to me when I went to university that the way to defend our oral traditions, because we didn't have the capacity to write. And I put it within my head, I don't have the capacity to write. They're saying I'm going to fight in oral means. And then later, I undertook a master's as well, and last year I managed to conclude my doctorate, the first indigenous doctor person of the University of Minas Gerais, and I noticed that in reality, well, I didn't learn how to write, but I'm learning of the importance of oral traditions. It's because it's a refuge, it's really a document for us indigenous people. And the importance of this space, because within the legal world, what is really valued is a document that's right here so that it's registered. For us indigenous people, the word has a lot of value. That people might even have a collective reflection and go back on what they said, but the word usually has a lot of value. It's important to learn that for us. The word is also a document. When people say, well, there's so many colonial terms that we repeat, and then we analyze and say, well, to legalize indigenous territories. And I keep thinking about that. We're irregular? Original people, indigenous people are irregular? Because in 17 we already had the law of lands in Brazil. They were not irregular. The truth is that there was given a deadline for 5 years after the Brazilian constitution was promulgated. So I keep thinking of the memory of the document. We are a document before the document that we have, be it in the justice instances. We are a document. Memory is a document. Cemetery is a document. Funeral urns are documents. Cultivated forests, such as in the Amazon and the Atlantic forest, is a document. Tropical forest is a document. Is the means of life of indigenous people. Is that not a document? When in the National Park of Piroço in my region, that is a sacred region, that became World Human Heritage by UNESCO recently, there's a variety of corn that was older than 9 million years. And there's members of Shacriabá peoples, Kayapó. Is that not a document? And then, when you talk about land invasion and when people take our lands, what is that? Well, in Portuguese, the expression came from a way to say of forging documents. And it's a technology to sequester, to take indigenous territories from them. And this happens a lot, especially in border areas. Not everything that is legal is moral. So this land grabbing, it's not because it's legal that it's going to have it be a good project. Well, they want to legalize and have this land grabbing with mining. There's a congresswoman that signed a document that would allow that, and the mercantilization of Brazilian, of indigenous lands. We're in a moment where we're talking about the process of energy transition, petrol, gas, mining. At this time, this year, we're talking about climate crisis. You're going to say, oh, we're against progress. You're hypocrites because you indigenous are using cell phones yourselves. They use these heavy metals from mining. People say, do you want to cook with wood again? Do not use flames? Well, there's a research that say that the areas that are already been deforested and used for agriculture are enough to sustain Brazil until 2050, even gas-wise and petrol. So what we must say that from here onwards, we cannot think in the same way. And often, even nowadays, they say, oh, you're primitive. They are always afraid. They would say that you eat people. I say, oh, mining is primitive. It destroys mountains. It kills people. So legalizing this project is as if making death legal. It's not an ideological question that is romanticized. When Minister Marina Silva went to the Congress, the Minister for Environment, and said, well, France wants to grab Brazil, land from Brazil, and they themselves destroy their own forest. Why can't we do it? It's a very primitive way of thinking about things. The whole of Europe saw how much destruction costs. I was really curious about how many people were there. The pillars in the Congress took. Well, they took 3 years to be constructed. Copacabana Palace took 4 years to be built and is 70 meters high. Brazil's highest, tallest tree, Sumauma, is 70 meters tall and takes up to 600 to 900 years. Look at man's time and nature's time. It's far too long. It takes way too long for that to happen. And justice very often looked to indigenous rights such as reforesting. It takes 50 years. It takes 100 years. What we're planting today, the shade will not be for us, but for future generations. I say, well, then we're going to destroy. Because look, agribusiness protects 80% biodiversity. No, that's true. Those who do that is the indigenous people. There's a research in the Amazon and in Federal University that says if they do not stop voting on projects that destroys the National Congress against indigenous people, 57% of Brazilian agribusiness benefits from indigenous protection, and the deficit for the Brazilian economy is 388 billion reais. Indigenous peoples should be considered extremely important place for the economy, even to think on direct financing for COP30. But when we reach this place, some people are going to hack the system. And what we do is to just include indigenous people in the system. With only 3 years of mandate in the National Congress, our mandate up to the first week of the Indigenous Women's March had 1,700 legislative proposals. Now we have 1,800 in 3 years of mandate. And now we're proposing, we'd like to invite you as well in a global project. Without women, there is no climate. Tomorrow, we're going to go to Colombia. I'm going to launch firstly to Colombia. There's going to be a project where many parliamentaries of the entire world, they also create their law. Without women, there is no climate, because 150 women will be pushed to poverty because of climate crisis. And a science magazine says that a vast majority of women, percentage of women don't want to have children because they fear for their future in this world. everyone who traveled here traveled on a plane. When people sit in a plane, people say, are you over 60 years old? Are you pregnant? Are you ready to sit at the emergency exit? Are you able to? Well, the climate crisis is going to be a big emergency exit. And we say, yes, we're ready. Well, we're not. Just as we answer yes on the plane without paying attention to what they're saying, we must implement exits for a climate crisis. That's why we created a project, a bill of law that is for the Ministry of Education, recognize indigenous quilombolas and traditional territories as existing climate schools. We must prepare ourselves because it's already happening. And very people are afraid if we're going to resist. We're concerned if anyone and everyone's going to resist, because after doing this chaos in planet Earth, they're looking for life or how to sustain life in Mars. Are we going to take everyone to Mars? No, we're not. So it's important. Planet Earth is a great place to live, and we can take care of Earth and the planet now. To finish, now we have another project. There's a proposal to a constitutional amendment. But around 130 signatures of Congress people, and want to reach to 170 to make it go through. It's inspired in the Bolivia's and Ecuador's constitution, but ours has a difference. On Article 16, we're proposing the Amazon, Cerrado, Caatinga-Pampa, Atlantic Forest as a legal entity. And I know the majority of legal instances are written in the Supreme Court, but the National High Court was very important also for salary, for maternal leave for women, including especially for under 16s. And it went through the National High Court for that. The shared responsibility for basic sanitation, demarcation for indigenous lands and territories. So we have two things in common with the STJ and the Supreme Federal Court. You are guardians of justice and the rights of the minorities, and indigenous people are guardians of the planet. We could call the indigenous leaders of justice prosecutors and promoters as well. And already mobilizing, we're gonna request to de-archive many laws, projects, and bills of laws. And we want to work with law orally because our grandparents know how to say what they need, what we need, what we want. The first one that was approved was the autonomy of indigenous schools and quilombola schools, so they can decide on the curriculum and how to teach. And we need the justice system guarantee this right. We're at a moment of not just a necropolitics, decide who's going to hear, speak, and who's going to die, but also necroparliament, they decide who's going to vote projects, who can't, who won't. But we're also at a moment necro-justice, necro-environment, necro-humanity. But inspired in Davi Yanomami, just like you, we have something else in common. You avoid the fall of rights, while we avoid the fall of the skies. We are guardians of justice and the planet. That's why we have a very important challenge. Humanity's problem is that the planet is every time hotter. And humanity is every time got colder hearts. And we have the challenge of reduce the planet's temperature in order to warm humans and people's hearts. And so we have the third power, that is the legal branch and justice, but we're the fourth power, that is the defense of nature.
Thank you so much, Congresswoman Celia, for your fantastic speech. We know, well, those of us who pay attention know where this hatred, this prejudice comes from in relation to indigenous people, where it comes from and what is the goal of this hatred in relation also to the preservation of the environment. And it's important to see how this message that one person can make a difference, the presence of 5 people can make a big difference. And this gives us hope so that we may further ahead have dialogue that allow us to advance, that allow us to go ahead and advance in the struggle for preservation in the way of living of indigenous people in their territories, and maybe awareness that it is only this awareness that will allow us to save ourselves as a nation. May this, in fact, let the planet not go on fire, and that the hearts of all people will not be frozen. Thank you so much for such a brilliant speech. And now I'd like to give the floor to Mr. Paulino Montejo, historian with a specialization in management and development. He acts as the political coordinator of the Indigenous Peoples Movement of Brazil, APIB. Paulino, you have the floor. Thank you so much, Minister. Special greetings to Justice Herman Benjamin, a longtime partner. And in his name, I greet the whole table. In fact, Minister, lots of greetings to our indigenous relatives and all of the different networks of partners that help the indigenous cause. A big hug by the Indigenous Peoples Movement of Brazil, APIB. Since yesterday, I've been listening in the plenary. I want to talk to all of the different speeches that happened yesterday and today. I'd like to greet all of our relatives in the movement, and I was just sort of having to control myself because I wanted to speak to everyone. And as our Congresswoman said, we are oral peoples, and we have this temptation of wanting to react to all the different speeches and to talk to everyone who is speaking. And like Justice Mateo said, Matthew, the judge Matthew, asked him, how old are you? Because he brought so much interesting information. We're almost in the same generation. We have 5 years of difference because he saw all this architecture of international law that has to do with indigenous law, and me as well. Before this, then I'd like to work with our memory, remind you all of our relatives who were present in the struggle for the 1988 Constitutional Pact. Some of them are still living. Salimi Machakari, our dear Haoni, whose daughter spoke to us brilliantly, highlighting the right of consultation, the need to strengthen the indigenous institutions, and the need to understand and value our ancestral knowledge as far as medicine, as far as our land. So many wise things that our dear relative pointed out. And we also have Solima Koshi, Haoni, Davi, Yanomami was here yesterday. It was so inspiring. Naoto Patashaw and his sister, may she rest in peace, Nega Patashaw. Caboquinho Potiguara, Amasima Koshi, important living leaders. And a few of them have also moved on to the next realm. Augusto Caingang, Chican Chicuru, Nim Fernandes Chicuna, Palinho Paiacan, Manuel Moura, Cacique Damião. These are warriors. Warriors who gave their time, their effort to accomplish the indigenous chapter of Constitution. It was hard to overcome this concept of the Indian, remembering that this is a category that was resulted from a nautical mistake, thinking that they were in India. They wanted to go to India, they got here, And then they called us Indians in their prejudiced minds. That's the way it worked. Matthew's speech, and yesterday as well, the speeches yesterday reminded me of a variety of topics. In fact, we have been victims of various genocides. Yesterday, they reminded us, that judge from Ceylon remembered the crimes against humanity committed against the original people. Just in Mexico, from a period of 100 to 150 years, the Mexica people, the Aztecs as they're known, more well known as the Mexica or the Nahuatl, were decimated from 23 million to 1.5 million people in less than 100 years, in a period of 100 years. In Peru, from 9 million to 1 million in a period of 100 years. This is an average. In Brazil, so that we don't fight with historians, some people say 5 to 8 million, 5 to 8 million inhabitants reduced up until the time of the constitutions of 230 indigenous peoples. We had 230 indigenous ethnicities, and according to a sociologist whose name I just forgot, one of the creators of the Social Democratic Party, they said in the year 2000 there would be no more indigenous people in Brazil. That's what he said. So we were the victims of a genocide. And thank you so much for reminding me, Mr. Matthew. The same happens in Palestine as well. Ethnic cleansing and genocide that is ongoing in Palestine is inadmissible, and the international community is omitting itself. In less than 2 years, 200 journalists were murdered. 6 just last week. 61,000 Palestinians murdered by guns. 197 starved to death. 96 of those starved to death, children. We know this history as indigenous people, from Canada to Tierra del Fuego and Mapuche territories, from the north to south of the American continent. We know this story. So it is impressive how the international community and the UN can't react to the offensive that seeks to occupy this territory, leaving a people without a land. And our Palestinian comrades sometimes call themselves the indigenous people of that territory. So I'd like to remind us of this issue, because we can listen to some of this by the media, but we're silent about the day-to-day murder of our leaders here in Brazil. So in the south, in Paraná, in Mato Grosso do Sul, in the south of Bahia, in the state of Maranhão, in Roraima, you can just read the CIMI report from last year about indigenous leaders who were murdered in Brazil. And we're silent about this. I'd just like to call attention to this aspect. And to remind you all that the resistance continues. There's so much to talk about, my dear justices, that I'm a little bit even lost with my reasoning, because the political moment that we're going through right now, it seems like there's an agreement, especially with this institutional crisis promoted by the unnameable in 2023, and now there is a perspective of harmonization of powers, but this harmonization oftentimes seems like it is done by throwing out rights, especially in our case, throwing out indigenous rights. It is quite frightful. It is quite astounding that last week, and my friend Congresswoman here has mentioned this briefly, in the Human Rights Commission of the of the Senate, they talked about bills 213 and 250 that seek to really legalize mining and all sorts of economic activities in indigenous land. This continues an absurd chamber of conciliation that was instituted in the Supreme Court, that instead of reiterating the inconstitutionality of the temporal framework thesis that was proclaimed by our Supreme Court in August 2023, they created a conciliation chamber, and conciliation that doesn't exist when one of the parts doesn't agree to it. The Indigenous Peoples Movement was left from this chamber. It is illegitimate, illegal, and unconstitutional what they're doing in the Supreme Court with this conciliation chamber. And finally, they threw to the executive the responsibility of changing the 175/97 decree that establishes procedures for indigenous land demarcations. And now, I'm going to rapidly mention this. Now they're talking about the possibility of buying land for unconstitutional removal of indigenous peoples. I participated in the Constituent Assembly together with my relatives and partners that I mentioned here. They talked about the creation of reserves. Reserves, that's an exceptional case. In the case, there's a difficulty of proving the traditionality of the occupation. They talk about buying parcels of land to put indigenous people while they're fighting for the regularization of their actual land. So they're trying to about dislocating them from the actual land and buying some parcels. This might become jurisprudence. And there's a bill that's still trying to uphold this, the so-called temporal thesis, that is, that indigenous people should have been occupying their land in 1988 when the Constitution was approved to be able to have this. I grew up in the struggle for indigenous rights, and I cannot accuse myself from this. So I have the responsibility of talking about our indigenous rights issues. We're talking about fundamental rights here. And there's an unsolved problem here, my dear justices. The right of indigenous people. One thing is talking about indigenous law, and then we can also talk about indigenous rights. Look at the difficulty that my brother here, Davi Anamami, pointed out yesterday. Our way of being, our way of living, our way of organizing ourselves, which the Constitution recognized. They declared this recognition in the 1988 Constitution. In Latin America, they call it the Derecho Mayor in Mexico. They call this indigenous law in the Andean region, or common law in the more in the English-speaking world. So, referring to our way of being, to our way of socially organizing, to our rules. We don't ever talk about this. It's considered archaic, it's considered primitive. What happens, what matters is positive Western law, and not our own indigenous law. But our law was in a way or another recognized by the Constitution, and Supreme Court Justice Faquin said that they are petrol clauses, they are unmovable, important clauses. So it's an absurdity what's going on in Congress. There's a point of view of absolute ignorance and prejudice. And we keep on being, as one of the speakers before said, we are considered obstacles to development. We continue being seen like that. And so anything is approved in the name of this so-called development. Right now, there's an amendment bill they're trying still with the time thesis. The time thesis that says, the temporal thesis that says that indigenous people should be occupying their land in 1988. So we know that Mohammed just had the responsibility of but they're still trying to modify the indigenous chapter of the Constitution, putting in trying to legalize the so-called temporal time thesis, the Amendment 96 that transfers the responsibility of demarcating indigenous land to Congress. So every indigenous land needs to be a bill in that if that bill is approved, and therefore, well, we have an anti-popular, anti-indigenous, anti-environmental Congress right now, in which for now, in 37 years, we still have a huge passive of demarcation of indigenous lands that should have been demarcated in the 90s, and they're all blocked. Do you think they'll be any better if the Congress takes over this? How many decades do we need to demarcate indigenous land? Amendment 132 that looks at what happens to land grabbers in our lands. We don't even have money for health and education. What about they want to indemnify invaders? They want to indemnify invaders instead of investing in our social security. We don't have resources for our indigenous policies. We're not even talking about other quilombolas, indigenous communities. Brazilian state needs to look for international cooperation to pay for its bills. Most indigenous lands in Brazil were demarcated through Pepetal program, the pilot program for the protection of indigenous lands in the legal Amazon. That's where it advanced with foreign funding, as if we only had indigenous people living in the Amazon. What about the Pantanal? What about the Caatinga drylands? What about the Cerrado Savannah? We're only considered national heritage if we're in the Amazon. Given the policy for monitoring of the Amazon, you know what they're doing? They're destroying the Cerrado in the Mato Piba region because they only care about the Amazon. There is an offensive against indigenous rights, and the justice system needs to pay attention to this. It needs to fight against this. The prosecutor's office cannot stay quiet and say that they have a hard time, they're having difficulties. Constitutionally, in Article 232, the Federal Prosecutor's Office needs to be in service of indigenous rights. I'm trying to call attention to the co-responsibility of all of the branches of power of the state for the defense of our Constitution. Indigenous people have the Convention 169 ILO to talk about the right to difference, about our culture, our societies, and there's the right to our lands that we originally occupied. The originary rights, this means the rights that the national state of Brazil needs to follow. And when it says that recognizing the social organization in the ILO Convention, we're reiterating what the UN Declaration restated, the right to self-determination, the right to self-government. And the states are scared of indigenous people. In Article 46, the Declaration says, nothing which is declared here may go against the territorial, political, and physical integrity of indigenous people. So our right to our original lands, our right to specific policies, specific social organization in a structural and permanent form, the right to autonomy. This needs to be respected. That's why our Kayapa friends and we are against any sort of enterprises that usurps our rights without giving us a right to give our opinions. The free, informed consent consultations. This was done. This was established by ILO Convention 169, which is a part of our legal framework. Sorry for going a little bit long, but I tried to give a general comment of everything that took place yesterday and today, and I'd like to thank you, Justice. A huge hug to all of you. Thank you very much.
Thank you very much. Thank you for your speech, for telling about the fights and difficulties to guarantee the rights of indigenous peoples. I greet Justice Sebastian Hayes, who is here with us as well, and hand over to Justice Herman Benjamin. So we are concluding this panel now. At the end of the following panel, we'll have quite a bit of time for debates to listen to the participants. So please do take note of any observations, questions, comments you might have, and we will then have this debate, including both panels. So just a few comments that I thought of in regards to, well, about the excellent interventions here. Kokuna was really it was very opportune when she mentioned the right of indigenous people of being informed and heard. Informed and heard, and listened to and heard. And also the right to say no. It's not enough to be informed and heard. Here at the STJ, at the National High Court, we have jurisprudence, we have legal acts in regards to this. And she also mentioned, I think this is a very relevant aspect of the very special relationship of the indigenous peoples with nature. For example, my area is environmental law. And through environmental law, I reach indigenous peoples' law and rights. But there are many colleagues that here present that from indigenous peoples' rights actually reach environmental right and law, because these two are actually inseparable. If anyone who thinks they're going to sentence, judge, or decide on environmental law without incorporating indigenous peoples is going to be considering the way that is not only incorrect, but is unconstitutional for our country. Our dear Congresswoman, Celia, she's saying very little. Usually she sings a lot more. Perhaps because when she arrives here, she feels perhaps a little bit, well, she already told me once, every time she comes, she feels a little bit more comfortable, but it was unusual for them, indigenous people, to be invited to participate, especially in events and speaking and talking. So the process of overcoming this reticence is still underway in her case. And so I thought it was really interesting to hear this reminder that she always makes, that Brazil is the only country in the world that has as its name the name of a tree. And a tree that is actually starting to be extinct. Actually, we already thought it had been extinct until a few decades ago. We discovered some specimens in the state of Pernambuco. And since then, we are planting pau-brasil in the country as a whole, especially even in projects here at the STJ. But in regards to our symposium at Congress here, I think that the most important thing of out of everything she said is that we judges are extremely powerful. We have, in the name of our institution, there is power, the legal branch or judiciary power. And according to her, this pen that we have, that nowadays is every time more the computer really, but that it's to ensure rights and not murder rights or kill rights. And I think this reflects this panel and a synthesis, a summary of this panel very well, and the observations that were made by my colleague, Justice Judge Matthew Palmer. And lastly, she also said that when dealing with the legalization of indigenous lands, that this expression is not correct. It's because those who occupy the lands in an illegal way are the foreigners who are occupying our ancestral lands. So legalize or to make them regular in the Portuguese words is incorrect, because we're actually only ensuring that the justice system and laws guarantee rights that were already theirs. I will not make many comments on what my dear friend Paulino said, especially because the analysis that were made by him has a strong political component. Paulino is a historical militant for the indigenous cause, participated in the creation of the Constitution of '88, so he has a lot of experience in this field, and as judge, I prefer to abstain from observing and making comments on what he said. That being said, we can therefore end the current panel, thanking Justice Paulo Sérgio Domingues, thanking all speakers in a panel who are dealing on Indigenous peoples' law and rights in the plural. And we're going to continue with the debate in the following panels. So, on closing this panel, I'm going to request Justice Teodoro and Sebastião to hand over the participation certificates to our speakers. But before that, I'd like to make a comment. I've known Justice Hammond Benjamin for over 40 years. When he was a justice prosecutor, young prosecutor, and I was a young lawyer in the environmental sector area. Justice Hammond was always a great defender of the environment, of indigenous peoples, during his actions, as a prosecutor, as a professor. Throughout the years, as he said, there was created a jurisprudence at the National High Court in favor of the environment, the recognition of the rights of indigenous people, quilombolas, and everything in regards to the recognition of preservation of the environment in favor of our peoples and future generations. But before closing this, I know he's going to hate me for doing this, but I want to make the most of it for all these initiatives in career, and the initiative for this first symposium last year, and now the second symposium of the indigenous peoples, to request applause for him. Just Sebastião Teodoro, if you could please hand over these certificates and we can continue to the next panel. I would like to already invite The speakers of the next panel. First, Chief Justice Sebastião Júnior, that is a justice of the Third Circuit, Third Grand Chamber of our court, one of the 10 ministers that decides on penal law and rights. And there we have leading cases that take care of penal aspects within indigenous peoples' context. Justice Reis, sometimes I call him Sebastião Salgado. He is our photographer among us justices here. And whenever I go to the deeper parts of the Amazon or other regions, I invite Justice Reis to come along with me. First, because he's very sensitive to these great questions and issues, but secondly, because his photography comes along with art. So I request that he please come over to the table. I invite Dr. Joel de Carvalho, General Vice Prosecutor, Deputy Prosecutor, Deputy Attorney General of Brazil, in charge of indigenous peoples. In Brazil, the indigenous question is of the federal justices, incumbents. And here we receive appeals of 27 state Supreme Courts and 6 federal courts of appeals. And it is fundamentally an attribution of federal justice, and that's why we have the intervention of the Federal Office of the Attorney General. And lastly, Virginia Casado, who works with this at UNESCO in Brazil. So let's start. I request that all apologies, I forgot to invite Chief Justice Kevin Smith of the National Court of Natives of Australia, and therefore I would also invite Ambassador Sophie Davies to also take a seat at the table with us, because he will now listen and hear President Kevin Smith.
Vamos sentar aqui, exatamente ao lado do Kevin Sebastião, que eu estou aqui, resolve.
Vou pedir aos brasileiros para falarem. Bem, então nós vamos dar início a esse segundo painel da manhã.
So we're going to start this morning's second panel, thanking everyone's presence here. Without further ado, hand over to Session President or Grand Chamber President. I request the technician to have a look. There's some noise in the mic. I've been informed that the noise is caused by myself because my cell phone is too close to the mic.
Combinei com as duas brasileiras.
So I've agreed with the two Brazilian women that are going to speak, Dr. Eliane Torelli de Carvalho and Dr. Virginia Casado, will each speak for 15 minutes. And President Kevin Smith will speak for 20 minutes with some flexibility, seeing as he's come from so far away from Australia. But with the two Brazilians, we will be extremely respectful of the time, only 15, because we must then have a debate. So in respect of the indigenous leaderships and leaders that are here and the participants, we must conclude in time and have the debate. So, Justice Sebastião Júnior, the official photographer of the beauties of Brazil, and dear colleague, please. Good morning, everyone. I'd like to thank you for the opportunity of participating in this event. I think the court has never honored its name, the Court of Citizenship, as much as it has recently with such timely debates. And so, wanting to be quick, I'm going to introduce Dr. Eliane Torelli de Carvalho, Deputy Attorney General of the Union, Coordinator of the Sixth Chamber of Indigenous Peoples and Traditional Activities, a Master's in Environmental Law at University of Houston, Texas. And we were colleagues at the UNB as students. It's a pleasure to see you here. So I hand over to Dr. Eliane Torelli. I thought he was going to start. Oh, actually, no, sorry. But next time, then that way, next time you don't have to introduce her again. But no, sorry. So we hand over to President Kevin Smith, that has a traditional links in the Strait of Torres. He worked as a professional and a volunteer indigenous questions for the past 35 years. He has a bachelor's in law in the University of Queensland and was at the Supreme Court of Queensland in 1994. He had senior executive posts in the Strait of Torres in the legal services in Brisbane, Yabrak Hostel Limit. Since 2002, he worked exclusively with native questions in Queensland, for example, and the native courts, executive director and vice president and director, non-executive director of native titles. In 23, he was named president of the National Court of Native Titles. Dr. Kevin Smith, the word is yours.
Thank you very much, Justice Sebastião. This topic is really a topic of great importance in Australia at the moment. So thank you for the opportunity to speak about the strategies for preserving Indigenous cultural heritage. And I will be also talking about the importance of knowledge in that as well. But my elders taught me that when you are not on your own country, you are always on someone else's. And that is not just a matter of good passing or good manners. It comes from our law in the Torres Strait, which is Marlowe's law. And Marlowe's law says, tag moiki moiki, kete moiki moiki. So your hand should not steal or take without permission, and your foot should not walk on someone else's land without permission. And that particular legal doctrine found its way into the historic judgment of Mabo No. 2, which I want to talk about in a little while. But just I wanted to make that statement right up front, that is, in legal terms, that would be the law of stealing and the law of trespass. And those laws are also Christian laws. Thou shalt not steal is an important Christian value. But in saying that, I want to acknowledge the country that I'm on. I want to acknowledge the traditional owners of this place and pay my respects to your elders, past and present, and also for your custodianship of this place and the laws that run with this place. I want to acknowledge all Indigenous brothers and sisters participating in this important forum. I must acknowledge Chief Justice Benjamin for your leadership, your commitment and your vision for creating a space like this to have dialogue. I must confess that through a level of ignorance around what has been happening in this country and coming here and actually speaking with people has opened my eyes to the commonality of challenges that we have right across the country. So thank you, Chief Justice, for that opportunity. I also want to acknowledge Australian Ambassador Sophie Davis and her terrific staff that has been supporting me throughout this process. So distinguished guests one and all, this topic, as I said in my brief comments, is something that's very live in Australia at the moment, the importance of Indigenous cultural heritage. I want to talk about three things that are influencing this space at the moment. In 2020, we had what's called the deliberate destruction of a sacred site called Juukan Gorge. It's a place that is sacred to traditional owners of Western Australia, the top part of Western Australia, and I want to talk about that briefly. The second thing is that in 2023, the Australian peoples went to the polls to decide whether there should be an Indigenous voice to Parliament enshrined in the federal constitution. And the laws to be passed in Australia requires a double majority. It requires a majority of the states, and there are 6 states in Australia, and there must be an overall majority of people. And Aboriginal and Torres Strait Islander people went to that referendum with great hope in their heart that their fellow Australians would recognise them for a change in the constitution, put a voice in there, so they could have a direct dialogue with the lawmakers that make laws about them. Sadly, not one state in that country voted in favour of constitutional recognition. And that's a sad thing, because the Aboriginal people and Torres Strait Islanders of Australia wanted to have three things. They wanted constitutional recognition, they wanted truth-telling, and they wanted makarata. And makarata is a Yolngu word for coming together to make peace after conflict. And we stumbled at the first hurdle. We stumbled at the first hurdle around constitutional recognition. But that's one of the contexts that we need to have this discussion in. And there is a third component to this conversation, is that every year in Australia, there is a scorecard that governments take around how the social indicators that Indigenous peoples are grossly overrepresented. Overrepresentation of the criminal justice system, suicide rates, and there's a plethora of those important social indicators. And each year that scorecard comes back with only one or two ticks going up, some no progress at all, but the bulk of them going in the wrong direction. So that's they're the three things that are influencing a conversation around what the strategies might be to preserve Indigenous cultural knowledge. At a more practical level, there is also the need for preservation of cultural heritage and cultural knowledge in the area of what I do in native title. Because in native title, we are actually reaching the finalisation of the first phase, which is the recognition phase. And the next phase of native title will be native title compensation. And then there's a third component to this next phase, and that is how Indigenous peoples manage or govern two-world governance. So when I talk about two-world governance, when native title is recognised, so put it as though that native title, if you imagine two circles and they're put together in a Venn diagram, the overlapping area of those two circles is native title, but one circle is the common law of Australia, and the other side are the traditional laws and customs of Aboriginal people. So native title is this unique section in the Venn diagram that the overlapping. So it's unique, and people and Indigenous peoples need to navigate that complexity. And that's not an easy thing to do when you've got a plethora of other issues to contend with. And so preservation of cultural knowledge is critical for the next phase of native title, because compensation requires the knowledge holders to speak about the compensable acts that occurred, and that's when a court will consider issues of economic loss, cultural loss. And so the evidence of those knowledge holders is critical to the success of that next phase. There's also a time imperative that we're dealing with in this next phase. And we've heard a bit about it today and yesterday. Our knowledge holders, our elders are passing. And with that passing, is that knowledge being preserved, and is it being transmitted to the next generation that needs to actually take up that fight? And so that's one of the challenges. Another challenge, and we've heard a lot about it at this conference, and that is the impact of climate change. The Intergovernmental Panel on Climate Change has written extensively around how climate change will adversely impact Indigenous peoples more than non-Indigenous people. I suppose there is some positive in this when we talk about that there is the knowledge that Indigenous people have around how climate change could be mitigated. And when I talk about this, in Australia we have, for millennia, we have had what's called cultural burning, mosaic burning. So it is a way of controlling the impact of a hot fire as a result of too much fuel. And this is the way that nature has been managed by Aboriginal people for millennia. So mosaic burning, cultural burning. So there's climate change is occurring, but knowledge around cultural burns is really important and how that's actually worked through. Preserving and practicing ancient traditional ways in the face of the unrelenting march of modernity is going to be a challenge in this next phase. And so that can extend to how artificial intelligence is used. It can be a good servant, but a terrible master. And when it comes to cultural knowledge, how AI could be manipulated in that sense is of concern. And finally, in this next phase is the global geopolitical crises that are occurring. And we know that when there are domestic or national priorities, regrettably, Indigenous people seem to be achieving a lower priority. And so this next phase deals with the real polycrisis of climate change, transitioning economies, and a whole range of other things. That is the kind of challenge that we will need to be talking about. What are some of the practical ways of dealing with those things? But one thing we do know about Indigenous peoples is that we are incredible system thinkers. We always see an issue holistically, and that is of important value for how we actually deal with the wicked problems of now into the future. And Indigenous peoples have much to contribute in that space. But before I get to some of the strategies, and gee, 10 minutes goes very quickly around here. I really do want to share with people here the Australian context, because even though there's a great distance between Brazil and Australia, there's much commonality, but there's also a lot of difference. We've heard common law systems and civil law systems. We have different legal systems. But I can say pre-colonisation that there was something in the order of 600 First Nations groups that lived in the continent now called Australia. Those people spoke between 250 to 300 languages, not dialects as well, and they had practiced harmony with the landscape for over 60,000 years. 60,000 years, continuously. In the case of my people, the Torres Strait Islanders, were a little bit less in the time zone, but it's nevertheless 10,000 years we've occupied our islands. And then this date, 1788, when Captain Phillip arrived at Sydney, in Sydney at Botany Bay, basically saying that this land of the colony of New South Wales was terra nullius. So by the time white people came to Australia, I think that they'd learned that the colonial project apparatus was a bit difficult when you recognise the people that are traditionally from that area. And so they somewhat conveniently labelled that this was an empty land, terra nullius, land that's empty. And of course there were people there, because there were frontier wars being fought for decades. And it was a convenient way of actually saying that the natives there were not of a level of sophistication to recognise and to enter into treaties. But it's 1788. This thing, 88 seems to come up quite a bit. But anyway, 1901. So you actually have these colonies that are created in Australia, and there are around 6 colonies. But in 1901, those colonies decided to get together and federate. And so you have an Australian constitution, but for the purposes of the First Nations people, we were not consulted about whether we wanted to be part of a federation, nor were we included. In fact, we were expressly excluded. There's a reference in the Constitution as it was drafted that the federal parliament would not have power to make laws in relation to Aboriginal people. They remained the preserve of the state jurisdictions. And I'm making this point because you've actually got this national law around property rights, but at the state level, cultural heritage is still regulated at that level. So you've got this juncture occurring at a federal level and at a state level, and there's a tension that comes in between those. And I want to unpack that a little bit. And look, so over the intervening 100 years, there was some policies of yes, genocide after frontier wars, and then there was this policy of protectionism. So it was the smoothing of the pillow of a group of people who were going to die, and they were dying out. That was the pretense of protectionism. So we were moved to reserves, prohibition of cultural expression, could not speak language, not dance, the level of control was an extent where movement was restricted. Even the ability is something as human as the ability to love and marry. Restrictions were placed on who you could marry. So every facet of your life under the rules of protection was implemented to Aboriginal people. After protectionism, so that went for 50-odd years, it then moved into this phase of assimilation. Let's just make them like us. And, you know, maybe that would just go away, this desire to be separate. And that went on for a little while. Gratefully, in the 1970s, the global international human rights movement started to penetrate the psyche of Australia, and we started to get really powerful laws around, well, programs, I would say, around funding for very important things like Aboriginal legal services, Aboriginal housing co-ops, Aboriginal childcare, Aboriginal education, really important programs. But these programs were considered to be for a pan-Aboriginal polity. We were considered to be homogenous, but that was never the case. But nevertheless, under that construct, there was a level of self-management that started to occur. And it was amazing to hear Funai, the work that's done there. At SIC, we had something similar to Funai between 1989 and 2015. And it was called the Aboriginal and Torres Strait Islander Commission. And it was a commission that was responsible for funding, service delivery, political representation, but then it was abolished. And so we lost a lot of momentum around how self-management and self-determination could occur. And I'm now got a 1 minute. I'm going to have to engage upon your indulgence, I'm afraid, Chief Justice. So what we've got is, we've got these different phases, and they've moved through. And Aboriginal people have had to, it's like dancing on moving carpet, constantly having to move with whatever's being changed at a macro level. And that has had an impact. But I can say this figure 1988, remarkable. I have to confess my ignorance is that I did not know of the Constitution of Brazil in 1988 until I actually was planning to come across here. 1988 for me is also important because it's the date that the High Court of Australia said that the Queensland Coast Island Declaratory Act that was prohibiting a claim by a land rights activist, Mr. Eddie Mabo, that the claim that he was bringing was invalid because they were going to actually pass a law that said you could not bring that claim. And the High Court of Australia in 1988 said that the passing of the Queensland law was inconsistent with the Racial Discrimination Act, which is a Commonwealth law, and because of that inconsistency between the Commonwealth Constitution and the state law was deemed to be invalid. And I have to say, if that invalidity did not take place, we would not have had a Mabo number 2. And Mabo number 2 is when the High Court recognised the Torres Strait, the Miriam people, my people from the Torres Strait, that we had a continuous connection to those islands since time immemorial, and our laws and customs gave us rights and interests in relation to land and waters, that the High Court would not recognise the laws and customs, but it would recognise the rights and interests. And that's not a bad second gift. But the major thing about that is this racist legal fiction of terra nullius, the Brit that had blinded the country to its past was blown away. And so terra nullius was then abolished. And that then allowed the principle, the Native Title Act, to come into place. And so that's how we've got to where we are now. The point that I want to make is that when it comes to strategies around cultural heritage, you've got this really peculiar situation where native title collective rights are recognised at a federal level, but then cultural heritage is then regulated at a state level. And then, but for Indigenous people, native title, cultural heritage, two sides to one coin. We don't bifurcate these things like that. And this tension has been in the system for a long time. And in 2020, the date that I was talking about before, in 2020, Rio Tinto, a company that had entered into agreements under the Native Title Act with a traditional owner group, essentially blew up a cave that had 46,000 years of connection. And I just wanted to read a statement by one of the senators in the parliament when this travesty had occurred. And since I'm quasi-judicial, so I don't have to be as apolitical as the colleagues here, but I'm reading from Hansard here, so I'm protecting myself. And the senator said, "I rise tonight to speak on the irreplaceable loss of Juukan Gorge rock shelters in the Pilbara of Western Australia. These were willfully destroyed on Sunday, 24 May, at the beginning of Reconciliation Week." Get to what Reconciliation Week is. Rio Tinto blasted the Juukan Gorge rock shelters to smithereens. The rock shelters showed 46,000 years worth of continual occupation and provided 4,000-year-old genetic link to today's traditional owners. 4,000 years. The Putu Kunti Kurama Pinakuma people, the traditional owners of this land that was blasted, did not want this heritage destroyed, but now it's gone. People around the world rightly condemn the destruction of ancient statues and sites by the Taliban and ISIS, What was blasted in the Pilbara in Western Australia is irreplaceable, 46,000 years, and is rightly being condemned around the world. Rio Tinto knew the cultural significance of the site to the traditional owners. They even helped to make a documentary about it. They can't deny that this was willful destruction of a heritage site. It is morally and ethically wrong. They do not have a social license to do that. Now, that, as sad as that was, destruction like this occurs on a regular basis, not to that scale, but on you know, all destruction is terrible. But there might be one silver lining about this, and that was that it actually prompted a joint standing committee inquiry, so of the House of Representatives and the Senate, to investigate this. And they investigated this and they produced two reports. The first report titled Never Again, and the second report was A Way Forward. Now, we don't have enough time to unpack those, but essentially some of the things that came out of the reviews was that in the looking at cultural heritage laws, there would need to be system change. There was almost a universal acceptance that the cultural heritage laws in Australia aren't working for Aboriginal and Torres Strait Islander people. They also said that a guiding principle ought to be the free, prior, informed consent as articulated in the United Nations Declaration on Rights of Indigenous Peoples. That's quite profound. Australia is a signatory, but for laws to be domestically implemented, it needs to be enacted. There is no UNDRIP law at a domestic level, even though there is reference to it frequently. But the thing is that the strategies that need to be implemented was that whatever the system change, it had to be co-designed. And that is really a first, because things, the comment is yesterday made by our colleague from UNICEF was nothing about us without us. That actually is what that is about. In the design of whatever model is developed, Aboriginal people had to be part of it. Not design it and then give participation later, but part of the co-design. And there are three models that have come out of that co-design exercise, and I can't talk too much about it because it's still the subject of deliberation within government, but I'm hopeful that we will see at least an exposure draft of what that law looks like. And if FPIC is a guiding principle, then it would be interesting to see what that looks like in the draft exposure. And I also have to be careful because there's a second limb to the review, to the inquiry, was it the Native Title Act, 30 years on, needed to be considered again, because was it fit for purpose? What was developed 30 odd years ago in the statute, is it fit for purpose for the next 30 years? And my tribunal is the subject of that inquiry, and we are a robust organisation, and we are looking forward, we're participating in it, and we want to be involved in whatever the outcome is. So, but I'll conclude by just making some very brief comments about the practical things that we are doing as a tribunal. We see the development of preserving cultural knowledge by mapping rights and interests on behalf of traditional owners, but only where their data sovereignty is maintained. So instead of being reactive to what is happening on country, when a proponent wants to do a range of things, there can be a conversation around these are no-go zones, this is where we might have a conversation, and this is where there's conversations for economic opportunity. Because in native title in Australia is very reactive and it's transactional. And unless you get ahead of the game and there's good planning occurring around that, then that's all you're ever doing is reacting. And when you are constrained by resources and sorry business and a range of things that go on in community, it's very hard to get ahead of the curve on these things. So we're doing some practical things there. We're wanting to work with people to preserve cultural knowledge in a way that can be transmitted to a young generation with the benefit of technology. Ideally, should be transmitted on country. But if you can't do that, then there might be other ways of developing it. So we're looking at those practical ways. But in conclusion, so I'll just make one other point. And the third point is system coordination. The Tribunal, along with other Commonwealth agencies, are wanting to work better together to make the system more coordinated. And that's difficult to do in an adversarial system when you've got the Federal Court, the NNTT, impartial bodies, and then you've got other participants that are operationally adversarial at the bar table, but trying to work together for building system capability and capacity is really critical. A small but important part in that process. So in concluding, the strategies to deal with the preservation of Indigenous cultural heritage and knowledge is that there needs to be a systems thinking approach. No more of this, incrementalism. You need to look at the big picture, and Indigenous peoples have a natural propensity to look at the big picture. And so we can draw on our own ability to do that. Co-design is critical. And then when the co-design is done, Indigenous people need to be in the driver's seat. No more passenger side, driver's seat. There needs to be sufficient resources to make these things sustainable. Data sovereignty must be critical. But all of these things will be strategies. The success will be measured on whether the closing the gap indicators are reduced. I mean, that's one of the things. Reconciliation. We live in a coexisting reality, and the quality of that coexistence needs to be peaceful. And that means there needs to be an emphasis on the relationship between Indigenous and non-Indigenous people, and there needs to be peace. And then there needs to be a shared vision for what the nation of Australia is moving forward. And that's going to be a complex thing, but that's the only way that we can write the next chapter of Australia. So kaima aweswa, big thank you.
Eu agradeço muito o presidente.
I thank President Kesman Smith very much. I think that through this speech, there are common experiences and challenges. We sometimes have hope that the Indigenous communities in other places might be in a better and more advanced situation, and then we notice and reach the conclusion that it is not the fact. There's a resistance, or often unjustified, in accepting who they are, their knowledge, what they have to teach us, what they have to add, and the difficulty in recognizing the rights that they have to being who they are, of thinking the way they think, and of believing in what they believe. Unfortunately, I think this is something that links us and joins us, unfortunately. So now I shall hand over to Dr. Eliane Torelli de Carvalho. Good morning, everyone. I'd like to greet my fellow roundtable members here. Thank Kevin, Judge Kevin, for his presentation. And as Justice Sebastião Reis said, there are so many things in common. And here, when the Portuguese arrived as well, They also thought it was terra nullius and no man's land. And from there onwards, it's been centuries of indigenous peoples fighting for their rights. Before starting, perhaps even to clarify to the non-Brazilian participants, the Constitution on Article 129 Incise 5 confers to the Attorney General the role of defending the rights of indigenous people. And also in Article 232, the Constitution says that indigenous people themselves have legitimacy to defend their own rights. And so, we currently have this competition in the good sense between the indigenous people and the Attorney General's office in the defense of indigenous people's law and rights. So this is why I'm here, as a representative of the Federal Attorney General's office and as a coordinator of the area of the Attorney General's office that takes care of the rights and interests of indigenous peoples. Okay, so the subject that was proposed were the preservation strategy of indigenous cultural heritage. That is, in fact, one of the subjects on which the Attorney General's office works, and is the subject that takes most time for us now is territorial protection, without doubt. Demarcation of the land, and that has been suffering a series of setbacks. We also act within indigenous health, indigenous education, and of course, cultural heritage protection.
Então, a questão da proteção do patrimônio cultural indígena,
indigenous cultural heritage protection has had a turning point with the 1988 Constitution, because before that, we had a completely Eurocentric paradigm. And this Eurocentric paradigm defended the preservation of that which was cultural heritage, but centered on that which would mirror how the nation was created and formed. And unfortunately, that would and did not include the indigenous people's contributions, and of also the Black, Afro, and traditional community contributions that we have in Brazil, that we have at least 28 traditional types, traditional communities, at least of those registered. And so our cultural heritage is huge, but it was for a vast majority ignored and dismissed in this Eurocentric pattern. I'm going to speak quickly of legal aspects. The Constitution of 1924 and 1891 did not talk about cultural heritage. 1934 Constitution started treating it, and after in the Constitution 1937, where we created ISFAM, which was the Protection Services of Historical Heritage. And then we started working on the declaration of them such as heritage, and the documents and monuments that were natural, or documents of arts. It was a concept that was also starting to be enlarged for the protection of areas that had a scenic value and other natural beauties. The 1967 and 69 constitutions were the constitutions of the dictatorship times, but would repeat this protection to cultural heritage. And then we have the 1988 Constitution that confers us a completely new protection to cultural heritage. And so in Article 115, in the first paragraph, the Constitution says the state will protect the manifestation of popular, indigenous, and Afro-Brazilian cultures, and that of other groups of the civilization process of the nation. And this concept, therefore, was so broadened to protect not just this culture within a European vision, statues, monuments, and so on, but also for the protection of this entire cultural heritage of indigenous peoples. This involves things such as rituals, traditions, body paintings, feather-related arts, and this whole range of cultural manifestation by indigenous peoples, and also maroon peoples, quilombolas, and traditional communities.
Well, starting with the 1988 Constitution, we've had two very important laws. Law 13,199, which is the biodiversity law that foresees that traditional knowledge of indigenous people and then of traditional communities associated to the genetic heritage are a part of the Brazilian cultural heritage. This was a theme that was explored quite widely and that brought about some very important cases of appropriation of indigenous traditional knowledge as it is associated to biodiversity. I had the opportunity to work in a few cases. I'm going to present this briefly. We also had the Snook Law, which had the objective of protecting natural resources that are necessary for the subsistence of traditional populations, respecting and valuing their knowledge and their culture, and protecting their means of life and the culture of traditional extractivist communities. That is, we started to have legislations that are environmental as well, and Justice Benjamin also mentioned this. You can't separate these two. You can't protect nature without protecting traditional peoples. After all, we know that the forests are indeed the product of human interventions as well. When you go to the Amazon rainforest and you see nut groves, you see rubber tree groves, do you think all of that was there just by coincidence? So it is starting with this understanding that our legislation started evolving. And I'd also like to say that within the federal prosecutor's office, before we used to have a very rigid division between prosecutors that dealt with the defense of the environment and those that defended indigenous people, as if
como se tratasse, por exemplo, as áreas protegidas como patrimônio intocável, onde
as if the protected and environmental protected areas were untouchable heritage and you couldn't have the presence of traditional people. Now we have a very interesting evolution in that sense. So this case that is mentioned in the screen is the Umurumuru case. Umurumuru is a plant that is quite well known by the Ashaninka people. The Ashaninka people are people from the state of Acre in the border. They are very different from the most other indigenous people of Brazil. They have a very different style of garb and from what we usually think of when we think of indigenous people of Brazil. And they had traditional knowledge associated to biodiversity and the use of umurumuru. And a researcher went to this community, according to what he said, with the objective of carrying out studies, and then he had the contact with the use of Umurumuru by the Ashaninka people, and he negotiated this to a national company, a large national company, first, without the informed previous consent of the Ashaninka people, and second, without any sort of benefits given or shared with the Ashaninka people. So they were commercializing this without giving any benefits to the people. So we installed the procedure at the prosecutor's office, the attorney general office, and we started a lawsuit in favor of the Ashaninka people. This was judged partially in favor of our action. Unfortunately, Justice is still awaiting trial in the regional district court of the first circuit ever since 2014. It's still awaiting trial, so we still have not had closure to this case. We also had another case which was quite interesting, which was the Krao people, which is more or less the same modus operandi. Researchers go to the community, they say they're carrying out this or that study, then they do not carry out previously informed consultations for consent of the community. Afterwards, they start selling that traditional knowledge that they acquired in that community. In this case, it was enough to have a recommendation from the prosecutor's office, and the issue halted in that moment. And this case is very symbolic, very emblematic, but also a very sad case in which the construction of a hydroelectric power plant dam in the Telespires River did not take into consideration the indigenous component in the environmental licensing. They destroyed a waterfall that was a sacred location for the indigenous people of that region. The Seven Falls, that it was known. It was a place where they practiced not only their ceremonies, but also where they had buried their ancestors. The federal prosecutor's office came in with a lawsuit demanding that they should have correct licensing and that the indigenous people should be consulted. We were able to win in the first level, but unfortunately our decision, that decision was appealed, and the construction continued, and they destroyed the waterfalls, just like the case that Judge Kevin told us about. That waterfall was destroyed, just as the cave that that Judge Kevin mentioned. I'm about to wrap up, okay, Justice Benjamin? So the devolution of objects. No, I think I skipped this. So when you give back objects that are of cultural value to indigenous people, which ended up being taken from them without the consent of people. So we have the case of the axe. Sorry, let me just refer to my notes. Anyway, the most famous of these cases, of course, is the case of the famous Tupinambá mantle. That case started back in 2000 due to the occasion of the 500 years of the arrival of the Portuguese in Brazil. There was an exhibit, and this mantle came to Brazil. It was in Denmark, I believe at the time. It came to Brazil just for an exhibit, and the Tupinambá people felt offended by this exhibit, that this beautiful mantle, well, they didn't have access to this mantle. This is the Tupinambá mantle. It is made out of feathers of a bird called the red ibis. It is a beautiful piece of handicraft. At the time, the prosecutor's office started a procedure. This was in 2000, okay? At that time, here in Brazil, we did not have any sort of institution. Well, since this is a very ancient piece made out of biological materials, it can't, well, it needs to be in special conditions for conservation. And at that time in Brazil, we consulted various museums, and we did not have in Brazil any museum that declared themselves as having a condition to receive this mantle. They all denied it. Well, anyway, happily, I believe that it was 2 years ago, in 2023, the Brazilian government was able to repatriate the Tupinambá mantle, and now it is in the National Museum. It's in the National Museum. Finally, we have the funerary urns of the Munduruku people. Many of them were in a museum. And these are obviously, I mean, they're funerary urns. They are objects which are considered very sacred to the indigenous people of the Munduruku community. The Munduruku people themselves went to the museum and they took their funerary urns back. I'm not judging the merits here. So the Munduruku people went to the museum, took their funerary urns, and buried them in the proper sacred location from where they should not have been taken. So that's the way that that procedure was concluded. And I'd like to thank Justice Herman Benjamin, Justice Sebastian Hayes for the opportunity to tell a little bit, even if very briefly, of the work of the Federal Prosecutor's Office on this area. Thank you very much. We're the ones who like to thank you. We can see from Dr. Eliana's speech that on paper, there are rights. Rights are recognized on paper, but there is eternal difficulty, so it seems, for these rights to turn into reality. Sometimes when we look at these interventions that are necessary for the Federal Prosecutor's Office, even in guaranteeing fundamental rights or cultural heritage, even simple things like pieces of heritage, of material heritage, and then you need to have the intervention of the Public Prosecutor's Office, intervention of the justice system for these rights to be recognized. It's a constant struggle, is it not? Now we're going to pass the floor to Dr. Virginia Casado. She is a social scientist with a graduate degree in sociology. She is an official of the UNESCO Culture Office in Brazil, where she has been looking at projects commanded by UNESCO since 2005 involving cases such as creative economy, cultural heritage, cultural diversity, intercultural dialogue, museums, among others. Other than experience in technical operation and culture, she's also been the manager of programs, spaces, and projects, also in public, private, and third sector instances. Dr. Virginia, you have the floor. Thank you. Good morning, everyone. I would like to greet the panel. I'd like to especially greet Justice Herman Benjamin. We've had other opportunities to share these such special themes with UNESCO, so I'd like to greet all of you. And I'd just like to ask to greet you and the previous president, Maria Teresa Justice Moura, the previous Chief Justice, who in 2023 coordinated a symposium that also with years of the 1972 Convention of the World Heritage, with an emphasis on the interrelationship between natural and cultural heritage. So, our proposal for today, especially because we don't have a lot of time or have very little time, is to present a general overview regarding instruments of multilateral instruments from the UN, and then we'll go further in depth in relation to instruments emphasizing binding instruments that promote effectiveness in relation to the implementation of policies, actions, and programs. In relation to this point of reference, we need to list a few of them that were important, not just in relation to heritage, but also involving indigenous peoples' rights, such as the Permanent Forum on Indigenous Issues, which was implemented in the year 2000. And there was an alert that indigenous people represent less than 5% of the global population, but they are the guardians of 80% of the biodiversity of the planet. And this was contemplated or mentioned ever since yesterday's opening table. Today we also had a panel that talked about these conditions. Another important instrument, one of the most relevant, was the 169 ILO Convention, which Brazil adopted effectively in 2009, based on a variety of ratification processes, etc. And beyond this condition of effectively implementing policies that may benefit these peoples, this ILO convention also proposes consultations to the people. So this direct dialogue, this direct effective participation of peoples. And in 2021, we have the implementation of UNESCO's policy of collaboration with indigenous people. What is this policy? I'd like to call attention that this is not a binding instrument, but it is a very important reference or point of reference, so that all the different programs in UNESCO that involves education, culture, communication, heritage, the area of scientific knowledge as well, social sciences, cultural sciences. So we need to identify all of these programs such as the Decades of the Ocean, which is a cultural science, natural sciences program, in which we might be able to identify opportunities for the implementation of actions which may contemplate indigenous people. So that is a great opportunity to create an inventory and to trigger these actions globally. In 2019, in this session of the World Heritage Committee in Baku, Azerbaijan, there was the implementation of an instrument so that indigenous languages are identified as items to make up the process of World Heritage Conversation. This was called the Indigenous Engagement in the World Heritage Processes. And in that year as well, we had the International Decade of Indigenous Languages. That's one of the main areas that we act in. It's going to be the theme of a panel in the afternoon. This is also a context in which there is the effective action and a lot of engagement. We have a working group in which the different countries set up a governance structure and different strategies for the implementation of actions for the International Decade of Indigenous Languages that started in 2022. There was also the International Forum of Indigenous People for World Heritage, which reinforced the previous conditions that I just mentioned, especially for the identification of sites that would be in a list, which is not the formal list like in the 2003 convention, as you will see a little bit further on. The identification of sites that are in a condition that are threatened. for heritage and cultural diversity. Well, the indigenous people are the guardians of a large part of biological, cultural, and linguistic diversity of the world. So 40% of the 6,600 languages spoken throughout the world are in the brink of disappearance. All of these points of reference are identified with the goals of 2030 agenda. And one specific goal is the strengthening of efforts for the protection and safeguard of cultural and natural heritage of the world.
We've also had a benchmark, what was the Monchacuch summit in Mexico, and that this year we're going to have another Monjacuch. In regards to UNESCO's culture sector, represents a great benchmark. Why? Well, because the treatment, the attempt to find transversality, because if we've identified that Convention X with these, identified with these parameters, well, there's a proposition that this concluding the construction of instruments that foresee transversality. And one of the main agendas was discussion on climate change, of course, involving cultural heritage as a whole. And one of the items, one of the agendas that were very strengthened by Monjacuch was considering world heritage and traditional knowledge for the mitigation of the effects of climate change and facing the challenges caused by climate change. And I think this agenda has already been vastly mentioned here, even in this morning. I'm now going to hand over to the normative binding instruments in the cultural part, emphasis with the Convention of 2003 for the safeguard of immaterial cultural heritage. Because why? Because the representation of UNESCO in Brazil has been collaborating with public administration and civil society to implement several actions, especially involving this convention. Why especially for this convention? Because we're attending to the demand of the country's request of the state. And in this sense, throughout the last few decades, we have been participating through technical international cooperation in the implementation of several projects, especially with IFAM, FUNAI, and other entities. But it is important to cite, in this context involving indigenous rights and cultural heritage, there's no way we can't cite the 70s convention that was even mentioned by Dr. Eliana here not long ago. It is a convention that was adopted by Brazil many years ago already, and was of course mentioned as a great benchmark, the return of the month to Binambá. The condition of its return wasn't directly involved from a legal institutional point of view, but for programmatically wise, yes. Of the Convention for the Protection of World Heritage, Cultural and Natural that I mentioned previously, that was the subject of a special symposium here, an international symposium, 2 years ago, 2023, if I'm not mistaken. It is also a really important convention that is a reference. I'm going to cite some connections regards to indigenous cultural heritage as well. So this 2003 convention that I'm going to talk about, and 2005 protects promotion of the diversity of cultural expressions. And let's say that within this context involving peoples, indigenous peoples, benchmarks is a convention that we still haven't used as an essential reference to implement actions in partnership with the government. So I've mentioned Manto Binaba, that was a benchmark. And then I've already even mentioned that hasn't directly involved this convention, but from a program point of view, yes. But in this convention involves several cultural heritage, but we have especially natural heritages, some sites, some in the Amazon, some others involving the Atlantic that involve it as well. Is interesting because from the point of view, because Dr. Eliana mentioned the Eurocentrism, well, there is a movement this moment to rename this rediscovery. We have the original peoples that this is involved, and the Jesuit Guarani missions, of course. And this heritage dialogues more with the period, and the Jesuits were in a condition also of, well, Eurocentric way, objective also of being questioned from a point of view of a colonization point of view. But we also have possibilities and in a very robust way was undertaken by IFA and other partners, including Guarani communities, to work on the language. And we have, so the national inventory created by IFA, it involved Guarani as one of the main, including the Guarani languages as one of the main concepts. So including recognition of expressions, practices, techniques must be recognized and treated as a cultural heritage of an immaterial nature. So the function of the party states, which is the character of this convention, that is that once adopted by the member state, it is mandatory that it be implemented. And in Brazil, when Brazil implemented this convention, the instruments that it already had implemented was referenced, and they were therefore recognized internationally. And this is one of the conventions in which Brazil collaborated the most. And it was a little bit different in regards to the one of 72 that would just have a representative list. This has the representative list. So the expressions that are considered safeguarded, but also the ones that require urgent safeguarding and the best practices list. In that sense, the first expression has to do with a complete synergy with this protection of indigenous peoples of Brazil. I'm going to try and go a little bit faster. Expression of Izayampi, that was the first expression, and then we have in the list of immaterial heritage the Iaqua ritual, that is of the Iauene people, and that is creating a case. So UNESCO is giving visibility to it because this moment the community representatives and IFA itself are building a process to recognize the committee of the convention of 2003 to go on to the representative list. And as mentioned already, we have a technical cooperation with the National Museum of Indigenous Peoples for over 20 years and as the safeguarding of the linguistic cultural heritage of several peoples. And these are the language and territories involved in this phase of the project that involves indigenous of recent contact and borders. And I cited the INDL as one of the main instruments, so the National Diversity Inventory to preserve the indigenous language. And at this moment, we're involved in a work group that the indigenous protagonism is being considered. So we're reworking this model. And lastly here, we published bilingual leaflets involving peoples of the Vale of Javari. I would like to thank and apologize for going over our time.
Bem, agora nós vamos.
Very well. We are therefore now going to head on to the debate and interventions, as I promised. We're already at the lunchtime, but the debates are more important than lunch. So, I would like to open the floor. I'd like to mention that we have Cacique, so Chief Megaron, that is here, and several of his colleagues.
Quero dizer que nós oferecemos.
I would like to say that we offer the leaderships, so Chief Megaron and all his peers, flight tickets. But they said, no, we're going to go by foot as a pilgrimage. And so that's why they arrived a little bit late. And I'm very grateful to have them here and happy to see them here. So I'd like you to, or anyone who would like to talk now, I'd request that they please identify themselves. Though we are going to give preference to indigenous people. But you raise your hand so you can speak. But please do introduce yourself.
Por favor.
Bom dia, né? Meu nome é Marcondes.
Good morning, my name is Marcondes. I'm from the Tapuia people, and I'm originally from the Federal District. We were the indigenous people that were invisibilized by the construction of the capital. And one of the important subjects that I wanted to bring to enrich the discussion is because what we've been hearing since yesterday is the question of all the indigenous languages, the more than hundreds and thousands of languages, and more than 300 peoples. But what we noticed in the course and the other branches of power, legislative, and even in the federal district, we still see a lot of discrimination. I think subject for the judiciary, for the legal branch, when we talk about indigenous peoples and their rights, is to concern themselves more how to solve the discrimination. We had a federal congresswoman that was recently discriminated against as well. And we talk about this a lot. We talk about 305 peoples. So all have characteristics, physical characteristics that are completely different. We see in the panel, we see Pataxó and other ethnicities, all very different. But the people of the central plains of this federal district, of the interior, and the heart of Brazil are very discriminated against. This stereotypically, I'm going to say even just because we just talked about Ifá, is that the indigenous, the oldest indigenous remains was of an indigenous one. We're talking about their black, like Afro-descendant-like traits. So these are remains over 12,000 years. So the oldest indigenous people had some African traits, something we still talk about nowadays. And so we see that this mix and such happen. And it's important to understand because recently, here in the federal district, the current governor said the indigenous peoples should go back to their states. and have the obligation of with these people as of their own state, not knowing the history or not acknowledging the history and the just people of this actual place and the federal history. And the masters must understand that each people have their own traits, characteristics, and this should be considered when we fight for the earth. Today, I am from the village Raiaan in Paranoá, less than 30 minutes from this house here, and we're still fighting for the basic rights for Earth. Because when in '88 we were in our original locations, Paranoá, and then in '89 governor removed us from there without any specific policy, and we still need to fight for the land. We finally, we only just got electricity a year ago. We were there in darkness for years, and we still live without any roads. It's because in Brasilia, oh, the image of a plane or the architect, this and that. Wait, when I look at the project, I see there only a bow and arrow. My first project was a bow and arrow. So what he thought when he was building Brasilia. And then now, one of the biggest riches is the Paranoá Lake, which is the language of my grandmother. It's called River Parnauá. So you have the laws and the rights, but when they're applied, should be applied, they're not applied. Thank you very much. The question of discrimination in our country is alarming. And here in the STJ, we have many precedents, but the precedents of fundamentally in discrimination in regards to women, of Afro-descendants, and more recently, that of other minorities. So it's important to recognize that discrimination of indigenous peoples is huge and starts very often by being barred from entering the court's buildings because they're not because they are not, as I once heard from a security officer who stopped the indigenous people from entering here, the STJ. They were coming to meet with me, and I went to speak to the security officers that are in front. I was like, why were they stopped from entering? I said, well, because they're not dressed as citizens. It's as if the citizen had to have a certain standardized way of dressing themselves. So we do recognize the gravity of this and the existence of this discrimination. But there are other kinds of discrimination of indigenous peoples as well. If we think properly, the effacing, the way of making them invisible, is a way of discriminating. Direct discrimination that is more visible. Perhaps that which shows up the most easily. But the invisibility of them as a group, as people, I think this is the worst kind, or the worst one we have. So thank you for your intervention. Next one. Justice. Good morning. First, I would like to greet Your Excellency for the great initiative and especially our indigenous leaders here. Would you like to introduce yourself, please? Yes, of course. My name is Marcelo Rosa. I'm a lawyer and study indigenous rights, and I really care for the subject. And I'd like to ask something, especially to Dr. Kevin Smith, related especially to, well, because I think it's something that it's already agreed upon, and STJ has already, the Supreme Court has already considered the temporal thesis unconstitutional, and the land really is ancestral and does belong to our original peoples. And so that is no longer being discussed, despite parts of society thinking otherwise. However, our concern as regards of the demarcation. That is a very slow, time-consuming process that is taking place in Brazil, and sad even in regards to the state engine, the attempt to silence, discriminate, and make our people invisible. However, there are parts of indigenous peoples and leaderships that defend a movement called the ethno-development of these territories from the consultation and protagonism of these leaderships. So there is an experience here in the state of Mato Grosso. Could you please ask the question? Okay, yes. So there's a question in regards to the plantation of soy in these territories. My question to Dr. Kevin is the following. How does he see this movement of the indigenous heritages on economic development of and in these territories? I'm sorry for taking too long to ask.
That's quite a bit to unpack.
Please.
Look, I think the tension between economic development and maintaining culture is a real one. And how people deal with that will depend upon the decisions that they make. And so it's a difficult one to answer, but it has to be unique to the individuals, provided there's free, prior, informed consent. I mean, it's really critical that if people come on to wanting to do projects on people's country, that there's the requisite information that's provided, that there's notice provided, that it's information that's accessible to them, that the discussions around the implications of that is all up front. So, it's a very specific question. I'm not really understanding the context of this land, but over in Australia, free, prior, informed consent is a real issue. Sometimes the processes, the timeframes to respond are too short. The information is too scant, and the pressure of just community also impacts upon the ability to make decisions. Free, prior, informed consent also, there's an inference that it's an ongoing obligation. So that when you're implementing agreements, that there's an opportunity to check, to see whether consent is ongoing. So, yeah, it's a critically important right, and it's an access to justice issue as well.
Muito bem. Então, talvez mais uma pergunta?
Maybe one more question? Good afternoon. My name is Bruno. I'm an archaeologist. I'm from the Ministry of Tourism. I used to work at Eliel in the Ministry of the Indigenous People. An archaeologist. Yes, I'm an archaeologist. So in our surveys, we're going to have a book that's coming out on archaeology, cultural heritage, that has to do with this cultural heritage debate, and taking advantage that we have people from the National High Court, UNESCO, and the prosecutor's office that have a big problem in the Ministry of Indigenous People that people will be commenting on, which is the issue of the lack of knowledge and lack of action by the state. So currently we only have 6 indigenous immaterial heritage. Material heritage also very little compared to the amount of churches that we have. For instance, we have so many different churches. There's a very relevant in the heritage. So there's a lack of balance between the activities of development in the Brazilian state, especially regarding environmental licensing, with the preservation of these assets. So currently we don't have legal mechanisms with rituals that are not held as heritage that are affected by construction work. The cultural impacts aren't even considered when there's a construction work. So taking advantage of the fact that we have here, and we're talking about cultural heritage, I think this is a moment where we need to refound this whole situation. We need to make it so that these cultural heritage assets, which are oftentimes massacred, the construction comes in, they affect these people. There's no sorts of indigenous descent, even for the indigenous movement to act, because the assets that are considered heritage, they're only recognized as heritage by the state, and the indigenous heritage, the heritage is, sorry, the heritage recognition by the state is very slow. It takes a long time for them to be recognized. So this is more of an appeal to all of you. I think the executive branch has very little resources for now. Clearly, that's not the priority because they have a lot of different priorities, and I'm not criticizing them to have very serious priorities. In the debate, considering the importance of this panel and of your speeches, that I think that we should maybe create these sorts of instances, bring about this debate. We need to bring the indigenous people on the table. We have, for instance, very proved damages that were affect the indigenous people. Maybe we should have some different sort of mechanism. That's more or less it. What's your name? Bruno. Bruno. All right. Can I comment something on that? My name is Thaisa. I'm from IFAM. I'm currently IFAM for our foreign guests. It's the National Heritage Institute. So taking advantage of Bruno's speech, I was actually going to comment on that. Yes, we have a variety of different failures and a huge historical debt inside our institute. We're actually working in a few working groups with the Xingu people, indigenous land. We also have a partnership that's starting now with other indigenous peoples for us to try and take into account this large passive that we have with all these liabilities that we have with indigenous people, including the almost 300 currently recognized indigenous languages. They're only recognized when they are a part of the MDL. You're going very fast, otherwise you're only going to be speaking to the Brazilians because the interpreters won't be able to translate. So there's the promotion and evaluation of the linguistic diversity. Please speak more slowly to help our interpreters. Okay, I'm trying to go quickly to, no, you don't need to go fast because otherwise no one will understand you. Okay, I'm sorry. The foreigners won't understand you if you speak too quickly. Okay, so I'd just like to reinforce what Bruno was saying in relation to the lack of capacity of the Brazilian executive branch to take care of the institutions that have this role of protecting and valuing cultural heritage and linguistic heritage of the indigenous people, as well as the archaeological assets. We know there's not just the 7 waterfalls of the Munduruku people. There was the cave in the Xingu. There's various different cultural heritage assets that were also threatened by the railways. We don't even have enough assets. We don't even have enough resources to monitor those that are already listed and recognized. As far as linguistic diversity, we tried to get just 100,000 reais to try and support our goals for indigenous languages, to have a gathering of indigenous people. We tried to get 100,000 reais and we couldn't have it. We have millions going to colonial heritage for the restoration of churches and things like that. So it really is, in fact, for a situation in which for the protection of those rights, it demands a strengthening of the institutions and the strengthening of these, and even for understanding of the institution itself, of what its own role is. And since it finds almost 90 years old, and practically 80 of them were directed towards colonial heritage, even within IFAM, we're still starting in baby steps to work with indigenous heritage, and we need guidelines that come from public management. For instance, the working group. I'd like to thank you. I'd just like to remind you that IFAM is a very important agency for our country. I wrote an article, an op-ed, for the Folha de São Paulo newspaper, something like the Brazilian New York Times, on IFAM, and celebrating the magnificent work of your technicians. It's an agency that has very little in terms of budget and a lot in terms of its mission. Soon, you will be 100 years old, the institution. We are actually in a listed listed building right now. We can't do anything in this building if we don't have the approval and studies from IFAM, because it is material heritage. That's material heritage, but here we're also dealing a lot with immaterial heritage, tangible heritage, languages, cultural components of indigenous people. Let us wrap up. I'd like, before I pass the floor to my colleague, Justice Sebastião Reis, for the closing, I'd just like to say that regarding this theme of the panel, which is the protection of cultural heritage, that the National High Court, the STJ, has more precedents in favor of material and immaterial cultural heritage than all other Supreme Courts of Latin America added together. And it's still not a very large number. We probably have something like 20 or 30 decisions, 20 or 30 precedents regarding that area. And in the environment, our home, the STJ, here then we have an amount of precedents which is enormous. We judge annually over more environmental appeals than all Supreme Courts of Latin America and the Caribbean, many times over. And if on the one hand, this makes it so that we are in a certain way satisfied, insatisfaction must be the rule, because what we actually judge is the very tip of the iceberg of what is going on in our country. Regarding cultural heritage, Brazil, it was this court that established this. It was the only country in the whole world to recognize judicially that the UNESCO Convention for Historical Cultural Heritage, natural and cultural heritage, can be directly implemented by judges. Because the literature of compared law is all in the sense that the convention cannot be implemented directly. But we concluded that it can. It can be applied directly, of course, jointly, in a kind of legislative marriage with Brazilian law. This is the only precedent in the world still today to give teeth to this convention, to make it more effective, so that it's not just another international declaration document with some persuasive power. No, it can be directly used and referred to by judges. The theme that was brought here in one of the interventions is what would be the role of the judiciary regarding cultural heritage that is not yet protected and recognized by our agency in charge, which would be IFAM in this case. I think that was Bruno's question, really. The National High Court has precedents saying that the Brazilian judges not only can but must recognize and protect elements of natural and cultural heritage. This is an advancement that we still don't have other precedents in Latin America, but I know from colleagues, especially from Central America, from the Mesoamerican region, from Mexico, and even from the Andes, with a very rich cultural heritage, in which judges, based on this precedent, are waking up and saying, listen, we can recognize that a certain asset is extremely relevant, for instance, extremely archaeologically or ethnographically relevant, or even naturally relevant. And then in environmental law, there are precedents from the National High Court, there are a variety of them, saying that we judges can, of course, always based on the legislation and with elements of expert opinions that are a part of the court of the trial documentation, that we should recognize some environmental law. All of you have heard about a variety of the various Brazilian biomes. The Amazon is one of the biomes. The place where we are now is in the Cerrado biome, the Caatinga, where I come from, Pantanal marshlands, and then the Pampas. But there's a new biome that has been recognized judicially. It's not in the official list of Brazilian biomes from the agency that is in charge of Brazilian geography, but the National High Court has recognized the new biome.
São os campos rupestres de altitude.
There are high plains in the Pinhais, the Rupestrians high altitude plains, because they're completely different from everything else that we have. We don't have a legal regimen for these rupestrian fields. What does that mean? That there are rocks in these fields in high altitudes. We don't have anything else like that. And so I'd like to conclude with this note on the importance of the work of judges, and also at the same time on the importance of the knowledge of judges about these themes. I myself had never heard of this. I was the rapporteur of this case of the high altitude Rupestrian grasslands. And they're not just grasslands. But I had never heard of these Rupestrian high altitude grasslands. And I have been working in this area for 40 years. So sometimes we judges don't make good decisions, or we don't even make a decision because we don't know. We don't have the proper scientific information, and thus the value of permanent education of judges.
Nós somos 15 mil no Brasil.
We're 15,000 judges in Brazil, but many judges would like to know, who would like to know more, but they might not have the time to dedicate themselves to these themes, because you can get a judge from the countryside of Brazil. They're all alone in a huge area, and they have to take care of all different matters. Environmental or cultural areas might come up a single time in 10 years that judge is in that area. And we have penal issues, family issues, land issues, all of that is their day-to-day work. So please forgive some Brazilian judges, because oftentimes it's not because they don't want, or because there's discrimination. They might just not know. With this, I'd like to end the session. Thank you, Justice Sebastian. I'm going to I want to share his beautiful pictures that he takes. We are all beneficiaries of his artistic point of view. Thank you so very much. Let's go to lunch. Oh, just one piece of information. We're going to have an official picture of the whole group in 2 different places, but this will be after lunch. So we're late. Let's say that at 2:15 p.m. Okay, in the afternoon, we'll start at 2:30. So at 2:10, I would like to ask the STJ staff to bring everyone to the main hall, where we will take the official picture, and everyone is more than welcome to come to this picture. Thank you very much.
Nós vamos. Não vamos entender, mas faz um favor.
This
Eu já
is
convido
by the entrance. I'd
os
like to already invite the
palestrantes
speakers
desta
of this
sessão
session
para tomar
to
assento
come over and
à
take this
mesa.
seat at the table.
Em primeiro lugar, o Eloy Terena, que é
So first of all, Lloyd Terena, who is Executive Secretary of the Ministry of Indigenous Peoples.
ministra
He's the Deputy Minister for Indigenous Affairs.
a ministra Sônia
Minister Sonia Guajajara, who comes to this court quite often. She's now on holidays in Europe.
The minister is on vacation in Europe. De todo modo, temos a
The
presença
way we have here the presence of Secretary or Deputy Minister Eloy Terena, and we will be visiting Terena land at the end of this month, the state of Mato Grosso do Sul. And Secretary Eloy Terena will accompany me. We also have Mauricio Igueta, who is the Director of Law and Public Policies at VAS. He will explain what VAS is. Mauricio is one of the best specialists, as well as Eloy Terena, in Indigenous Peoples Law and rights in our country. Kari Guajajara, I believe is already here. She's another specialist in Indigenous Peoples Law, and she's a legal advisor in the Center of Legal Advisory for Indigenous Peoples. And Dr. Makoshi, who is an indigenous lawyer as well as an excellent specialist. So we have really a fantastic table here of the creme de la creme of rights of indigenous people here. I'm a little bit of an intruder here, because they really are the specialists who know indigenous people's law and rights and depth. And I don't know if you've noticed, but all of them have at the very most half my age. So they're young lawyers, extremely promising lawyers. And us of the legal system must invest a lot, of the legal branch must invest a lot in the qualification of these lawyers and specialists in indigenous people's law and rights. I think this is one of our responsibilities. So without further ado, I will hand over to Secretary Eloy Terena, first of all. As I mentioned, he is the Deputy Minister of Indigenous Peoples. And Eloy, I'd request if you could talk a little bit about your ethnicity as well. And the other, Alcar and Ivo, if you could also talk a little bit about your backgrounds and ethnicity. What region of Brazil? Here we have foreign specialists that don't really know exactly our territory. With this, I hand over straight on to Eloy Terena. Good afternoon, everyone. I'd like to initially greet Justice Herman for this initiative. So we are here once more together and congratulate him for this collective construction. Because everything we've been doing here, everything we've done since yesterday and today has been active participation of Indigenous people, Indigenous ministry. Every speaker is counted here with our participation. So I would like to congratulate you and for what is taking place here in this auditorium and court, and at the same time greet our lawyer, my peers, lawyers, Guajajara, Makoshi, Mauricio,
de longa data já na trincheira da advocacia indígena.
Lawyers that have been fighting for indigenous cause for a very long time.
Já para o cerimonial já está aqui slide que eu preparei.
So I have a slide here that I've prepared. But before treating specifically or talking specifically about the presentation, I'm going to follow the Justice's recommendation here. So I am a lawyer. I'm from the Terena people. Terena lands are in the Mato Grosso do Sul state. We're from biome Pantanal. We're always like highlighting that we are part of a generation of young indigenous peoples that went through this path from the village to the university. So we are the first generation, second generation of indigenous had access to higher education through affirmative action. So the quotas were implemented in the state of Mato Grosso do Sul in 2005, and I'm from the very first class of those. I was already graduating, and I was able to get a scholarship through ProUni, and this is something I already highlighted together with the president's cabinet. So through several affirmative actions, I never imagined that 20 years later, leaving the village and going to study at a faculty of law, school of law school, I would now be executive secretary at the brand new ministry under indigenous management that is part of a project of really including indigenous peoples. We have now Minister Guajajara as our chief in command. We have a Wapishana, who's the first woman indigenous lawyer that is heading the FUNAI, and also Cesai, an indigenous lawyer, Tapegua. So I'm really happy to be here today in this dialogic situation. Just like to greet the indigenous leaderships that are present here, the team of the indigenous of the Ministry of Indigenous Peoples, and the rest of the academia here. Very happy to be here to talk about Indigenous Peoples Law. So Justice Herman, Terena people, traditionally in Brazilian anthropology, were much studied in the 1940s and 50s. Because it was thought that was a case of a limit of being an indigenous person and not in Brazil at the time. Those who were dominating social sciences were those geared towards assimilation, integration. And there was a race in Mato Grosso do Sul because they thought that in the Terena people this anthropological phenomenon was taking place. And thankfully, anthropology studies abandoned this position. And from there onwards, we started working with categories of inter-ethnic friction. Because although we had a public with very intense interaction with non-indigenous people, we were peoples that spoke Portuguese, used clothes, used local coin, but they were not being accultured. They were there in an inter-ethnic interaction with local society. And so anthropology changed its way of thinking, but law law still, it hasn't, and unfortunately the law is quite behind in its dialogue and the way they see that. And we must bring, therefore, these constitutional paradigms and treatment of the relationship that one should have with the indigenous people of Brazil.
Todos os atos normativos baixados nessa época
tem essa visão, né,
And
integracionista.
all these have this vision, integrationist, negationist, very influenced by positivism. And from an international movement, managed to change. The Convention 107 has this integrationist vision. Now we have the 169 from 89.
Esse movimento é um movimento que influenciou aqui os nossos, a nossa
And this influenced our constituents, those who create our constitution and the indigenous movement itself.
povo terena, o meu povo, né, durante muito tempo ele foi estudado sob essa perspectiva.
And so for quite some time, my people studied on this perspective. And now we are proving that that is not a fact. We do have a cultural tradition.
Aproximadamente 30.000 indígenas, desses 60%, 70% ainda
And we have a good, vast percentage of our people that still speak our own language. And despite having this intense interaction with the representative structures of the Brazilian state, we have been maintaining our culture quite strongly.
Para falar pouco do povo terena. Agora entrando, né, especificamente aqui no tema da proteção territorial indígena e construção.
Now, enter a little bit about the subject here.
Tá aqui, né? Legal. Eu gostaria de frisar aqui na minha fala uma experiência que nós estamos tendo.
So I'd like to highlight an experience that we're currently having within the Ministry of Indigenous Peoples, and to speak of a policy that we are simultaneously building and executing, which is that of the functioning of the interministerial committee for the removal of illegal entities within our territories. And so with first participation of indigenous people in the court before last year, we indigenous peoples in our own name and through our own lawyers managed to reach to the jurisdiction there through law. And I think this is the first time that indigenous people recognize their right of being there. This is the first point. The second point is that the Supreme Court also recognized the means by which the indigenous people represent themselves through APIBD, Brazilian Indigenous Peoples Articulation Coordination, is an indigenous organization de facto and truly, but it's not within the traditional Brazilian state means of being recognized. They're not a legal entity and such, but that is how the indigenous peoples want to be recognized. So the Supreme has advanced a lot in allowing and recognizing the legitimacy of indigenous peoples to act in such a way, and at the same time recognize legitimately the way by which indigenous people choose to make themselves be represented. And I think there's a great legacy that marked the legal framework in Brazil. And we are very proud of being part of this work that was built in a collective manner. And one of the decisions of the Supreme Court was to make the removal at the time from 7 indigenous territories that had a high rate of invasions that were even being stimulated by the government at the time. That is the Yanomami indigenous lands, Caripuna, Munduruku,
todas localizadas, né, na Amazônia
all located in the Brazilian Amazon, Yanomami lands, Caripuna, Munduruku, Araribóia, Caiapó, and Urueu, Auau.
E mesmo o Supremo determinando a desintrusão,
and so this decision of removal of foreign entities, so it's basically illegal mining, mining for gold usually, but many other lands we found also loggers and illegal cattle raisers, herders. But mostly there was illegal gold mining. And despite the Supreme Court determining that, and even allowing the opening of extraordinary decision about opening credit for that, it still wasn't done. So when we reached and have this indigenous management by indigenous people in the ministry in little more than 20 days, as the secretary already received the official from the Justice Ministry and determining that that would be done. So we left a position from being those demanding the action. Minister Sonia was coordinated by PB, and then suddenly she became the minister, and I was the deputy minister, the executive secretary. And we then became the ones who had to the responsibility of making it happen. So this is the experience that we proposed, and President Lula signed within the 100 years of his mandate. The decree instituted an interministerial committee of removal of foreign people from indigenous lands. This is determined by 20 ministries and federal organizations and ministries because we determined it to do this removal in an integral way. Yes, we do need an interagency action, a structural and global responsibility and agency, and a role undertaken by the state and not just by a government. So I think this is an aspect that we must keep in mind here, that the protection of indigenous territories must have this state engagement from the Constitution itself. So this interministerial committee of the liberation of the indigenous lands, here we had the decrees, and here throughout it, we were perfecting the function of the committee, which was first of its kind, and we saw some modifications that needed to be done. So, illegal activities identified: illegal mining, illegal extraction of wood, cattle raising by non-indigenous people, illegal hunting and fishing, occupation, irregular occupation of non-indigenous territory, and so on. Here we have some results that we've measured. The number of people benefited, 98% of active mining in Yanomami lands, over 745 million in losses due to illicit actions that now have been stopped. So this is all numbers that we highlight. Here I'm talking a little bit about the land, this indigenous land. Alto Rio Guamá was one of the first ones that we undertook when we started the Yanomami removal. So we had a legal decision by the federal justice here, and we included it in our work plan. This was one of the first lands that we handed over. Then indigenous lands, Apiterewa. The Supreme Court ended up including it also in the decree under 79. It wasn't initially, but because of the high rate of invasion, the Supreme Court recognized that the situation was important, and so included them. Located in the state of Pará, the Abacajá area, also in the state of Pará, the Yanomami lands. We only actually managed to advance in the operations after installing a government station house there in Boa Vista and increasing the Brazilian state's presence within the territory. And I don't mean just with the civil servant presence. We had to break a paradigm also of military action in indigenous lands. We know that when we look at the evolution of indigenous policies, military presence was always something that was quite controversial. But we did do this work of doing capacity building with the military forces so that they could act for the protection of indigenous people and indigenous people's lands. That is federal good as well. So to understand this, the multi and this plural nature of indigenous lands. So 477 million reais of illegal mining that was avoided. The roads of until June 25 is the latest update we have. The area in yellow. Look at how much we've reduced since March 2024 to July 2025, June 2025. It's quite a big reduction. Then we have the Caripuna indigenous lands, that is in the state of Rondônia. We went there to deliver the indigenous lands. So once we remove all the intruders, we then hand the lands back. We had the Munduruku indigenous territory. Here we have the formal handover back to the indigenous people. And the Araribóia indigenous land, that is the lands of Minister Sônia Guajajara as well. And now we've just ended the action at the Kayapó lands. Two things we must define here. People sometimes have quite a few doubts. These removal of intruders has nothing to do with the 1775 decree removal. We know that a decree that regulates the land demarcation of indigenous peoples. Soon after them being allowed, they have a certain amount of days, and if the invaders remain there, then we can open the second step, which is this intruder removal. This intruder removal of the decree is an administrative removal. The FNI, after the notification, will then notify the people who are still there, the demarcated land, and will eventually then use legal means to remove these people. So now, in this intruder removal, this is actually real extrusion. Because aside from the entire federal government planning team, we also include the security forces. And then they truly do go to undertake the extrusion, the removal of these people that are illegally occupying indigenous lands. The board say this because now we're signing a series of decrees homologuing these lands. And people are saying, wow, now the army is going to come and remove us from here. So the administrative removal is through a different way, following other paths. This one here, however, that we do within the removal committee, intruder removal committee, this is really an extrusion. So these are lands that have been homologued for quite a long time. There is no type of discussion in regards to its administrative regulations and legality. So there's an order from Supreme Court so that the Brazilian state promotes the indigenous communities' handover of those lands. So I'd like to announce that the Ministry of the Indigenous People opened what we call a program of consolidation of the indigenous ownership, which is to actually, there's no point taking out those illegal people and then not give the conditions so that the indigenous communities can then
have an autonomous capacity to manage the territory and also have the presence of the Brazilian state. Otherwise, criminality will come back and it will be a waste of public resources, because expelling intruders is not cheap. It's very expensive. It costs a lot. So this program of consolidation of indigenous tenure of the land is something that we instituted, and now we are in the phase of structuring this program, which will count not only with the Ministry of Indigenous People, of course, with FUNAI, which is our executive branch of our indigenous policy. This program will start with the 7 indigenous lands. In Yanomami, there's already a series of actions of disintrusions, but we have Duruku, Araribóia, Caripuna, Uruewawau. Well, in these 15 minutes, I sought to give a general context, a real general overview of the work that we're carrying out in the Ministry of Indigenous People by bringing this defense that the protection of indigenous lands is a constitutional mission of the government, a duty of the Brazilian state. And the experience of indigenous people ahead of the Ministry of Indigenous People in Afanai, we've sought to pursue as a priority the protection of these indigenous territories and of other territories which are a part of our work group, work plan. Thank you very much, Justice.
Ao secretário Eloy Terena.
I'd like to thank Secretary Eloy Terena, and as he mentioned very well, protecting indigenous territories is the duty of the state and the duty of judges as well.
Passo então a palavra.
I'd now like to give the floor.
Vamos ouvir a Kari Guajajara.
Let us listen to Kari Guajajara. I'm going to change the order. Kari, if you can, explain a little bit about your people and your...
A gente tem 270 línguas e nem o
We have 270 languages, not even Tupi is accessible to people. We recognize a greeting. This is... I was speaking Ninhate from Guajajara, the people. I'm from the Arariboia land in the southern Maranhão. I am an indigenous lawyer. I'm part of this process of this generation of lawyers, which is a result of a historic claim of our leaders and of the indigenous organizations themselves about the need to have indigenous professionals that could be at the service of the collective struggle, never excluding non-indigenous partners, but always thinking about strengthening indigenous people, starting with our own professionals that are able to have this capacity and this notion of the reality of the land, of the territory. So that's the territory I come from. I come from the Guajajara people from the Aradi. Boy, I'm a neighbor of the minister, Sonia Guajajara. Our houses are right by each other. We have around 400 years of contact, and we've never lost our language. Unfortunately, my territory is known as one of the most violent indigenous lands in terms of murder or violence against indigenous leaders. For my territory, we had the murder of Paulo Paulino Guajajara. It was in my territory that Zico Guajajara was murdered. Other indigenous leaders that acted for the defense, and so many others, like Tome Guajajara and many others, were murdered. And up until today, Tome Guajajara was murdered in 2007. And we still do not have an effective sentencing of any of those responsible for these murders. So it's a territory that, despite this long history of resistance, it's a territory that's never lost its original language, a territory that keeps its traditions, a territory that also provides to the rest of Brazil a huge quality of indigenous leaders. So I'm going to pay homage to my territory. The minister Sonia Guajajara comes from our land, and it's a land that has this complex issue that we still haven't been able to solve with the solutions that have been given up to this point in time. We're in this process of extruding the invaders from our territory. Of course, there's a process of consolidation of our tenure of the land. There's a lot of work in the executive and the protection of the people and of the land itself, but it is still a territory marked by a lot of violence, marked by extreme violence, especially in relation to our indigenous leaders. So this is my land. It's a double characteristic. It's both a territory of resistance, but also a territory marked by bloodshed in the defense of our land, of our lives, and in defense especially of our isolated partners, because we have a territory that we share. We have the Guajá people. They live in isolation. They do not have contact with national society. So it's a shared territory that's extremely violent, and that brings to us, the Guajajara, the responsibility of also understanding yourselves in the scenario as the protectors, not only of our own lives, but also of the lives of those who have chosen to remain isolated within our land. So I'm very proud to say that I'm from Arariboia. I'm very proud to say that I'm Guajajara, that I speak my mother tongue, that I practice our traditional rights, because I believe that indigenous law comes from with this different perspective, this capacity of maintaining this bond with our leaders. Indigenous law is not a process in which we separate from the overall strength of the indigenous movement. Rather, we are a part of the collective struggle with them and not a separate process. It was a claim and a demand from our leaders, and now we act in service of the collective struggle. And to do this, we must keep one foot inside our lands. We must keep in touch and in dialogue with our leaders. We need to keep at all points in time this alignment. So indigenous lawyers are directly connected to the collective struggle. We're not isolated from the collective struggle. So, Mr. Justice, I went a little bit ahead, but I'd like to take a step back to thank you for the invitation, to thank you for the opportunity to be here. It's an honor to be a part of this panel. Aloy is a very important reference for indigenous law. You, Mr. Justice, are a reference in the defense of indigenous people, and I'm the only woman in this panel, which makes it special for me as well, of being a young woman. Even though I look a little bit tired because of all the struggle, I am still a young woman. Having presented my people, my land, and so they had to know a little bit of who I am, I think maybe my role here is to take a step back from this concrete reality that Eloy has mentioned, but also to provoke you all. I think that we need to understand that we're speaking in a country that has a history of denial of the right to land to the different peoples, including the indigenous people. The whole basis of the construction of this country was delineated and based on the taking over of territory. The objective of the process of colonization up until today, when we have a variety of different initiatives and instances with the goal of weakening the rights of indigenous people. All of this is focused in a very specific objective. The non-indigenous people who attack us especially, which is this taking over of indigenous lands. So we have a history that is marked by this occupation of indigenous territories that moves is connected to these different policies that came from non-indigenous assimilationist, integrationist policies, eliminationist policies, and a very specific conquest, which would be taking over of our territories. And this left a history that is marked by a lot of indigenous bloodshed and a history that was marked by indigenous people who were ripped from their territories. And today, they're denied that there was a relative of indigenous relative who was claiming for their territories, and they said, "Oh, why did the indigenous people come in and now they want land?" No, this was our land, and we were kicked out at some point in time, and there's a process of claiming back these territories which were traditionally ours. So, talking about the right to land in Brazil, in this country marked by the invasion of indigenous territories, among others, is also talking about human rights. We have in Latin America, starting the second half of the 20th century, large force of indigenous peoples organizing together with supporters and partners, and this is reflected in more accessible constitutions for the different countries in Latin America. So we also had a huge impact in this indigenous collective actions from Latin America in international norms and treaties. So the indigenous movement is more and more organized and brings this influence. I think we're there in a point in time in Latin America where we no longer have the option of not recognizing collective rights for indigenous people. The process of struggle was such, the strength was such, that society could no longer deny these collective rights. I'm speaking formally, okay? We'll reach the practical side of things very soon. But so formally denying the rights of indigenous people, and it's based on this scenario that we see this more collective perspective arise regarding rights, this wider reaching perspective for indigenous rights. And it is in this scenario that we start to think of how do we structure this throughout Brazilian history. This guarantee to the right to land and the rights of indigenous people. In his master's degree, the Eloy has dissertation has a very interesting line because everyone really looks at the 1988 Constitution and the main point of indigenous people's rights happened at that point. Like if we had no other moments that were marked by laws and other normative instruments that referred to the rights of indigenous people, including as regards our territorial rights. So Eloy brings this timeline. I really recommend that you read his master's dissertation. And in this perspective, we can understand a little bit of how this reality is being structured, including the demarcation of our territories. If we think about for Marechal Rondon, what were the guidelines for Marechal Rondon and SPI to demarcate indigenous territories? There were reports that are really dependent on their own awareness and consciousness rather than a normative framework or administrative framework would guide them during this demarcation process. So yes, we have a long history of issues in the Brazilian legislation, even before the 88 Constitution, that has to do with the right to land, with territorial rights. But we accomplished this with more strength and more boldness in the 1988 Constitution, which in the first part, and I think that Article 231 is spectacular, as any other indigenous person does as well. In the first part, we have this perspective of the recognition of the right to be. We accomplish the formal recognition of the right to be and to remain being. We no longer had this transitory condition, Carigo Jajara, since I have an iPhone, I'm no longer considered a non-indigenous person. In the past, people would be able to accuse me of that. So in law, we need to interpret this the right to be as in the right to live, the right to be indigenous, to remain indigenous. It needs to be in the same category as fundamental rights like the right to life. Being indigenous and being able to remain indigenous, that means having the right to life. That is the first part of among too many other reflections that we can have because we only have 15 minutes here. And the second part has to do with the other fundamental right of indigenous people, without which we cannot exercise our right to be and to continue being, which is the right to land, the right to territory. So we must understand the struggle of indigenous people in the Constitution itself with these two aspects. Article 231 necessarily brings us to reflect on these two aspects, the right to be, the right to remain being indigenous without taking away this transitory nature. And as for the right of being, that means that I need to guarantee my right to territory. It's almost like it was intrinsic to our being, to our existence. And so we need to bring all these interpretations, and I think that's a little bit of the role of indigenous law, which is bring these points to the space that you're occupying as well. So reading or rereading and using good faith to analyze all these norms that have to do with our rights, and also approximating this to the reality of indigenous people. You can't practice law or carry out justice without us really understanding what the indigenous people say. A lot of you might have already heard this a variety of times. The indigenous repeat all the time that the right to land is important. But could it be that our justice system has already absorbed how this element is really structural to the condition of existence of indigenous people in Brazil? I think that's why we're always being attacked. We're always under attack. And so I don't want to use all my time because if I go into other reflections, I'll run out of time. But I saw in the morning, I heard something that I agreed with. We advanced a lot in regards to our legislation. I think we were able to have a huge advancement in regards to all that. And I also heard that we go through a process of the ineffectiveness of these rights, which is, in a certain way, puts us in a situation like if we didn't have those rights up to a certain extent. Then we ask ourselves, why? What are the aspects that make this happen? Why can't we advance in the effectivation of indigenous rights? From what I said, from the interest in the resources present in indigenous lands. And to wrap up, I'd like to share a reflection with you. All the demarcation process for indigenous lands is concentrated where? Well, you heard that in the morning. Someone answered that. The demarcation process for indigenous land. Just so you speak a little bit and wake up from lunch. The demarcation process is concentrated in which branch of government? Which is necessarily a political branch. Currently, we're very lucky to have Eloy Terena, Sonegoja Jara, and Joanna Wapichana occupying these spaces, but we need to understand that this is a very political process as well. And it's a political process in which we depend on political will up to a certain extent, and this directly impacts the interests of the demarcation of our territories. We've been talking a lot to our leaders in our walks, especially in the Amazon, which is where I act the most, that we cannot believe that this right, the rights that we have are guaranteed rights and permanent rights. No, our rights are a continuous process of struggle and resistance. And I've run out of time, but we're once again in this scenario with a variety. Well, maybe I would translate it to attacks. So there were various attacks instrumentalized in different ways as a basis for the rights of indigenous people. We go through, especially regarding territory. So we're reconfiguring these weapons, but the end is always the same, the invasion of indigenous territories. Thank you. Now, I would listen to the whole afternoon and a good part of the night hearing Kari speak. So much wisdom, so much knowledge, just like Eloy Terena. Now, let me get back to that order. Now let's listen to Mari Sueta, which, like I mentioned, is another important specialist in the rights of indigenous people. Like me, he's not an indigenous person up until, well, at least I don't think so. In this life, he isn't indigenous. That applies to me as well. Anyway, go ahead, Mauricio, you have the floor.
Good afternoon, everyone. I'd like to start with a very special thanks to Chief Justice Herman Benjamin. He really, he's always been my greatest reference, and I try to follow into his footsteps very humbly, of course, acting professional life in cases without forgetting about academic life, so that we can always be updated with the best right and law. And I remember one of the first recommendation of works you sent me that you called in 93, environmental damage and prevention. From many works that he's gifted us, he's a reference for the students, right? Thank you very much for the invitation. I'm very honored, and even more so for being next to colleagues. They're very competent, great friends, partners. Eloy and I have been defending at the National High Court many times. We've defended cases together. So it's great to work on indigenous people's laws and to learn with our indigenous peoples. And I would like to start remembering something from the past. It was said in the morning, in all of the world, ever since the colonization process, indigenous populations have gone down drastically. And since the 80s, there was certain anthropologic consensus where indigenous people would be going towards extinction, where the population is diminishing. And this justified from a legal point of view. If the indigenous are temporary, then their rights should be, or would be, temporary as well. Until the even negationist theory, where they would be integrated into the national union or social or society, as a logic between the Constitution of '88. So with the indigenous peoples decreasing, their rights would also be temporary. So then we had a couple, two anthropologists, that decided to challenge themselves, Chief Justice, and decided to try and map the indigenous in Brazil. He created the first social network, the anthropologic network. And as its mission, each of his colleagues, anthropologists, to catalog all the indigenous communities year after year, verifying a series of data, including populational ones, and they proved that in truth, the anthropological consensus that was supported by the big anthropologists and sociologists of the region were actually wrong. The indigenous people were actually growing and increasing in number. And this was one of the fundamental bases of the process of the creation of our Constitution. For there to have changed from a legal comprehension of indigenous peoples, that if the indigenous people won't be extinct, then their rights have to be permanent. And we see this reflected in our federal constitution. The process of the creation constitution is very interesting. In all the chapters in the environment, where Justice Hammond had a great big role, but also indigenous peoples chapter, in Article 231 and 232 of the Constitution. The indigenous peoples at that time were losing their main demands and requests at the creation of the Constitution. And then Ailton Krenak, who is known here by all, with a series of big leaders, that some were here, of Yanomami, and great leaderships that were meeting for the first time in Brasilia. They'd never come to the capital, and were meeting for a great fight in regards of the constitutional indigenous rights, and managed to collect sufficient signs for popular amendment, something that at that time was unthinkable, especially considering the rights of a minority. And so this is what gave the birth to these two constitutional articles. Basically, what we had with the Constitution of '88, first thing was the breaking the assimilationist logic, and therefore the respect of the indigenous people to exist or continue existing. So the respect of social organization, language, traditions, this is what this position, this article means. And then the territorial question, the fundamental right to the land. This fundamental right was put into the Constitution as an originary right, a right that precedes the existence of the state itself. This was a decision of the Supreme Federal Court, guaranteeing exclusive use of indigenous territory. But look at the term in the Brazilian Constitution of the permanent ownership. So the rights were no longer provisional, but permanent in the Constitution itself, with dispositions that do not allow forced removal and other very important guarantees. And it was already said here, and I'd like to, that it's really important to emphasize this in one of the last decisions of the group of decisions selected for this event. The last decision that Justice Hammond chose for us is one that says this. To be recognized, indigenous territory is not dependent of the administrative act of demarcation. The Demarcation Act is a merely declarational act of a pre-existing right, of a right that already exists. It is very important to understand that, and this decision of the STJ is reaffirmed by the Supreme Court as well. This is something completely fundamental because a series of policies depend on the state recognition of territories. I talked a little bit about the past, and now in the next half I'd like to talk about the present, of the challenges that concern us nowadays, Chief Justice, in regards to indigenous rights here in Brazil. The first subject that we should talk about, perhaps the most recent one, is about environmental licensing. Environmental licensing, I would say, is the main instrument of environmental policy. An instrument guarantees the prevention of damages and environmental impact and social one as well, and safety of people's lives, their health, and it's an instrument that's very consolidated. A big evolution of this instrument of over 40 years that has issues, has gone through discussion in National Congress recently. And we obtained 63 presidential vetoes to this new legislation, especially in regards to the indigenous one. I'd like to highlight some dispositions that were vetted and are being discussed again in National Congress. The first one is the one that's saying that environmental licensing of an enterprise, one could only consider for impact evaluation and measures of environmental conditions the homologued indigenous lands, the approved ones, and that excludes 30% of indigenous territories that still haven't had the approval finalized, their homologation. And so I think this would be a double violation of those indigenous who don't have the guaranteed territory. First of all, the state submission after 37 years to still not having an effectively demarcated territory, the process concluded. And secondly, because of the state submission, those peoples would not even be considered for environmental licensing questions. This obviously is against the STJ's and the Supreme Court's decision many times, and also the exclusion of the indirect impacts of enterprises. We understood with Mr. Luis Henrique Sanches, one of the biggest specialists of Brazil in environmental licensing, that the called direct and indirect impacts are simply an academic classification, don't really define the degree of importance of an impact. What is a direct impact? Direct impact is when you build, for example, a barrage for a hydroelectric. So the direct impact is for the 400 grams for fish. The indirect impact is that community that is next to the hydroelectric and that feeds off of these fish, and they will no longer have fish for their food security. This project tried to exclude the indirect impacts, but the indirect impacts are usually associated social impacts. I think it's an important debate that the society be able to participate in the legislative process in the Congress, because after the veto, the subject is going back as a bill. And within this concern, we have the concern of the bills of law, such as Project 6050 of 2023 and Bill of Law 1331 of 2022. They deal on the economic exploitation within indigenous lands, be it agro, fishing, or mining, or petrol. These are all projects that bring quite a big concern along with them. Firstly, because of the weakening of environmental licensing that seems to bring with it. Secondly, that Convention 69 from the ILO that determines the free informed previous information of indigenous people of administrative and legislative decisions that might affect them. Article 6. Well, this doesn't seem to be respected by the legislative. We see an effort of the executive trying to make this happen, but not on the legislative, causing a serious problems. And the lack of participation of indigenous people in these processes to discuss their rights and lives is in and of itself something that constitutes even a formal violation within what one would expect within a legislative process. And we also have, Chief Justice, a long discussion on the temporal thesis, timeline thesis. So I'm not going to talk too much about that, but what I wanted to say here rather quickly, part of the Constitutional National Assembly of 87-88. Opening quotes. The protection of the rights of indigenous population was broadly done in recognition of their pluri-ethnic character of Brazilian society and in the treatment of the two main problems that affect such populations. Then it brings the question of lands, territories, and legal protection of indigenous people. As for lands, it recognizes for the Indians, at the time it said Indians, it means life itself, and stipulate that they have right to its permanent ownership. The term permanent, as I mentioned previously. And after the Supreme Court and also the STJ and several decisions showed in 97, there was no novelty for Brazilian right and law, that the question of the land represents a fundamental rights and prerogatives, conditional prerogatives of indigenous peoples. Without the possibility of having access to the lands in 97, it exposes the indigenous peoples to cultural disintegration, the loss of their ethnic entity, and dissolution of their historical links, and erosion of their very perception as people. So these quotes bring a little bit of relevance in the indigenous territories in this moment when this debate at the National Congress was taking place, or future of these territories. Often in other instances, the Supreme Court itself debate of constitutionality or no, respecting the law 14701 of 2023, the temporal thesis. We must then think if these indigenous people's rights and law will actually be permanent or not. And reading a passage that the Professor Law itself has brought up, I use it sometimes in my classes, lessons. He says indigenous lands currently, with the current concept, the relevance it's given nowadays, especially in regards to climate change, it starts having a much bigger relevance beyond than what would be enough, which is the guarantee of all the rights of indigenous people, but also the guarantee of survival of planet Earth. APIB and other indigenous organizations have that campaign, The Answer is Us, which talks about the relevance of indigenous lands as areas of climate security. Should we not have these areas anymore, we would be putting in jeopardy humanity's future. I would like to conclude highlighting that there is and shouldn't be an incompatibility between development of economic activities, for example, agrofishery, and the existence of indigenous lands. So look, we have recent studies of well-known scientists that 80% of the necessary rains for Brazilian agriculture are influenced by indigenous lands. So in truth and reality, what we always say here is the coexistence of these constitutional values as the Constitution orders. Especially now when we're so close to the tipping point, the point of no return for the Amazon, where the level of deforestation it attains may cause it to lose its ecological balance, generating disastrous consequences for Brazil and the entire planet. So in that sense, I'd like to thank once more the Chief Justice for this really honoring invitation, and thank you. Thank you very much, Mauricio. The very last point of your intervention in regards to relationship between the indigenous lands and water production is something fundamental. Because what we're saying is that indigenous lands are giant water boxes, water reservoirs, and that help directly the Brazilian agriculture. Brazil is a huge exporter of grains, and for agricultural production, we have as inputs the land in first place, and in second place, water. Because without water, there is no agriculture. There's plenty of land in the Sahara Desert, but there is no water. And this input is fundamental for the vitality of Brazilian agribusiness. We are the biggest exporter of grains in the world. The first or second in soy, the first or second in corn, and so on, in all the other items where we are within, not even referring to meat, not even referring to cattle and such. But this point is very important to always highlight the ecosystem services that are produced in indigenous lands and exported for free of charge, not just to Brazilians, but to the entire world as a whole. I'd like now to hand over to Ivo Makushi, who is another young lawyer and specialized in indigenous people's rights, and that has been participating in the events that the STJ organizes in regards to this, but also in the capacity building courses of the National Magistrate School, of which I've already been a director once, and that also forms and teaches the state and federal judges. I would like to thank the presence of Ivo Makushi, who now has the floor.
Thank you, Mr. Justice.
Makuji, Roraima Mabotego Manzen, sendo Pabu advogado P, Sr. P, 19 de agosto lá estar o STJ, Superior Tribunal de Justiça da Erebanzá, e Esrugom Bussermai, Murobai, Comantogong, Tadzegong, Corimantogong, Muradega Bussermai, Erebanzá, Tauia, Muricombu, Yomblama. Boa tarde, ministro.
Good afternoon, Minister. I'd like to greet the panel. The indigenous authorities are present in the audience as well. I was introducing myself in my Makushi language because in every event that I go, some people ask me, why don't I use a headdress? But I said, I use my headdress when I want. But I carry my language wherever I go. That connects me to my land, to my territory. My name is Ivo Makushi. I was born and raised by the Mao River, next to our sacred lake of Aracana. I come from the state of Roraima, a land of resistance of the Makushi, Wapishana, Yanomami, Apuana, and many other ethnicities. We're divided into 3 countries, Venezuela, Guyana, and Brazil. They didn't ask us for permission, but they cut our backyards, our gardens with artificial borders and divided our people into different countries. Being here today in the National High Court and reinforcing this to anyone watching us and for those who can't see us but to listen to us, I am a lawyer. My hair's a little long. I use glasses. I'm wearing my suit and my tie. I'm using my tie in a sort of earthy tone that I'm using on purpose, the symbolism. I'm talking to different authorities here the home of justice and the court of citizenship. My appearance is of someone a little over 30 years old, and this is a great opportunity to be here. For those of us who are watching us on YouTube and other social media, we were here on August 19th, 2025, speaking as an Indigenous lawyer. So for us, Mr. Justice, this is a wonderful event, a very important event because it brings Indigenous lawyers, and we've always asked to be heard because we as professionals, lawyers, Indigenous lawyers, we have a different point of view regarding justice, a traditional point of view. The legal world needs to have a plural interpretation, and our mission as Indigenous lawyers is to carry out a visceral analysis, as I often say, opening up justice laws, looking at the viscerae of the justice system and laws, because many of these laws were not created by us, but of people who oftentimes don't even know that we exist as Indigenous people. I have some things to share so that we can reflect on this event and on the purpose that Justice Herman gave us. And I'd like to reinforce something quite important for those of you who organized and invited Indigenous lawyers here. Something that I felt in the people and in the justice when I was talking to His Excellency is the sincerity of receiving Indigenous people in this space, because it's not everywhere, it's not in every space that you have this treatment as Indigenous people, that you receive this sincerity, that you receive respect and sheltering. And I'd like to congratulate the staff of the National High Court. From the moment we left our villages, oftentimes you have to use boats, then airplanes. So I'd like to congratulate all of you and like to highlight that. Yesterday, I heard the speech of our great Pope, the shaman Davi Copenau, our counselor, and what really marked me is that we as Indigenous people can't speak the language of market goods, of mining. Whoever has read Davi's book, he reinforces that, and it's up to us, Indigenous lawyers, to reflect on what he says. Oftentimes, I ask, "What do you mean?" And sometimes he says something else, but with intentionally to make me think more as an Indigenous lawyer. It's up to us, Indigenous lawyers, to have another interpretation of the laws based on our territories, because land cannot be negotiated. Our lives, our people, our language, our way of thinking of the world and of seeing the other cannot be currency for exchange, and our dignity cannot be negotiated. Our future cannot be negotiated. This is why we deal with these words as something very sacred. Our future depends on it, because we don't know what will happen in the future. Davi Copenau and Aito Krenak as well teach us to step slowly on the earth, because the earth has a heart, has feelings. And what is the role of law then, of lawyers? Is interpreting the law according to the understanding of our shamans, of our pajés. We Makoshi also have this, not seeing nature not just an environment to be appropriated, but as a home. Not only the home of people, of human beings, but of other living beings that inhabit the waters, the forests, the mountains, that are part of our spiritual world. So this is what we contribute as Indigenous lawyers, because laws are very cold, but we bring these cultures, these new reflections, as a way to interpret the world based on this teaching, on this ordering of the legal system of the state. So we can do that so that we don't fall into this traditional interpretation of laws. This is why for us Indigenous lawyers, it's inconceivable and unimaginable to say can't go through our heads the death of a stream, of a river, the destruction of a home. That's not a part of our lives, or way of living, and a way of looking at the world. That's why we like to share all these reflections, because it's urgent to reinvent our way of living. You should listen to the indigenous people who are here, living in their lands for thousands of years, and we never destroyed the land. That's why for us lawyers, land isn't an economic asset, isn't an object to be exchanged or appropriated, or property, as you put it. It's a collective good. We cannot appropriate it for ourselves and give a value to put brands, symbols of profit, of money into our land. Oftentimes we want to add value to that. No, land is living. It's a living being in which we live. We have a reciprocal relationship with it, in which we respect the land, respect the place we are, in which we request what we want. Even when we go to wash in a river or lake, we ask for permission because of the respect that we have with our home, with our environment. Not as merchandise, not as a natural resource to be exploited. That's why in indigenous land, up to today, and the UN has already said this, last year, once again, they have this data. That's why indigenous land, even though we are around 5% of the world population, even then, the World Bank and other institutions, they say that we are in poverty oftentimes, as part of the 15% of the world that's in extreme poverty. But we are guardians of the biodiversity of nature. That doesn't just help indigenous people, it assists all of humanity. And even then, we can't have access to our rights, to funding, and to other ways to improve our livelihoods. This is also what we're dealing with, globally speaking. That's why every discussion in relation to indigenous people's rights must also bring this kind of information, because this is a global struggle for us, indigenous people. That's why we fight against all sorts of threats, like the temporal thesis, like the laws that are passed in National Congress without consulting us. I'd also like to reinforce that still there isn't a culture in the legal branch or in the judiciary branch as see land as a fundamental right. Why? Because the right to land also guarantees our housing, our food, our health, everything that we need. So we are held hostage, oftentimes, of the political will of the state and of those who are occupying government. It should be a state policy to demarcate indigenous land that is obliged by the Constitution. But even then, it still depends on the political will of a variety of authorities. And this is why we indigenous lawyers continue to fight to guarantee that we, in fact, have our fundamental rights preserved and guaranteed. In this scenario of legal struggles, indigenous lawyers are fundamental. Why? Because we speak a different language with our leaders. We're able to interpret the language of our territories. What do our leaders mean when they're saying this or that? And we must also make the paper speak. We must make the Constitution be executed. I can't understand why non-indigenous people want to take our rights from the Constitution. Isn't that already set in paper? Didn't we already fight for this in '88? Why do they want to take it away? Why can't they just follow the law? They create this wonderful thing, democracy, a state, a nation, but they still don't follow the law. This is a constant questioning for us indigenous lawyers in relation to our action. And we must appropriate ourselves from these informations. And defending democracy is also defending the existence of indigenous people. Democracy is important for indigenous people. We live, our way of living, the way we participate, the way we construct our public policies, because democracy allows that. So it's important to say that as well. And unlike Dr. Eloy mentioned, we've had a variety of advances. I had the honor of advancing aside other important lawyers like Cari, Eloy, Joenia Wapichana, the first indigenous woman lawyer in Brazil, Paulo Pancadaru, the first indigenous lawyer in Brazil, and we keep on having this commitment to our are collective, and the same holds true for indigenous law. We are completely committed to collective social environmental justice. It's important to reinforce that the defense of life in its plurality is our goal, its complexity of what society can be. We don't need to just fulfill the execution of the laws, but actually interpret what these laws means. The ethics, indigenous ethics, our commitment, our indigenous thinking is different. Our indigenous worldviews are different. Bringing other types of thinking. This is all different, and oftentimes it can't fit into the laws. Oftentimes we try to put this into words, into the language of the non-indigenous people. This is why the interpretation of laws based on our indigenous realities is different, and it's also up to us to bring this interpretation as indigenous lawyers. Our important contributions to legal paradigms that can respect the ancestral knowledge of our leaders and of our peoples, of indigenous territories. And the indigenous territories are diverse, and within law as well. We want the non-indigenous people to understand the rights of nature. Sometimes they can start to feel this right, because oftentimes we need to speak in a language that non-indigenous people can understand. That's why the National High Court is to be congratulated, because I feel that there's something going on that we need to take advantage of. And the leaders often say, a boat is going by the river. We need to get on the boat and row alongside those. That's why I like to congratulate Justice Herman, because STJ is also demarcating time. They are making history in bringing indigenous lawyers to the fore. And we understand that the court is, in fact, the court of citizenship, as it self-titles itself, and needs to hear indigenous people. You can't have justice without listening to indigenous people, and indigenous lawyers also have that role. You must understand that justice is plural. That is the goal of the court of citizenship. It needs to listen, and it must also go to territories. And we know that Justice Herman has been to a few territories. And to conclude my speech, which is a short speech but with a purpose, I'd like to highlight one point, which is this alliance of the STJ court, that it be a practical, sincere, and lasting alliance, that other justices that will come to the court continue this work of this commitment to the indigenous cause. Everything that was shared within this event can't just stay here in this auditorium. Why? We need to reflect on what is our direct contribution based on this seminar. Tomorrow, what are you going to do for indigenous people? Tomorrow, today, in relation to indigenous people? Because the survival and future of our people, the defense and the promotion of indigenous rights, is not just a challenge of a single institution. It's not just a local challenge. Rather, it's a global, international issue. Countries also need to hear the voice of the indigenous people. When leaving here, please remember, every sentencing, every decision, every study, every political decision has a contribution which may support indigenous life. Whatever you do from now on might put into risk the lives of indigenous people. We must reflect on that. Indigenous people often say, we don't need solidarity, occasional solidarity. We need permanent alliances, true alliances, sincere alliances, as I've mentioned. And we leave here not only informed, but transformed, with the courage of doing something different, of heading towards action, of acting, of making the Constitution real solid, and following the UN resolutions, the Inter-American Human Rights Court's decisions. So we must review our civilizational pact with the indigenous people and guarantee their indigenous lands and lives, because the world needs this. We can't go towards a geopolitical discussion that puts indigenous lands as merchandise for so-called progress in so-called sustainable development. Thank you very much. That's what I wanted to say. I'd also like to thank Ivo Makushi And as I had promised, look at a wonderful panel that we had. I know and I've heard the 4 speakers who are here. And Secretary Eloy Terena, at the beginning of his intervention, mentioned that this event was developed, the design of the event and the choice of speakers was done, I'd say almost all of them, by indigenous people. It were the institutions that picked the speakers. I barely had the condition of choosing the moderators. My colleagues from the National High Court, I was wary whether I should pick these moderators or not. And further on, I will thank the team of the National High Court that helped with this communication, with this design, as well as with the logistics of our event. Ivo finished by stating that, quote unquote, indigenous people do not need occasional solidarity, end quote. We could not finish this panel with a more powerful phrase than that. You don't need solidarity because solidarity is what happens when there's no law, when there's no constitution. We judges need to protect indigenous people, not because we want to, not for option, but because the Constitution and the laws guarantee rights, establish obligations, and in a state that follows the rule of law, we judges need to fulfill what is set by the Constitution and the laws. Debates will be carried out in the end, like in the morning. So I'd like to thank our speakers, our 4 excellent speakers. We're going to start with the next panel, and here we're going into language protection. Last year, I stated in the end of the closing of the last symposium that in the next symposium we would deal with languages. And in the second one, I will say that the third one, still under my tenure, language protection will be the main point, because it's not enough to protect the land if we don't protect the language, because the language is a passport to cosmology, to knowledge, to communication, not just internal, but also among all of us. It's wonderful to hear such diverse, wonderful languages that we have in our country. I can't understand a word, but even just the sounds, the wealth of these sounds. Each sound has its history. That's why we have the duty of ensuring their protection. Repeating what Ivo said, not as occasional solidarity. Thank you very much. Let's go to our next panel.
Próximo painel é presidido pelo...
So the next panel will be chaired by my colleague Afani Vilela, Justice of the STJ.
Mas ele está em sessão.
But he is currently in a seating. I know it seems he's already back.
Ele continua, ou melhor dizendo, a turma, the chamber, continua em sessão.
Actually, no, the chamber is still in session, but he is here with us.
O ministro Afrânio Vilela
Justice Afrânio Vilela is from the state of Minas Gerais, and his grandmother was Ari Araxá,
que hoje deu origem
who
etnia, o nome da
gave the origin of the ethnicity of the city of Araxá. And this direct connection of Justice Afrânio Vilela is something I did not know of. And this is one of the importance of having these events here. And from now onwards, he will be the Indigenous Peoples Ambassador within us justices, among us justices. So I'm really happy to have found out about this, which he told me since the moment I invited him to preside, to chair this panel. So to all the indigenous people here, remember that in the STJ we do have someone with a direct link, an open link with indigenous peoples. Justice Afrânio Vilela. So Justice Afrânio Vilela, a career lawyer, contrary of Justice Afrânio Sérgio, that comes from the federal justice system. He came from the state one. Was a judge in the state of Minas Gerais, one of the most important and richest states of Brazil. He was an appellate just of the state court, Supreme Court of Minas Gerais. And he's a very close, a very dear friend of mine here at the court. And so we have speakers in this panel here that I'm going to invite now. Julio Benítez.
Altaci Cocama.
Altaci Cocama.
E a professora Bruna Franqueto.
And Professor Bruna Franqueto.
Da programação aqui. Eliel Benítez é diretor do departamento
Benítez, director of the Department of Languages and Indigenous Memories, the Ministry of Indigenous Peoples. Altaci Cocama is a coordinator of language policies of the Ministry of Indigenous Peoples. And Professor Bruna Franqueto is of the Department of Linguistics and Anthropology of the Federal University of Rio de Janeiro. So I hand over to our chair, Justice Afrânio Vilela. So Chief Justice Herman Benjamin, ladies and gentlemen, guests, participants, I'd like to first of all congratulate and say great things about this event. I know that everything that Justice Herman puts his hands on is like it becomes gold. And something that brings my attention to here, especially in the question of language, the second international symposium of the STJ, that is the Citizens Court, which is the one on indigenous peoples. And especially, Justice Herman did not know this connection of mine with indigenous origins when he invited me to be part of this panel. I told them that I'm the grandchild of grandmother Tonha, that passed away when she was 100 odd years old. and that throughout her existence showed us a series of behaviors and terms that she used that at the time we didn't understand. We imagined that it was a linguistic mistake of hers when actually it was her remembrance bringing terms and vocabulary that she had in her mind of her childhood in a farm of Spanish in High Paranaíba that she was remembering and would talk to us about when she used some terms, for example, with Spanish roots, and we would correct her. She said, "No, my son, I'm absolutely certain that I am speaking correctly. I'm gonna she used Spanish-like words. I have a dúvida instead of dúvida, which is the Portuguese correct term, a Portuguese term. And this is a posture that has to do with, have you ever heard of Corimboca? It's a mix that existed in High Paranaíba. The biggest Quilombo, the biggest Maroon society, over 1,300 people. The Ambrosio Quilombo had a lot of strong relation with the indigenous people in the region. And there we had the Kayapós, warrior indigenous people, and that are here. That connect themselves to the Are Achás that were at the time called Indians. So the Indians that lived in the south of Brazil are connected to the crown when the mines of Minas Gerais no longer had that vast quantity of gold, but the mines from Goiânia were discovered, and the Are Achás went to that region to help the crown in pacifying that region. And my grandmother was born from this union, Grandmother Tonha. I even have pictures of her here. I'm sure that if I put them or when I show them, those present here will recognize her. But, so we're talking about linguistics here. So she would tell us about the stories, and always spoke like this of the elder. The absolute respect to tradition, to orality, oral tradition. These are terms that she received as a cultural richness, personal cultural richness. And we must remember that Brazil in the 1700s, especially in São Paulo, we have the largest concentration of people or population. We once had their language that language was basically Old Tupi Guarani that was spoken more than Portuguese until about 1730s, when eventually was decided that all languages should be reduced except for the use of Portuguese. And I remember the practice she had with herbs and dealing with animals. And here's the person, when they arrived at the places and locations when there were animals, they would see her as a good person. And so I imagine when this break from the Tupi language occurred, the one that was spoken in Brazil in around 1730 and 1730s, how much technique, knowledge, and did we lose that we could try and recover? And that is why, Chief Justice, that I'm really happy to chair this panel. And without further ado, already taken far too long, showing my joy here, and I will be more than happy to be the ambassador, if not truly an ambassador, at least your aide and a colleague. I suggest that we follow the order that is in the program. And here, Sir Eliel Benítez is the Linguistics Indigenous Memories Department Director of the Ministry of Indigenous Peoples. The floor is yours. Good afternoon, everyone. It's a pleasure to be here at this very important event, the second International Symposium of the STJ. To greet the table, Antonio Vilela, Francisco Kama, Bruna. It is our reference in studies and academics of this types. We are the Department of Language and Memories of the Ministry of Indigenous Peoples. I'm of the Guarani Kaiowá ethnicity of the state of Mato Grosso do Sul. And it's a great honor to be here debating this agenda about language of indigenous peoples. I consider that we have a vast number of linguistic expression of indigenous peoples here in Brazil, and it's fundamental to think about this and keep that in mind in the perspective of promotion of public policy regards to strengthening languages. And first of all, it's important to consider this agenda within the idea of promotion of justice for indigenous people. Justice itself must consider the historical process of peoples. And especially when we speak of languages, I speak my language, Guarani. And to say that language is considered, first of all, as an entity, as a subject. And for us, we call it language. And they are part of the spirituality of our people. And so, the peoples that represent the physical entity, so the indigenous peoples that we see nowadays, are part of this process. So it is important to consider this, to reflect a bit on the violence process, the process of violence towards the indigenous people and their languages, especially historically. Considering the number of indigenous languages in the beginning of colonization, it was a process of effacement in a deliberate and intentional, planned way by the first colonizers, and later on by the state system. So in this education, policy promotion, in effacing indigenous languages in Brazil. In our case, the language of Guarani in the state of Mato Grosso do Sul is a border of the center-west area, from border with Brazil, Paraguay, Argentina, Bolivia. We are peoples, Guarani, Guayá peoples, where the borders started being imposed on top of our people's territories, where the peoples are divided. Guarani Kaiowá, Paraguay, between quotes, Guarani Kaiowá of Argentina and the Brazilian ones. So actually the border was imposed to us throughout history. And it is important to say this, to contribute in the linguistics of this territory and area. I speak from this point of view because we feel far safer and a stronger connection with our worldview, and our language, so that we may point at the current 365 peoples in Brazil. And this data changes every time more, but and to say that language as a subject, and is not subject in the Western sense, but it's in the sense of this perspective of spirituality of peoples. And for that, for the explanation here, I even tell a little bit the history of our people, the origin of the language, so that you can understand that language is part of time, and time and language will promote the territory. It's important to keep that in mind. Territory is product and part of language itself. Thus we have the forest and then the animals. Animals, they're not actually animals, because they're considered from a biological point of view, classified from a Western point of view, but we are entities, subjects. The forests are beings. The rivers are beings. The land is a being. So these beings make up the territory, and they have their language, their way of being, the form. That in Occident and Western science they speak of systems. That's why we have the climate system, the forest system, the river system, the water system. They talk about systems. But in our language or vision, they are subjects. They are beings that are present and therefore have their language as a condition of such. And the language, the production of territory, indigenous people, is part from our vision, a Guarani Kiowa vision. And from this relation and this context, it edifies language, the Guarani language, for example, which communicates itself not just with human beings, but with the forest, with the water, with rain, with a totality of beings that make up the territory that have their language. So the root of the language is in and within the territory. So the beings of the territory make up the language that is broadened, in this case, Guarani. But it also goes throughout time. And time is not Western time. It's not chronological time, but it's time with the with which the territory was marked. And today, with the political perspective of indigenous people, we speak of ancestral time, the ancestral time. The event, primary event, that occurred in time, is the basis of the sense within which it gives the horizon of the people's existence. That would be time. And it has its language as well. I would like to point out these more cosmological worldview aspects to understand another way of thinking, of existing, of understanding, and within the perspective of a language as well. And the Guarani language is not just a language for humans. As I said, they are languages for or to communicate with divinities as well. Divinities are the forces and powers that compose the physical existence so that we may exist. Why are trees alive? Why is the river alive? Why do we exist? There is a force, invisible forces, that allow us to exist.
So these beings are the roots of languages that we may use to communicate. So I'd like to say in that sense, and using some concepts coming from our vision, that for us to express the importance of language, because language has content, the worldview of people. And this cosmology, the worldview has historical depth. Reality is but the tip of a story, the tip of a wider reality that goes through time. So today is a part of the past as well. And we seek in the future the construction of the past, because it's in the past, it is in ancestrality, our deities created the territory itself. That's why language, and it's important for us to consider public policies in this perspective. I'd like to sing a little bit in my language to materialize a story, to tell you how our language rose according to our Guarani language. There's a song that we learn with our elders. I am a professor at the Federal University of Dourados, and we train teachers, indigenous teachers, and I am now the director of the languages Secretariat of the Ministry of Public of Indigenous Peoples.
Aê, 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 aê. Esse canto,
That song, Godone, means when land first germinated, the territory germinates. We, the Guarani components, were there at the very beginning. So, language is a part of the origin of land where our deities were present. So, in that story tells us that our first deity was walking through the cosmos, and they communicated with a variety of existing beings, and the sum of the relationships of these beings promote a language, a universal language, which is our language, the Guarani. This was the universal spiritual language. I'm saying this, that Guarani, we're a people. Here in Brazil, we have 305 different peoples with their own histories and languages. Language is not just communication between people, but with the cosmos, with the universe. And this diversity is what was violated throughout time. This diversity was decreased throughout time. So that we may promote linguistic justice, which is, it's important to consider the history of this process and the presence of this language in the system of law, everything that was discussed. And I'm running out of time as I was reaching the second part of my speech. We need to consider the language of indigenous people, this diversity, this wealth, linguistic wealth, as a part of the language of the national state, as a right, as historical reparation. And reparation is not just resources. Reparation is recomposing this cosmology, this worldview of the different peoples, to recompose the powers of the universe of all the peoples that were degraded, decomposed throughout the centuries of colonization and all the violence we went through. So in this perspective today, in the Ministry of Indigenous People, we're trying to seek out interinstitutional dialogue. One very important thing is the issue of training indigenous language interpreters, something else that's quite concrete, and not mentioning other areas that we are articulating. We have the Indigenous Language Decade that our companion Tassi will be talking more about, that is to talk about the big challenge that we have in relation to languages in Brazil, which is giving linguistic justice to the peoples. This means the result of the historical violence on languages in Brazil conditioned the reality of the linguistic diversity in Brazil today. Today, there are various situations in which languages are extremely threatened with extinction and weakened, and this violence continues. The system today is still loaded with powers that degrade languages in Brazil. So it's always necessary to continually act very clearly, very reflectively, using a perspective of the strengthening of indigenous languages in Brazil, starting with public policies, so that society, Brazilian society, where do we want to reach this sense? We want Brazilian society to understand that linguistic diversity is not a problem. No, rather it is a source of wealth. Using indigenous languages in the judicial system, for instance, in law, that is very fruitful. That is a cultural wealth that we must use, that we must articulate, that we must live, so that we may, in fact, be able to think of full justice. the objective is that we might be able to, through this process of our existence and promotion of justice and public policies, that we could recompose the cosmology of indigenous peoples, of the reality of their history, and in this context, produce new generations with new values loaded with the perspective of diversity. Diversity is wealth. Diversity of languages and cultures is wealth. It's not a problem. Western culture that the state sought to implement is a culture in which they want homogenized people, an absence of linguistic diversity so that people are easy to dominate. So that was the quick reflection that I'd like to make. As someone coming from the Department of Languages and Memory, and as well as this commitment from the Ministry of Indigenous People, and I'd like to thank you for this very important event so that we can reflect alongside you on the agenda regarding the languages of the peoples, which now more than ever is a beautiful thing full of history, struggle, dreams, and it is through language that we dream. We dream in our people's language. We dream of our land. We dream our land through our language. That's why it's fundamental to follow this theme so that we together can think of the paths ahead of us for public policies in a more sustainable fashion in the perspective of promoting indigenous law and justice in this country. Thank you.
Professor Eliel Benítez.
Professor Eliel Benítez. He is a professor and he is a teacher of indigenous teachers, especially connected towards the teaching of natural sciences. And he talks about the need to of linguistic recomposition, which I also defend, as I also stated in the beginning of my words. But this connection of what life is for him in the Kiowa sense, in the Guarani sense, which is the communication with the forest, the rivers, with the rain, this whole essence that he told us about, and that has to do with ancestrality. Very well. I will now pass the floor to Professor Justiça Okama. She's a PhD in linguistics at the University of Brasilia and Masters in Society and Culture in the Amazon in the Federal University of Amazonas, among many other characteristics and predicates that I could say about you. You have the floor.
Mitawara Waina, Altaci, Cocama, Indira, Tataia, Tawatsuri, Santo Antônio, Tamaquara, Amazonas. Sa Kakur, Brasília Quara. Sa Tseta, Yutsurupaki, Apo Afrânio Helena. Auano, Mitawara Waina Bruna Franqueto, e Mitawara Eliel Benítez. Apo, Comitza. Boa tarde a todos.
Good afternoon, everyone. My name is Altaci Kokama. I greeted the table.
Está esperando o slide.
I was waiting for my slides to come up. I'm going to be following the guidance of the slides that I wrote.
Eu sou do Alto Solimões, no
I come from the High Solimões River in the Amazonas state. So we have two extremes, the Solimões and the Upper Solimões and the Upper Negro River. And in the struggle before the quota system, in '94 I left my territory to seek an improvement, to seek health, to seek education for me, for my mother, for my family. But I went by myself with a dream of being a university student. It took 5 years in university entry exams in a popular university entrance exam course in the slums of Manaus, and I have not stopped studying since then. And I went through civil service exams. I became a teacher in the municipality of Manaus. My second civil service exams teacher in the municipality of Manaus. Many civil service exams later, the last of which I became the first indigenous professor in the University of Brasilia, and currently I am a part of the Ministry of Indigenous People as a part of as the coordinator of linguistic policy promotion. But before the ministry in 2020, in a global call from UNESCO, I was elected as representative of the decade of indigenous languages for Latin America and the Caribbean. An arduous process of construction of a worldwide plan for valuing indigenous languages. I'm the one who controls the slides, right? Okay. So why is it important to implement the International Decade for Indigenous Languages? First, recognizing linguistic rights as human rights is recognizing, as Professor Eliel said, that territories are living, their rivers are living beings, their trees are living. And just like all biodiversity, because the indigenous languages that are all the secrets, all the knowledge, all the speech, all the different medicines, ancestral connections reveal the resistance of indigenous people until the current day. Because in the 2010 census, we have 305 indigenous people, as has already been mentioned. Indigenous peoples. We have 275 languages. This was in 2010. This is from the 2010 census. That is more than the 234 ethnic groups in all of Europe. So Brazil has a diversity of languages and peoples that the 2022 census will present new updated data, because the indigenous people are on a path towards protagonism. Today, we are the ones who say who we are. We're no longer classified from the outside. Oh, you're indigenous, you're not indigenous. Oh, you look like an Indian, you don't look like an Indian. No, now we say who we are. And so I stated a few points of why we should have this decade: to protect indigenous languages, considering them as cultural and spiritual heritage, guaranteeing linguistic rights as human rights, guaranteeing the full participation of indigenous people as citizens. It is only with linguistic accessibility that will guarantee the citizenship of indigenous people. To leverage the social cohesion and intercultural dialogue, multilingual practice as a flag for world peace. As Professor Riel was saying, linguistic diversity is not an obstacle for progress. Rather, it is wealth. Each people, each language must contribute to the good living of all, because it's not just the Amazonas that needs rain. The rivers that we have aren't just for the people of the Amazon. It's not just for Brazil, it's for the whole world. The proper valuing of indigenous knowledge and the recognition of indigenous epistemologies for the good living of the biodiversity of the planet. This recognition of the biodiversity, which is inside the indigenous languages, and when the biodiversity is with us, it's marginalized. But when it goes out, then it's valued. Here in Brasilia, if you take a natural medicine, it costs a lot, but if we use it, we're marginalized. I remember the case of my sister who went to have a baby at the hospital, and she didn't want to eat pirarucu, and they forced her to eat that fish, pirarucu. And so there was a psychological impact within that is the traditional diet that we had that she wanted to follow, and she was forced to not follow it. So if you pay, you can have whatever kind of labor that you want. So we have physical and spiritual meaning for us. Oh, I only have 8 minutes left. I prepared my speech for a time. What are the advances and challenges in the implementation of the Decade of Indigenous Languages? In Brazil, this was extremely important because before the creation of the Indigenous Peoples Ministry, we already had a movement here in Brazil of the International Decade for Indigenous Languages, made up by 3 working groups. And the demands of these working groups were the creation of a location, a department, a secretariat, a directorate that could make indigenous languages into a public policy priority. And as the ministry was born, the Department for Indigenous Languages was also born. And this location has the mission, the evaluation of indigenous languages, guaranteeing public policies, in which for the first time we're creating the linguistic policy at the national level after the Federal Constitution of 1988. It is this department and a bill that we created to value indigenous languages. Then we create this department together with the National Working Group for the Decade of Indigenous Languages that promotes the valuation of indigenous languages and the use of indigenous languages at the national level, that recognizes indigenous sign languages, languages spoken by indigenous people forever, but were never recognized as languages, as well as the Portuguese that is spoken by indigenous people as well. Quickly now, we have a presentation of the makeup of this department, in which indigenous languages are a transversal theme. All that we do goes through communication, goes through understanding, and linguistic accessibility is extremely important. Without linguistic accessibility, no public policy will reach the goal, its stated goal. And here we have some of our main goals that we have, as I mentioned, all of them, be it in education, be it in memory, linguistics, cultural policies, heritage policies, the historic violation of indigenous populations. All of these policies defend issues related to linguistic of indigenous languages. There's the issue of the indigenous universities, the core of which are indigenous epistemologies, and within the indigenous epistemologies, it is necessary for all knowledge to be
epistemológico da academia ou das epistemologias indígenas.
To use academic epistemology, indigenous epistemologies, they need to be in dialogue. And to use indigenous languages. These are some of the actions that the ministries of indigenous people support. All of these actions are supported by the Ministry of Indigenous People, including seminars, many seminars that our ministry, through our Secretariat of Articulation and Promotion of Indigenous Rights, have carried out. Actions in partnership with the Dini movement, which is the movement of the International Decade for Indigenous Languages. These actions, well, we have the Indigenous Oral Languages Working Group, in which we create teaching materials so that we can strengthen this campaign, and so that society and institutions, and I really like to thank this agenda, and that you're going to make it the main topic of the next symposium here at the STJ. And we are also fully through the process of co-officialization of indigenous languages. We're going to the second national event of the Indigenous Language Decade that will happen in the village of Buriti in August.
The Ministry of Indigenous Peoples, the FUNAI, the IFA, and other institutions that are supporting this event, we're also going to have the question of the workshops. The ministry, through our department, has been taking workshops of languages, a co-officialization of language, a revitalization of language. And here we have the work group of languages. That is also the second edition of taking this agenda that was made invisible within the territories. We've also had the co-officialization, the sign language of the Pataxós, today in Santa Cruz Cabrária, in the state of Bahia. It's a historic day for the indigenous peoples of Santa Cruz Cabrária. Many actions of this work group that are still undergoing. And then we have the Portuguese that is spoken by the indigenous peoples. That is a mix, well, that is the Portuguese, because the Portuguese is spoken by these peoples, represents the indigenous worldview, their cosmovision. And very often, Professor Ariel says that the Portuguese spoken by indigenous peoples is a path to take on against the ancestral language, which these peoples in the silencing process ended up having the language as silence, asleep, and now this is the path to try and find them again. And before I read my final comments, I couldn't possibly not sing. For you, I'm going to make you sing with me as well, because it's the decade, it's the call. And I know that STJ has taken upon itself to answer this call. And I'm very grateful to all the organizers of this event. And I'm not going to sing in Cocama. The only reason I'm going to sing Cocama is because I'm a little bit hoarse. And the tone of the Cocama song is quite high pitched. We're going to sing as we do in the Amazonica, in Ticuna, which is the language of my grandmother's language. I'm going to sing and you're going to repeat. And the song is a thanks. It's called Pacori. Okay? Let's go.
Chonenga Kurunamai neva Eruche Agudura Guchakura Yomadana neva Yana Ine Gochga Finalizando, é urgente o reconhecimento das línguas
should be recognized as immaterial heritage, but especially as a linguistic right. This conception requests that we go beyond the rhetoric of diversity and adopt a policy of effective valuing of original languages in public spaces, educational spaces, and legal spaces. Facing glottocide is by guaranteeing the life of indigenous languages in the schools, in the means of communication, in universities, and in all the environments. Nothing about us or for us without us. Thank you very much, Professor Ataci Cocama. Life story is very beautiful. when, as a teacher, as a professor, and today is defending agendas such as that of the recognition of indigenous languages as a immaterial heritage, as a linguistic right, but especially as a human right, because diversity is life, life of and for all of us. Thank you very much for your participation. I'm now going to hand over to Professor Bruna Franqueto of the Department of Linguistics and Anthropology of the Federal University of Rio de Janeiro. So the example of all who spoke, there's a curriculum that if you would read it entirely, it would take up the entire time of the symposium or the seminary. But graduate in philosophy in the Institute of Homo Sapienza, a doctor, a PhD on several subjects in social anthropology, for example, and ethnic linguistics of the group Caribe of High Xingu, Alto Xingu. Thank you very much. It's an honor to be here with you all. The invitation to be here is an honor. And well, I'm the only very light-skinned one here among the speakers. I'm Italian, but then took on the Brazilian, then took on Brazilian nationality. I was of Italy, border with France, and then I decided to leave the old world and to go across the Atlantic and go after languages. And this was my life's passion for all my life, and my objective was to study and know and get to know non-Indo-European languages. So I got a scholarship in Australia to study Aboriginal languages, and at the same time to Brazil, and Brazil was the one I chose. I could have been the opposite. I might have been in Australia now with my white hairs, but that's what happens. So I'm going to speak as a linguist here, complementing the speeches that came before me that were very beautiful. And the fundamental one, well, Brazil is a multilingual country, completely multilingual, that is denied the 5th century of colonization for the sovereignty of a single language, the language of the state, of the colonizer, of the conqueror. The native diversity in Brazilian territory survived and resisted miraculously. I'm trying to make the slides go by here. To a disastrous, murderous tendency. What would be the territory called Brazil was invaded and conquered and colonized, meaning that when the Europeans arrived, there were over 1,000 indigenous peoples, and between 12 and 4 million people, and about 600 languages, spoken languages, at least, at the very least. And since then, what happened? We had the loss
uma perda de mais de 80%.
The loss of over 80%, so 83% of native languages that existed when the colonizers arrived. The loss of over 80% of this diversity is disastrous data. that is very exasperating. That which was lost in these 500 years in terms of diversity of languages, language variety, because there are no homogeneous languages internally. In reality, languages live in their internal diversity in dialectic way. It's diversity of dialects that makes languages exist and live. The concept of language is a Western construct.
É difícil, inclusive, definir o que
It's
é uma
even difficult to define what a language is, not an easy task. I insist they are internally diverse. Look at Portuguese. Brazilian Portuguese, Portuguese in the world, the variety of Brazilian Portuguese even, profoundly influenced by African and indigenous languages. Within the variety of Brazilian Portuguese, we have varieties of Brazilian Portuguese spoken by indigenous peoples in Brazil. That is one of the sides of the work group of the indigenous languages. So if you open a window or a door for important phenomenon, variety of Portuguese in Brazil, different by its only poetic difference, its music. It is a fantastic Brazilian literature and extremely influenced. Portuguese spoken locally, regionally by indigenous peoples. How many indigenous languages? Let's think of languages. Let's think of something difficult to be thought of. So we have a dance of numbers. They cannot fight because on one side you have a race, you have an investigation and research of a linguist that goes under certain criteria, and then now says there's an existence of 170 languages. This is the side of this dance of numbers. 170 languages spoken in varied degrees of vitality. You have very strong languages. We saw today Kayapó, Guarani, Andeva, Kaiowá. In Brazil, because there are obviously other varieties of Guarani languages in neighboring countries, such as Paraguay, for example, Argentina as well, and which is a trans-border language. The indigenous language, with very few exceptions, are all trans-border languages, because the borders of national states went over actual territory that was occupied and lived by native people without borders. They're on the borders between indigenous territories. They exist, they're fluid, but they are not the lines that were forced to the national states. So this map alone that I'm showing here is going to show several colors. Reduce a little bit the colors. The famous ethno-linguistic map that was published in 1944. Imundabaju tried to give a vision of linguistic native diversity in Brazil between the conquest and the first century of the colony. But very soon this group of colors visualization, multicolor visualization, gives a certain impression of this diversity. And why? Well, languages. If we consider this number given by linguists, it is not the number given by the 2010 census. Those are 224 languages. Census by self-declaration. These are the criteria that are in play. And we'll see the results, the last census of 2022-2023. You will certainly see, I'm a consultant of the IBGE, the Brazilian Institute of Statistics. You'll see the number of ethnicities increased these last 15 years, as well as the amount of self-declared languages. Probably going to go over 300 self-declared languages, or even more. But considering the linguistic criteria itself, look at what's behind this rhetoric of diversity. Because it's a serious thing. Diversity must be recognized, researched, and documented. Just on the Tupi branch itself, it's 7 linguistic family. The Macro-G branch, Arawa family, the Caribe family, the Pano with 16 languages, the Tucano with 11, and then we have the Eastern Tucano in Colombia, Western, between Colombia and Peru, the Pano family with 16, the Chapacura with 6 languages, the Nadahup, the Northwestern Amazon, the Mura family with 2 languages, Lamipara with 3 languages, the Waikuru, you were in the Pantanal, 1 language in Brazilian territory, the Bora family, the Yanomami family. You think Yanomami is a language? No, it's a family with 6 different languages. Arawak family with 6 languages. Have at least 8 isolated languages. They don't have other languages coming from the branches, or at least for the moment we think there are. And you have Creole languages. And we have the border with the French Guyana and English Guyana. Creole languages that are French base languages have a border with French Guyana, still a colony. Several language contributions, indigenous languages, giving origin to birth to 2 languages called Creole. This is the Creole Paripuna, a Creole Galibi Maruano, and we have the sign languages. Indigenous sign languages. So to this map, we must add sign languages. They're not represented in this map. So this map is going to be far richer, more colored, if we represent sign languages. And here we have another visualization here of diversity, of this multicolored panorama of native languages with their branches and families. And consider that beyond that, we still have regional systems, multi-language systems. Some quite well known, such as the Alto Rio Negro one. Also well known is the multilingual system of Alto Xingu in Mato Grosso. In the south of Rondônia, this multi-language system that is very complex is being more recognized every time. What are the multilingual systems? The regional systems where people speak genetically different languages, have maintained relationships, commercial relationships, marriage relationships, rituals,
a variety of different aspects of their cultures, and these regional systems, which were huge and covered enormous territories. You were the rule. Now we only know 3, 4 of them. They're survivors of old systems, survivors of glotticide, survivors of colonization. But before Brazil was Brazil, these regional systems were absolutely the norm, the rule. They covered whole territory from east to west, north to south, and going even further west beyond the borders of our Brazilian nation state. These multilingual, multi-ethnic systems, they're being ripped apart led to a huge impoverishment of the linguistic diversity. We need to protect what's left very strongly. And to protect, I'm just going to give you an example of this stunning diversity, which is our heritage. It's an amazing source of immaterial wealth. We say that they are immaterial, but they do have a materiality. You hear them. So they're not that immaterial. Let's call them, so to just call them immaterial is a little weird to me. That maybe we need to look at that concept again of material versus immaterial if we're talking about languages. In the case of Rondônia, for instance, Rondônia is an incredibly diverse state in terms of languages, and it's multi-ethnic, multilinguistic system. Look at the situation of the ethno-linguistic situation in the state of Rondônia now. Look at the quantity of groups that are people. In the first and the third column, it says groups. Then we have the population, which is not a precise number. This is not the number of speakers. You can look at the difference of population and speakers for each of these groups. How many languages just in the state of Rondônia, where you have strong languages like Surui. Surui is a language spoken by all of those people, small group of people, 1,000. In terms of damage, it's not that small, but all of them speak it. But we have some. Well, you only have the Poroborá, for instance, have only 2 speakers for a population of 50. And Orowin, there's a population of 82 and 4 speakers. So these small peoples, these small languages, where we only have 1, 2 speakers, 1 family, where you can count the survivors on the fingers of 1 hand. Will these languages survive? 10, 20, 30 years? I'm sorry, but I'm a pessimist. I'm extremely pessimistic. This is a very clear example, and I am a pessimist. These languages have very few speakers who are elders. They're not going to survive because glotticide happens through physical genocide of speakers, through infectious contagious diseases that have absolutely overwhelmed the indigenous population in the 4 centuries of the colony, but this happened in a more subtle way as well, through Christianization, through religious proselytization, both Catholic and evangelical, Pentecostal. But it happened through schools. Let us not forget that schools were a weapon of linguistic destruction. If now, over the last few decades, we're speaking about bilingual, intercultural schools, all of that, that's a very recent accomplishment from the 90s. Before that, schools were an instrument of destruction of languages. So, what is the, and I'm going to be wrapping up. Pay attention now. What is the mechanism that destroys languages? The mechanism that destroys languages today is, above all, the interruption of the transmission of a language from one generation to the next. This is happening in these small groups. Canoe, 80 people with 5 speakers, actually 3 now. 2 of them died. 2 of them died. I know this. It's a nice language isolate. It's done. This is a language that's done. It's no longer in the map. So the map is impoverished, radically, dramatically impoverished. The language has died. How did the Kanoe reach this dramatic situation? There was an abrupt interruption in the transmission of the language from one generation to the next. If there is an intermediary generation that is communicating in this native language with their parents, but they do no longer communicate with their children at home, they decided or were forced to speak only in Portuguese, and they no longer speak to their children in that language. And their children won't speak to their grandchildren, and the language is over. It's done. This is the deadliest weapon of glotticide. This is not just in Brazil, this is throughout the world. The interruption of intergenerational transmission, one generation to the next. I'm going to be stopping here. So I've already talked about this dance of numbers. Let's see the criteria. There's some of the criteria that are linguistic. There's some criteria from self-declaration. They give us different numbers. They're interesting numbers to be considered, definitely. And I can't help say, Atasi and Nadia, to talk about the enchanted languages, the languages that are being revitalized, and they need to put into that map, because if languages die, new languages are arising with more difficulty, but they are arising. Pachuhan of the Pataxó people, the Bukuás, in the Atlantic seashore in the northeast, the Quipeá by the Cariri people, the ancient Tupi by the Potiguara from Alagoas and other groups as well, Ngingatu, which is spreading very interestingly in a variety of different areas in Brazil, like in the lower Tapajós, in the Amazon, southern Bahia, and the Tupinambá from Paulo de Oliveira, the Akué. So the Chakrabá was here. Akué is being really adopted by the Chakrabá people. They didn't no longer spoke their ancestral tongue, the Chakrabá, but they're undergoing a process of retaking the Akué, which is the Xerente Akué, which is like the Xerente language, and a variety of others that are being revitalized. This is hope. This is hope. And we have Braslinde, which is indigenous Portuguese, which could also be added to that multicolored map of linguistic diversity that we had. So we're in this tightrope between pessimism and a moderate optimism. At least that's how I live. I repeat, languages need to be respected, but as a linguist I say, languages need to be known, documented, researched, analyzed, above all documented. That's fundamental. I decided to learn an indigenous language. I speak that language, I can sing in that language, I can even write poems. In Wikikura, it's from the Carib language family. I'd like to apologize, but the Basque movement in Spain, the revitalization of Basque language, they said that speaking Euskara is a revolutionary act. I'd like to wrap up by saying, speaking an indigenous language, not just indigenous people, but we, whiteies, we white people, non-indigenous people, if we speak indigenous language and we can communicate in that indigenous language, that is a revolutionary act as well. But it is in fact a revolutionary act. Thank you.
Professora Bruna Franqueto.
Professor Bruna Franqueto, We'd like to thank you for all the information that you brought us, talking about the quantity of languages, the diversification of the different levels of vitality, they understood as a level of processes of corrosion and the existence of these languages, the reason why it is necessary to protect them, even if new languages are also arising or getting, or that we're getting to know them. I don't know if I can say that they are actually emerging, but there's so many different language families, so many languages, but this information that the speakers of genetically distinct language families have different kinds of relationships. Evidently, they covered this territory of Brazil beforehand, but especially in this ethnic relationship that led to commerce, that led to marriages. All of this really lead us to understand that this seminar has reached, Justice Herman, its goal for this moment in which we must continue with these goals. And just to wrap up, I understood that languages, in the sense that we're talking about here today, is not just about communication. It is an expression of being. It has to do with the intimate world of the people who speak them, with the relationship of our indigenous people with their institutions, with their identities, with their entities, with what life really is, of all that is living, of all that participates in the day-to-day life, like fauna and flora. But all else also calls my attention, and I'd like to talk about the example of my home city, Ibia. Ibia, known as the land of the high streams. It was a plateau, the plateau of the Araxás, and there were a lot of springs that were born there. And I often say that it has to do with the miracle of nature, of transforming seeds into food and giving life, and everything that was discussed here. Thank you so much, Mr. Chief Justice. Thank you so much for the opportunity of being in this panel. I'd also like to thank you all for the opportunity of being together with Professor Eliel Benitez, Professor Altaci Kokama, Professor Bruna Franqueto. I'd also like to sing something, but I don't have that. I will learn how to sing an indigenous song. Maybe in the future, I may be able to sing to all of you. Thank you very much. Not just singing, but also the revolutionary act of learning an indigenous language. So I'll leave you with this challenge. I'll repeat this challenge that was presented by Professor Bruna. This was a beautiful panel, and evidently there's so much information about languages. We didn't even touch the surface of the complexity of this matter. And we, in law, should be concerned a lot more with language, because law is language. And everything that we do, we use a single tool, language. And the insensibility of us in law to language itself, and not just to legal language, our sensibility is very low, very small, almost null. And we all think that in Brazil that we speak a single language, and we're proud of this children
país que fala uma única língua, o português.
and say, oh, we're in a single language country,
Que
Portuguese.
fake news
That's
histórica.
historical fake news, isn't it?
Falamos uma única língua.
They say we speak a
Então, no
single
próximo
language.
congresso, vamos ter
Well,
mais tempo
in the next Congress, we'll have more time to discuss language.
do próximo evento.
Half of the next event will be about language. We won't forget rights, land, but we will be going further in depth
E eu já pedi
to this debate.
a nossa TV
I've already
Justiça
asked our TV station
programa
to have a specific show on indigenous languages.
Não sei se todos sabem,
I don't know
mas
if everyone knows, but this is also available on YouTube.
a TV Justiça aqui no STJ, o
The
estúdio já
Justice TV here in the National High Court, we've had a long interview with Cacique Raoni, Chief Raoni. We've had an interview with Davi Kopenawa. I'd like to recommend these interviews, and I'm going to ask for the link so that you can watch them.
o Davi e o
Usually, Davi Kopenawa and
Raoni
Raoni,
são entrevistados
they're interviewed
5 minutos.
5 minutes.
E aí, não, vamos fazer
And I said, no, let's have a full show, an hour-long show for each of us.
E foi o que nós
That's what we did.
fizemos.
That's what we did
Superior Tribunal de
here at the National High Court. I've already asked Dr. Giovanna Carneiro, my consultant, for every topic, including linguistic topics. I've already asked her to organize in the studio a specific show on indigenous languages in our country to call attention to this matter.
O desaparecimento de
The
uma
disappearance of a language, and we saw the statistics that Professor Bruna presented.
é crime.
This is a crime. This is a crime against humanity.
Nós ficamos horrorizados quando
We should be struck in horror
se noticia o
when
desaparecimento
there's a
de um
notice
inseto,
of the disappearance of a species, be it an insect, mammal.
grave. Mas que
That's a
tal
very severe situation. What about the disappearance of a language?
território humano?
We're now in human territory.
E daí a preocupação que nós devemos
Thus, the
ter. Eu
concern we
agradeço
should
muito
have.
esse painel.
I'd like to thank this panel very dearly, and we're committed to, after this, the next panel on gender, to open up to questions.
Na perspectiva dos povos
So gender in the perspective of indigenous people, we're going to be opening up to debates and to final considerations before we hear Professor
a conferencista
Stacy leads.
do nosso encerramento.
Stacy leads the closing keynote speaker.
Ela está aqui conosco.
She's here with us. She's been with us since the beginning, awaiting the moment that will come at the end of this
painel,
seminar. Before we go to the next panel, we want to have the already traditional collective photograph near the flags, and I'm going to. I'm sorry.
Não.
Is there some problem? No?
Agradecendo
And I'd like to thank all of you,
e muito especialmente
and especially my colleague,
a Afrânio Vilela,
Justice Afrani Vilela,
sua presença e os depoimentos.
your presence as well as your
Intensa com os povos.
statement regarding our connection to the indigenous peoples of Brazil. And I'd like to invite to the stage
Arnaldo Fernandes,
Justice Arnaldo Fernandes, Dr. Carlos Schmidt,
o Dr. Gustavo,
Dr. Gustavo,
a doutora Giovana,
Dr. Giovanna, Dr. Edivaldo,
doutor
and Dr. Fernando.
são os
These are
os meus auxiliares
my
mais próximos,
closest assistants who helped me in this event. And I'm going to present them so that you all get to know them. Before that, let's take this picture.
Bem, eu queria convidar,
So I would like to invite my counsel
vir aqui à frente.
to come here.
Todos? Vamos lá.
Everyone,
Não vamos perder tempo.
let's not lose time. Let's not waste time.
Então, aqui, podem ficar aí. Bem, o ministro Arnaldo Fernandes
So,
é diplomata.
Minister Arnaldo Fernandes is a senior diplomat of the Itamaraty of our Ministry of Foreign Affairs and is head of international advisory of the STJ.
A doutora Giovana
Dr. Giovanna Carneiro,
formada pela Universidade do Estado
graduate at the University of Rio de Janeiro, a master's in Harvard, and takes care
desde inteligência
of
artificial
AI, all the way from AI to
os eventos científicos
and the science events,
especialmente de direito
especially compared
O Dr. Carl Schmitt,
law.
juiz
Dr. Carl Schmitt is a judge,
do Estado do Rio Grande do
the
Sul,
state of Rio Grande do Sul,
o secretário
and Secretary General of the STJ,
Dr. Erivaldo,
Dr. Erivaldo,
juiz federal,
the federal judge,
o secretário
and he is General Secretary, the Council of Federal Justice. The President of the STJ is also President of the Federal Justice Council that reunites the 6 federal courts of appeals and does the management of federal justice. Dr. Fernando Gajardoni is a judge in São Paulo, the state of São Paulo, professor at the University of São Paulo, and is the secretary of the presidency. Deals with everything that has to do with sentencing, with the structure of the judicial legal questions of the justices. Dr. Maria Paula, the judge of the state of São Paulo, and takes care of the social part and the various councils of which the STJ participates. Dr. Joaci is a judge, also of São Paulo. He's here of the federal district, but he's a judge of the state of São Paulo, state judge. And Dr. Gustavo Mazzotti is a federal judge and takes care of the agenda of penal law, among other things here at the STJ. I'd like to thank them thank us teams here who worked at this event. I'd like to thank the interpreters that are also here and the institutions that work with us, international institutions and Brazilian institutions. So like a round of applause to them all, please. Now, applause.
Somando todos, não dá o Tiago.
Even if we put all of these together, they still wouldn't be as good as Tiago. Tiago is my right-hand man, one of the most incredible people that I know. Honestly, I don't know how he stands me, but he is truly someone that helps in everything, always and behind the scenes, does not want to be seen. He has a graduate in law. He entered the STJ when he was still in high school. Then did law school, and I was getting ready for the public competitions in life. Perhaps next year, once you come here, I hope Tiago is still with me, because even if he managed to go through these competitions, the judiciary has the power of requesting any civil servant in the country. So I don't want to scare the institutions for which he is preparing to try and enter. You will certainly be requested to continue here with me. Thank you very much, and another round of applause, please. Let us continue with our panel. It is an honor now to invite my colleague, Justice Daniela Teixeira, who is almost a baby at the STJ, is here only started working here 2 years ago, less than 2 years. And during this short period, has revealed all her energy and capacity work-wise. And the STJ has only 5 women justices, a very small number. And these 5 women, although not numerous, are a true example and model for Brazilian women. The ideal, obviously, would be that we'd have parity between men and women. This is the last panel between the closing session, before the closing session. It is about gender. And so without further ado, I hand over to Justice Daniela, remembering Justice Daniela that at the end of this panel, we're going to open to anyone who wants to ask questions. And then we shall have the closing panel with Conference Professor Stacy Leeds. And a real conclusion will be with Cláudio Providas, boss of the UNDP here in Brazil. So, Daniela Teixeira, the word is yours. Thank you, Chief Justice, for giving opportunity to be part of this symposium. It's so important to Brazil, to the justice system, that is to receive the indigenous peoples here to deal about their rights. They who are our original peoples and deserve all consideration, respect, and attention. I'd like to invite to be part of a table here, already greeting effusively His Excellency Dr. Shamara Pataxó, Her Excellency Dr. Shamara Pataxó, born in Cora Vermelha and Pataxó people in Porto Seguro in Bahia. She's a lawyer, PhD at the University of UNB, and since she graduated there, works and studies with territorial indigenous rights. Executive co-coordinator of indigenous peoples in Brazil, legal counselor of the peoples of the Northeast, Minas Gerais, Espírito Santo, the United Movement of the Peoples and Indigenous Organization Bahia since 2022, and Chief Advisor for the Nucleus of Inclusion and Diversity, the General Secretariat, the Presidents of our Superior Electoral Court. Thank you very much for participating. Also like to invite Appellate Judge Dr. Adriana is appellate court at the Court of Rio de Janeiro, auxiliary judge of the Justice Court of the Rio de Janeiro, doctor in public law by the University of Barcelona, master in criminology by the University of Barcelona, professor and masters in legal feminism, theory and practice, feminist practices in Barcelona, part of the teaching of postgrads of law at IMFAN, that is our National School of Magistrates, leader of the GAP DE 11, research on gender, human access and access to justice, of the professional post-graduation program in law here at IMFAN. As you can see, two highly specialist women in the subjects we're going to deal with, and the president of our chair of our channel now deals with gender perspectives in the indigenous cosmovision or worldview. The subject says a lot about what we're going to talk about here, which is the female woman's perspective in indigenous view and perspective, and it's a very important perspective. Indigenous point of view, the question of gender is very different from what we've seen here. We have a woman that's far more respected. Extension of Mother Earth. Under this ethic, nature and women unite themselves as if they were all one single being. Woman that generates life, fruits, and generates the entire indigenous peoples. So, with the entire respect that the indigenous cosmovision shows for women, will be brought over here now. When I started, I said it was so important for our court to deal with indigenous question, and it is. When I was I was the rapporteur of habeas, very interesting habeas corpus that I will leave at your disposal here, where we had as defendant 6 indigenous people, 4 women and 2 men that were accused of homicide, a very serious crime, of 3 men that disappeared in this indigenous land. That is forget the name of where it is, but the fact is 3 white men disappeared in these indigenous lands, and these 6 defendants were being judged in common justice, as if it was just a simple homicide. And so the Attorney General came here to nullify the process, saying exactly this. Before this homicide, it was invasion of a land. It was a threat to these indigenous peoples. They were defending themselves from a previous crime. And so I nullified the whole other process that was in the state justice or the process could start again in the federal justice, and with support of FUNAI for these indigenous peoples, and determined that they be immediately freed. They were incarcerated. I took to the circuit. It was a new case, and it was unanimous by 5-0. They maintained the decision so that these people, especially these women, Dr. Samara, be judged in the federal justice with the attention of FUNAI, under this look that the Constitution tells us we must have. It says this very clearly in its Article 231, that respecting the beliefs and traditions of the original rights of this population. When someone goes there and invades their lands, it must be seen under this optic and the reaction that was given. One, people that simply killed someone. So our STJ, in this specific case that I brought to you, as I was the rapporteur, showed this concern and care for preserving those indigenous women that were incarcerated. So I hand over now, saying that we have a specific time that we must respect, of course, as always, 20 minutes. I will let you know we'll have 5 and then 1 minute left. Just for Appellate Judge de Mello, for 20 minutes. Thank you, Appellate Judge, for being here with us. Thank you. Good afternoon to all present here. It is an honor to be here in this panel, being coordinated by Justice Daniela Teixeira, for whom I have great admiration and respect for the work developed here at the STJ. Also thank for the invitation. There was Justice Herman Benjamin extended to me so I could be here. I also greet my other panelist colleague and everyone present here. I'm going to talk a little bit about a study that we are developing. And so firstly, of course, I am a appellate judge of the Court of Rio de Janeiro, acting in a crime grand chamber. But I'm speaking more as a professor here, not as a magistrate, but as a academic in this subject. INFAM was created in 2021, and within this professional master's, it was created by Minister Justice Herman Benjamin. And I remember all the meetings we had during the pandemic. So it's great to talk here about our professional masters of IFAM. And it's during one of our master's class and during the ethics and integrity course that I teach, where I started talking about just criminal system and justice for women, and then I taught ethic, legal, judicial ethics, and integrity, then ethics and equality. And it was during a lesson for judges of all of Brazil, especially from the north and northeast region magistrates of Brazil. So we also had a Cineia Wapixana to talk with judges about climate change and what these impacts would be in the life of indigenous women. Cineia accepted my invitation to challenge of talking to a whole group of magistrates and judges. André Brasil is present here, was also the one who introduced me to Cineia. She had a lesson over 4 hours with magistrates, and several judges told me, also said to Cineia, that they were not aware of the reality of indigenous women in Brazil, especially the northern region of our country, and presented a documentary called Quintura documentary, directed by Cineia herself and conducted. This was a watershed in our life, and I think in the life of some judges that were in this course. So from this lesson of Cineia, and here at the far right end of the picture, she was not able to be here this moment because she is in a pre-COP30 phase that we're going to have in Pará, and she is there talking with indigenous leaders, and with Cineia's own call, we started undertaking a study on the climate changes and the impact in women's lives, especially women that live in this region.
I was going to bring some data, but the time would probably not allow me do this. So I'm just going to highlight that Brazil ratified and committed itself very strongly indeed to protect the rights of women and above all of indigenous women. We have recently a consultative opinion, a recent one from 2025, talking about the importance of the climate emergency and of human rights, especially in relation to women. I could not help but speak about that. And I'm going to go straight to our study. And so this is a study that was carried out by the Gender, Human Rights, and Access to Justice group that has three axes of research and study. This is a study on policies of equality in the magistrates' offices, and then we have very, very, very few indigenous and black judges in Brazil. So that was something very important, a very low level of representativeness of indigenous women in our judiciary. So that's yet another reason for us to study and be concerned about this. This axis of equality policies has contributed to the National Justice Council's resolutions for the promotion of equality, for gender parity, and for the participation of women. The human rights axis, where this study is included, and the axis of access to fundamental justice. This is study is in access to justice. That's the nucleus. Studies in human rights, above all, women's human rights. And Sineya Wapichana is a part of this nucleus. They just defended their dissertation, master's dissertation in the University of Brasilia. And this study talks about the issue of intersectionality. And as I already mentioned, it started during this very class in our master's. So it comes from this master's and from this instigation that she brought to judges, many of them from the north, who had no clue about the impact of climate change, of the catastrophes, of droughts in the northern regions of Brazil, and how this has caused suffering like food insecurity, the difficulty of these women to access justice. And we're going to be talking about that very quickly because there's a video at the end with the indigenous women themselves talking about their demands to the judiciary power. And it is based on these demands, on the speech, that we reached the conclusion that we would need to study if the demands of indigenous women are actually arriving in the Brazilian judiciary power or not. And I wanted to know, and the students together with Sineya Wapichana, if these demands and the suffering and the anguishes that specifically have to do with women. So there's a big, there's an important gender component in the study, and this is documentary Heat Quentura that's available on YouTube. We detected that indigenous women depend directly on land and on these natural resources. They're the ones who preserve the environment the most, and they're the ones who suffer the most from droughts, from out of the time rain, increase in temperature. All of this has led to prejudice, to problems with women, and even violence against them. Not only domestic violence, but gender violence as a whole. Women end up having an impact with the overcharge of work, the search for water and food demands more and more effort from these women, a workload that has been strongly affecting their health. This is also seen in the documentary and is very present in the speech of indigenous women, as well as the increase in inequality and in economic insecurity that exposes these women to violence, exploitation, and sexual abuse. Within all of these issues that were instigated during this class and the study, we detected that even if they have a incredibly important role in facing climate change, they are always kept away from the decision making for resources. There's a very unfair contradiction here. Those who suffer the most from the climate change are exactly those people who participate the least in decision making. This really caught our eyes, and this is why the goal of our initial study is to investigate the intersection between climate change, indigenous people, and the gender perspective in Brazil, presenting proposals for the guarantee of women's rights as regards the judicial branch. You might be asking yourself, why would it be that a non-indigenous woman is here talking about this? First, I have a public commitment. Not only am I a judge, but I am a citizen. I am a woman. It's not because I'm not indigenous that I can't be an ally. Quite the opposite. I was implied by a speech from an indigenous woman, and I have all the tools for, together with them, try to improve their access to justice. So the study is justified by the urgency of this theme. It is the climate agenda that we're living. Brazil has been strongly struck by droughts, by floods, and the people who are suffering the most from this aren't me or the justices, or the indigenous women who are the forests, who are suffering from the droughts, from the lack of plants, from the dry rivers. They're the ones who are suffering. But the most complicated is these women who are in the forests. They're arriving, they're coming to the judiciary branch, and we're going to be presenting a little bit of these results, which are partial results because the study is about to be published. So we identify in these data collections, in this survey that we carried out, a bibliographical mapping. We're going studying if there were dissertations, studies, articles that were specifically on indigenous people, women, indigenous women, and climate change. We found climate change, we found a variety of articles on climate change, indigenous people, many articles, dissertations, theses. However, when we're talking about gender, the suffering that these women go through in relation to climate change, we found very, very little. We're going to say exactly how many. In the qualitative approach, in the second phase, and we're going to the third phase now, we had a study in the judiciary power of Brazil, in the federal court and in the national high court. We did not find demands from women specifically. And this made me, really impacted me, because we listened to a lot of cases of violence against indigenous women. Recently, it was noted that it was the indigenous woman who was arrested with a baby being raped inside a police station in the north of our nation. This demand was probably not adequately registered, but it's not a part of the judiciary as a violation of women's rights. It's a penal execution demand. But it doesn't show up in the judiciary sector. Who is this woman who was arrested? Where does she come from? What context was she in? Is she a mother or not? What ethnicity does she belong to? What region does she come from? Where does she live? That doesn't show up for the judicial branch. There's a lot of difficulty in understanding, and we'll be presenting some solutions. It's not all about the bad side of things, but we understand that the judges themselves, to understand what climate justice is, it's hard for them to have this, and this recognition to the rights of all beings to climate stability, the correction of inequalities. Why is it that this is going on in the northern region, in the south, who suffered greatly from the impacts of the rain? All of us see, but if you seek specifically for indigenous women, it's hard for you to find any studies regarding them. This is what we did. This is the invisibility of in the light of feminist constitutionality, which is the new interpretation of constitutional law. But here in Brazil, I have Professor Marina Fachin, Marina Bonata, Stefania Barbosa, and our own Christine Petter, who has a lot of work on feminist constitutionalism. So you'll see an erasure of these women in the judiciary branch. So with this study, and through a decolonial perspective of law, because law is still quite patriarchal, colonizing, and heteronormative. Decolonial studies have not reached law. They come maybe in graduate studies for those who are really going after. But judges need to look at, for instance, Maria Lugones Gata Spivak. These are authors from the global south that we do not see in law schools. But in our discipline, ethics and integrity, I always bring these authors and I bring these women to talk to judges because it is through education and above all through a judicial education with a gender perspective that I believe that we'll be able to advance, to turn this judiciary to something a little bit more fair. So these authors, such as Chicuriel, Hitalauro Segato, and two other authors that are quite important from our global south. This is our theoretical
além, claro, de outros autores como Achille Mbembe, e a gente tem que trazer
framework, including other authors such as Achille Mbembe and other indigenous authors, decolonial indigenous authors, and we also look at the issue of necropolitics. What is going on inside Brazil that the state itself allows and says who should survive to climate change? Who deserves credit? Who deserves value and who doesn't? These studies on necropolitics, this is what we must bring to law. In this panorama of climate litigation in Brazil, I'd like to bring the results that we've had. And I'm going to tell you, we couldn't find them. These studies, and I remember that I'm not alone. We have around 15 judges who study, one from each region of the country, one from each state. Other than Sinea herself and Andrea, who's here with us, the results of our surveys, both in the federal court and the National High Court regarding gender, indigenous women, look at the description, climate change, climate justice, and access to justice, the result was negative. There was nothing. Only 5 studies were found, 0 with indigenous authorship. That is, indigenous women are invisible, both in the bibliography and the theoretical framework, in the databases that we looked at, and also inside the Brazilian judiciary branch. And the women's demands are many. And so, I'm ready to go into the video because we have first and foremost to reflect. This study will be published. This is a partial study because the next step for this research is to have indigenous leaders tell us what they desire from the judiciary, what they expect from the judiciary. And I'm giving you a little bit of a spoiler. Well, we started this week to carry out the study in the region of Roraima. Andrea and Sinea were there because there are researchers, and we will also be there. And I'd like to tell you that indigenous women said the following in relation to what are their expectations. They're going to talk about access to justice. They need the internal regimen of indigenous leaders to be respected. They need intercultural education for judges. Depending on the sensibility of judges, they really claim they demand that judges are educated in this sense. They want specific training on Maria da Penha law, the female protection law. And they ask for a specific legislation to protect indigenous women from violence. They're suffering all sorts of violence, domestic violence, violence in the fields. These young women, young indigenous women are suffering in rural areas with sexual violence. It's enough. Is this arriving in the judiciary? I fear that what we get is very little, and when it arrives, it does not arrive with as a gender agenda. It comes in as an abuse or a violation, but without an ethnic, racial perspective, so that we may understand that at this moment when we have the gender protocol for the National Justice Council, and that was it is an honor for me to be introducing studies and teaching ethics and integrity for judges, so that judges can understand that this is their problem as well. This is not just a problem of indigenous women, of indigenous population. This is a problem of Brazilian society. This violence that we have, we really need to stop it with education. At least that is the role that we have as an educator of judges. I travel around the country to teach judges, to bring a little bit of understanding and a little bit of my anguish at the lack of access to justice of the most vulnerable people in Brazil, young people, women, and especially those who live in the countrysides and those who live in the forest. So I have a video that was made by indigenous leaders that hope, and with a variety of women, a variety of states from the state of Amazonas, state of Roraima, as well as Mato Grosso. Our study now is with them, and we will not ever leave them behind. This is a small research nucleus, but it will never stop supporting the indigenous cause. This was our commitment when we took on this work, and it's very, I get even emotional. I couldn't go to them because I had some trials, but Andrea went. But soon, very soon, we'll be directly with them, and they are participating in this study because this is their demand. We're just an instrument. So please, if we can see the video. Can you all see it, or do we need to turn off the lights, maybe? Can everyone see that? We're here straight from the Caracaranã Lake, the regional center of the Raposa region, in the Raposa Terra do Sol land. We're here with indigenous women representatives from all of the Brazilian Amazon. We also are here with our dear Kiliani from the Indigenous Council of Roraima. At this moment, we'd like to send this video to this important seminar that will take place in Brasilia. And at the invitation of Justice Herman, we're sending this video to show the strength of indigenous women in this theme of climate justice. We're here at Caracaranã discussing how indigenous women participate in this space, which is a UN space, but it has to do with a variety of different themes, and that indigenous women have participated in, such as mitigation, adaptation, financing, but especially the right of indigenous women to be in these spaces and to bring their voices to the fore. So it's very important to know that this exact point in time, judges, appeals judges all over Brazil are carrying out a study to see how women have been accessing justice, how many documents have arrived the courts. And at this point in time, this result is extremely important to leverage public policies so that we may really have a space for women to get closer to justice and really get to know mechanisms where they can bring their accusations of a variety of different instances in Brazil. We'd like to thank you, and I'd like to hear our dear Tushawa. We really want to thank you all, that our voices may be heard, and we have women from many different regions, and also from Omiabi, Koyabi, as well as from the Global Alliance. So being together, and especially talking about climate justice for indigenous people, and especially with this focus on women, indigenous women in these spaces. And here we are here with Sineya, who is the co-president of Campus, who is also the coordinator of the Territorial Environmental Management Unit for the Roraima Indigenous Council. She's the one who represents us in these spaces, and together we're here sending you this video within this space where we're sending you this video so that you can see how important it is to hear the voice of indigenous people. Thank you so much to Shawa Kiliani. It's very important to say that we have the representation of indigenous women globally speaking here.
Não, é um vídeo curtinho, mas que nós temos a Sara Omi, dá aceno aí, Sara Omi.
Sara Omi, she's the woman that represents us in the Global Alliance, all the indigenous women globally speaking. So I'm going to send this video for you to get to know our work and have the space where women can take their voices to be heard. Indigenous women, where are you? We are here fighting for our rights once again.
Muito obrigada, desembargador e professora Adriana.
Thank you very much, Professor and appellate judge. I think it's the most important thing. Nothing about indigenous women without indigenous women. They should be here. They're the ones who should be speaking and allowed to speak. And us, we're on the other side of the legal system. Myself as well, appellate judge. Our place here should be of listening, hearing what is said to try and understand, and try and do justice, take the equality that is in our constitution to these indigenous women. So now I'm going to hand over to Dr. Samara Patajó for 20 minutes. Just about the indigenous land that I spoke of was Paracana and Pará. To Dr. Samara, we're anxious to hear what you've brought for us today. Good afternoon. Thank you to all that are here in person. I greet the table here, Justice Daniela, Appellate Judge Adriana, and that also brought indigenous women's from Roraima's voice here. Here's my self-description. I'm an indigenous woman. I have light skin, a long, straight hair, glasses, and red feather earrings as well. I'm from the indigenous land Coro Vermelha. I would like to greet my brothers, indigenous brothers and sisters, those that are watching online as well. And something that's been very present of indigenous talk is saying what biome we belong to. I belong to the Atlantic forest. And a lot of people outside of Brazil think that we just have the Amazon biome, that there's indigenous people in the Amazon. Actually, not even outside Brazil. There are Brazilians that also think that. They like to say that the other biomes also have people that exist and resist, preserve their biome. Especially my Pataxó people that resist in the coast of Bahia, the place where the colonizers dare say that Brazil was discovered, but Brazil was actually invaded. So I have the pride of telling people where I come from, because we are fruit of the resistance of this Brazil that was constituted and so insists in killing indigenous peoples, treating us as invaders of our own territories. And so the Northeast indigenous peoples and of Brazil as a whole still resist after enduring many years of fight, suffering, but also future of hope. Also speak of the voices of indigenous women. It's a pleasure to be here at this panel, be able to talk about these subjects. Though I may be a lawyer, as the Justice said, I acted in the indigenous movement. I'm currently a counselor, advisor for diversity in the Superior Electoral Court. I'm not going to talk as an institutional person here, but I'm going to talk as an indigenous woman. And in the last few years, I've seen process of fights where many indigenous women are protagonists from the north to the south of our country in the different biomes. My speech here also comes a little bit motivated and guided to what we lived collectively 15 days ago in the 4th Indigenous Women March. that took place here in Brasilia, and also the Indigenous Women's Conference also took place here, where we united more than 5,000 indigenous women, representing more than 100 peoples and of the 5 different Brazilian biomes. The Indigenous Women's March is the 4th edition now. The first one took place in 2019. This march happens every 2 years and is organized and coordinated through National Coordination of Indigenous Women's Warriors, ANIGA, Organization of Indigenous Women, that represents these different biomes and contexts. The National Indigenous Women's Conference happened for the first time, and I'd like to highlight this something that that Minister Guajajara said during the conference. During the conference, the minister asked her, "Why is it only now that we're having an Indigenous Women's Conference, and why was it being done specifically since in September this year we're going to have the National Women's Conference organized by the Ministry of Women, and why wouldn't it be done together?" Indigenous Women's Conference together with other women. And I liked Minister Sonia's answer, saying that we took over 5 centuries so that Indigenous women could be heard directly. Each woman to be able to bring their reality, their pain, directly from their territory, saying what they go through in their biomes. And so it's more than fair to have a conference, a place where Indigenous women can deal with their own specificities. And the result, the conference was a document with proposals where they have 50 priority proposals that were approved in the plenaries, organized in thematic axes. The first one was management and territorial right, climate emergency, public policy and gender violence, health, education, and ancestral knowledge transmission. All this, I started talking about the Women's March and the conference, all to reinforce something that we are, to say that we are developing a discourse and a political action with a gender perspective that has as its base, especially that what we call body and territory. And that is what we want to talk about, the territory that is our body, the body territory. So with the census of the Institute of Statistics of Brazil, we've grown as a population of 1.7 million indigenous people, represents 0.83% of Brazilian population, 105 peoples, 165 peoples, 305 languages, and most of indigenous people in census are women. We are 50.8 and men are 49.2. However, this numerical dominance of indigenous women is not translated into fairer or equal lives, and nor does it guarantee our autonomy or the protection of our own territories or in our villages or in urban areas. We continue being the target of discrimination, being made invisible, and that makes us vulnerable in many ways. In our territories, though our people suffer impacts and advancement of mining, of illegal fishing, of illegal fires that compromise our sacred places, and also to delay the state to demark our lands. The effect of all this affects women, indigenous women, in a disproportionate way. That's because our territories, our land, has an intimate connection with our being as a woman. On a point of view that there is an intimate and intrinsic relation between the territory and us indigenous women. And it is in this context we talk about the territory body. And especially within ANIGA and international coordination, a national coordination, where through our reality and our biomes, we've been adding our strength to this fight. I like to talk about this a little bit theoretically, because aside from being in legal spaces, I'm also in academic spaces. And I really liked what Appellate Judge said. I want to read, I want to see these results. I recently wrote an article, still not been published, but it talks about the body territory and went to look for authors to write about this. from what is called the feminist community movements, and is led mostly by indigenous women in Latin America, especially in Bolivia and Guatemala, as the attempt to recreate feminist thoughts, to reinterpret these concepts from the historical reality lived by us indigenous women. Some authors are Lorena Cabinal, Rieta Paredes, some authors that speak about communitary feminism. In general lines, communitary feminism tries to denounce from the reality of indigenous women that the colonization isn't just about land, but also our bodies. And as they practice a domination, control, extermination, or violence, implies, first of all, from us indigenous women of having this desire for justice to recover our body, our territory body, our body territory from this violence as well as our territory itself, as a political emancipatory act. Within this perspective is that this notion of territory body, the idea that us indigenous women's fight is also manifest when we confront capitalist development models, patriarchal ones, such as exploitation of our territories, minerals, of all its riches, because our bodies are completely connected to this territory. And in this sense, our fight is intersectional, because it's not limited just to the physical defense of the lands we step on, the rivers we see, but as defense of our bodies themselves, understood as extension and continuity of the territory. There's a very well-known work, and I think it's one of the works that breaks the burst the bubble. He doesn't use the term territory body, but he talks about a part where he says we must admit nature as a huge variety of forms, including every piece of us that are part of everything, 70% water, and a bunch of other materials that make us up. Yesterday we heard Davi Kopenauer, a shaman, that also said about this intimate relationship with Mother Earth and the obligation we have with care that we're requesting the society also bring their attention towards that. And this is how I wanted to bring you to think about this concept. Another thing we'd like to talk about is that if in the past, the history books written by the conquerors, they omitted talking about the physical violence that us indigenous suffered, sexual, cultural, and heritage violences we suffered. And it caused the suffering and extermination of many peoples. And that was very felt on our indigenous women's bodies. The violences that we serve today, the temporary threats happening in front of the entire world and society. Just open social media, Google, ask AI, they'll show the vulnerabilities we've been suffering. And especially these right violations that compromise our biomes, food sovereignty, and the demands for all this is happening. As I said, we're developing a discourse and a political practice, and also legal, I would say, to a gender perspective that has as its basis our body and its territory. So that means that any policy, jurisprudence, or case law that looks for the indigenous people's protection should also recognize this integral dimension of our body with our territory, with our culture, with our ancestrality. And we're trying to do this as indigenous women, and we need allies. We've recently seen through organizations that maintain protection under human rights, appellate judge cited the CNJ resolution implements the protocol for judging with gender perspective. But the central message that I would like to leave you here with this international symposium for the academic, legal public is that the thought I would like to leave you with is how can we incorporate this concept and the perspective of the territory body in the jurisdictional or jurisprudence of the Inter-American Court, human rights. And this demands that magistrates have an interpretative approach that is more sensitive and connected to these multiple dimensions that we live through and the rights violations we face, especially as Indigenous women. This broadened reading would need integrated legal concepts with Indigenous experiences that only we go through. So the construction of the concept, body, territory, is theoretical, legal, political, talking about this impossibility of dividing between women and their territory. This concept demands not just a normative change, so no matter us having protocols, conventions, declarations, we must have the decolonization of paradigm that still sustain the selectivity and partiality of the system, where us, Indigenous women, being full legal entities, includes also recognizing our territories that we take care of, that we represent, in its many different dimensions, physical, symbolic, spiritual, and ancestral. This is the central message I'd like to leave you with, so that we may think in this territory body like a sentence that the mother of Brazil is indigenous, so all of us, sons of this land and country, must preserve and respect our mothers, grandmothers, and especially existential continuity. In my language, obrigado is aweri. So aweri for the opportunity of being here. And thank you everyone here. You've honored your entire ancestrality today, your mother, your grandmother, your land. Thank you very much for coming here to share with us this reality. And what is very interesting is this invisibility of women, be it white, black, indigenous, or sufferings, always placed somewhere where it cannot be seen. And so the importance of the symposium on the right of indigenous people, having this panel so can speak about indigenous women. I thank in name of our Justice Herman Benjamin and STJ for your presence here. Be it the appellate judge opening eyes and the new judges that are arriving and are here to this reality that was left as such for 500 years. It's late, but not too late. Thank you very much for this very emotional explanation. So at the request of the President, I'm going to hand over the certificate here. And I hand over to Samara Patachó our thanks for being here. And hand over back to our Chief Justice, who had the great idea of undertaking this symposium with this panel.
Muito bem, nós estamos nos encaminhando para o final.
Very well, we're reaching the end. And I would like to thank Justice Daniela Teixeira and also our two other speakers.
Para deixar uma mesa estritamente feminina.
I wanted to make this a strictly women's panel. I felt a bit like an intruder. That's why I left. But actually, I went to sort out administrative issues of the court. But when I was coming back, I looked at the table and I saw a table just with women. So I requested Justice Daniela, please remain here.
Em primeiro lugar, peço ajuda do nosso cerimonial.
And I would like to thank for the help of our ceremonial here to do the transition of the table. Without further ado, I invite my colleague Justice Benedito Gonçalves, Professor Stacy Leeds, I'm going to introduce in a second, and also Dr. Cláudio Providas.
Presidente desta sessão é o meu
President, the chair of the session is my colleague, Justice Benedito Gonçalves,
que é o atual
the current
da Escola Nacional da
director of the National School of Judges,
escola que
IMFAM, the
reúne
school that
todas as
gathers all
dos estados,
schools of different states, all the judicial schools in all different states, and all the federal schools. And as has already been mentioned by the judge from Rio in the previous panel, INFAM, the National Judges School, has a master's, which until not so long ago was the only one of its kind in the world. When I took over
a diretoria da escola,
the
nós tínhamos convênios
school, we had partnerships, and we still do have partnerships with the main universities, law schools of Brazil,
para mestrado, doutorado,
masters, PhDs,
e
or
também
judges,
com universidades
as well as some foreign universities.
pareceu que seria
And it
importante
seemed to me that it would be important to create a master's program for judges
com juízes,
with judges,
mas não há
by
precedentes,
judges. But there are no precedents
nem no Brasil, nem nos
in Brazil or in other countries.
os precedentes que
The
há
precedents that we do have
estilo.
are in that same style. Partnerships with universities and federal and state judges can do their masters and PhDs or even postdocs.
No Brasil,
In Brazil, the creation of a master's program
no mínimo 4
takes at least 4 years.
e doutorado, às
And a
vezes, chega
PhD
a 8
program, maybe even 8 years,
os mecanismos de
given the mechanisms of control for doing this.
dos argumentos
One of the internal arguments in our National High Court
nós não
is
queríamos
that we wouldn't have the conditions of making our own master's program. Well, then I decided
da Infam, e se recorda, eu resolvi fazer censo
to have an academic census of Brazilian magistrates, and I was surprised.
nós devíamos ter
I
alguma
thought
coisa
that we
em
had
torno de
something
300
like
mestres e
300
doutores. Fui surpreendido
masters,
porque
doctors.
no Brasil,
I was surprised because in Brazil at that time, certainly
havia,
there are more,
na
certainly.
estrutura brasileira,
At that time, Brazilian
havia
magistrates, we had 1,250
doutores,
masters,
pós-doutores.
doctors, and postdocs.
Doutorado
And
não só nas melhores
with PhDs not only in the best universities in Brazil, but also the best universities throughout the world.
nós estávamos em
That is, we had the condition to
mestrado.
have our own master's program.
Conseguimos aprovar
And we were able to approve this in the Ministry of Education
uma burocracia
with a
gigantesca.
huge amount of bureaucracy in 8 months.
E já estamos na nossa
We're already in our 4th
de mestres
class of masters who study
disciplinas
in a course designed by us, which has the concern of raising data, carrying out research that might have immediate or medium-term relevance for the exercise of their jurisdictions. And in second place, that have the goal of, through this master's program, of integrating the country's judges. So I'm very happy that it was during my management that this master's was approved, first by my colleagues and great friends.
Internamente, meus colegas ministros e também no Ministério da Educação.
Colleagues, judges, as well as those in the Ministry of Education who helped us out. So it was the first, but it's not the same because, not the only one, because Spain, that has an excellent judges school, has approved their own master's programs it into its own master's program, and not with the University of Madrid or the University of Barcelona, the best universities of that nation. Justice Benedito has been a magnificent dean. In Portuguese, we call a magnificent dean. That's the way that we don't call them Your Excellency. We call them the Magnificent. So we call him the Magnificent when we want to kid around with him, because he is the dean of our school. And he comes from Rio de Janeiro state. He was a federal judge, a career judge. Afterwards, he was a member of the Federal Court of Appeals of the Second Circuit, which is the state of Rio de Janeiro and the state of Espírito Santo. Not only that, but he's a dear, dear friend. We were colleagues in law school in the Federal University of Rio. Well, we're not going to tell you what we were like in college, okay? We won't go into that. Well, I can tell you that we were happy in law school in Brazil. For those of you who are colleagues, you're 5 years in law school. That means that you have a lot of time to do other things as well, especially going out to bars, parties. We also study a lot of law. Now, with the floor, Justice Benedito Gonçalves, and allow me, Justice Gonçalves, for us, it's an immense joy to receive Professor Stacy Leeds here. In the United States, they're both women, and there are only two deans of law, directors of law schools who are indigenous, and she's one of the two. We are extremely happy to receive her here. We hope that this is the first of many trips to Brazil, first of many meetings. Next time, we'll go together to an indigenous land, or maybe more than one, who knows? So that you can, because coming to Brazil and not going to an indigenous land, especially when we're here in the Brazilian savannah, in the Brazilian cerrado, is almost unforgivable. Of course, unless it's your first time. With that, I'll pass the floor to Justice Benedito Gonçalves, and we're also going to get the intervention of the director of the UNDP in Brazil, Claudio Providas, someone with huge global experience, who we who travel think that we travel a lot. Well, he worked literally the world over.
A sua experiência é bastante
Their
relevante para
experience is
nós,
very relevant to us,
e é alguém que goza da
and he's someone who
grande
has the trust
Achim
of a
Steiner
grand friend, Ahram Steiner,
o chefe
who was
em Nova York e
the
antes foi o chefe
UNDP boss in New York, and before that he was
global,
the
tanto no
global
PNUD, diretor-geral,
PNUD boss.
no PNUD. E o PNUD é parceiro
He's an
importante
important partner
do Superior Tribunal
of
de
the
Justiça.
National High Court.
Não é parceiro no sentido
It's not
de
a,
nos
they're
dar
not a partner in the sense of that they give us resources, no.
Aqui é
Rather,
cooperação distinta.
it's a distinct kind of cooperation. We
Entregamos os recursos
give them the resources
PNUD
to the
para
UNDP
administrar
so that the UNDP can manage these resources.
Se
Usually,
vê
when
título de
you see at the title of an event,
PNUMA, o PNUD,
UNDP, and you say, oh, okay, they're contributing financially. No, this is the opposite here. We give them the resources, and they make it easier for us to manage everything and the logistics because they have huge experience, technical expertise as well. Anyway, Justice Benedito, you have the floor. Thank you so much, Chief Justice. Good afternoon or good evening. I think it's already good evening, right? Good evening, everyone. It's 6:30. It is with immense satisfaction that I'm here to chair this closing conference, keynote conference, and I am responsible for fertilizing and watering the seed that Chief Justice Herman has planted in the judges' school, something in favor of judges' education. Here at the school, we're not here to train them in academic courses. Here we do the filtering of all the different profession courses so that these candidates can become judges, so that they can learn how to be judges, they learn how to respect ethics, so that they can respect human rights, so that they can work with new technologies. So that is my responsibility to continue a great legacy that Justice Herman has left us in history. Still be speaking a lot more about this. And I also have the honor of chairing this conference, leading this select panel in the name of Chief Justice Erwin Benjamin, my longtime friend, as Caesar has already mentioned. With his permission, I'd like to congratulate this event. I heard that in 2023, we also had a symposium on indigenous populations, and at that time, there was the participation of Professor Stacy Leeds, an enthusiast of the Amazon. Her vast curriculum, I tried to think of how to select it. She acted as a judge at the Supreme Court of the Cherokee Nation. In academic life, she's the dean of the Law School of the University of Arizona, and there's so much more in academics as well. Ever since 2022, she acts as the dean of the Sandra Day O'Connor Law School and University of Arizona. She was the director of the Law School of the Arkansas University. She was the first indigenous woman to lead a law school in the United States. In 2024, she was elected for the Philosophical Society of America. She's an experienced leader in law and in higher education with a specialization in American indigenous law, tribal governance, property, economic development, and Cherokee legal history. And to wrap up so that we can listen to her more than me, of course, I would like to quote a line of thinking from a great photographer who was in love with the Amazon, Sebastião Salgado, who guided us towards justice, care, and ancestrality. Quote, so that life and nature may overcome the extermination and destruction, humans throughout the world need to participate in their protection. End quote. I hope that these words can resonate in each and every one of us as catalysts of action that may motivate us to transform sensibilities into protection, memory into politics, art into justice. With the floor, Professor Stacy Leeds.
evening, and thank you, Justice Herman Benjamin and the STJ, and all of the justices of the National High Court for allowing me to participate in this conversation. As is customary, I would like to start off with a brief introduction in a Cherokee language, and as a Cherokee language learner, I have been told not to apologize for being a learner, as similar to the theme we heard earlier today, every day that Cherokee words are spoken out loud is a good day. Osio Nagad, Stacy Dawado, Jijalagi, Jalagi Uniji, Panoleg, Haweta, Talakwa Janela. I introduced myself and told you that I'm a Cherokee person from the Cherokee Nation, which is now located in the state of Oklahoma. It's in the south central part of the United States. I am a mom to one son named Hunter, or Ganoleg in a Cherokee language, and our permanent homeland is in Tahlequah now. It's the capital city, and it is the government seat of the Cherokee Nation. My son is also a descendant of the Choctaw Nation, the tribe of his father, and Howeta is how you pronounce his name in the Choctaw language. My last name, Leeds, comes from one of my great-grandfathers. His family were immigrants from the UK who came to the Cherokee Nation in the late 1800s looking for Reuben-born work as migrant farmhands. We think it's important to communicate our existence in a way that's recognizable to people around the world and in terms of political affiliations and nationalities. And so I describe myself here and always as a dual citizen of the Cherokee Nation and the United States. And I talk about Indigenous nationhood in this way, although it may be provocative or strange for some to hear for the first time, that it is in of itself a sovereign act and a refusal to be othered, othered by or felt to be less than other nation states. We believe that words matter, and citizenship is an important piece of who we are in the Cherokee Nation. Viewing our own sense of belonging with each other, but also responsibilities to each other, and also how we view our own power, sovereignty, and stature in this world. And these are not just words that I use as an academic in this matter, it's words that the Cherokee Nation has carefully chosen to employ in our own laws and in our own constitution. Just as if we don't speak our language, it will die. We also believe that if we don't speak about ourselves in international matter, that no one else will. So although it's a very complicated history that leads us to this moment, I'm a very proud citizen of both nations. But it is just that, a nation-to-nation relationship and also a government-to-government relationship between the two. Next year, the United States will celebrate 250 years of nationhood as its reminder that we have a very long history in the Cherokee Nation and other indigenous nations inside of the United States. When we think about 250 years, it's a very short time frame as part of our collective history, a blip on the radar. And by way of longevity in this hemisphere, it's important to remember that indigenous nations are the mothers and fathers here, and not the wards or the children some external laws or text or narratives sometimes describe us over time. And just as we heard earlier today from Brazil Congresswoman Cecilia Acriaba, when she talks about indigenous peoples here in Brazil and their ongoing and sustained resistance over these past few hundred years. At home in the Cherokee Nation, we are not simply one of the world's indigenous peoples or one of the 570 tribes now within the borders of the United States. We are simply a nation. And we have our own courts and our own laws, and we exist relative to the United States, both as pre-constitutional and also as extra-constitutional entities. We have an undeniable political and territorial boundary that was bargained for in exchange for our homelands, and we have government institutions and an economic impact that is on par with some of the countries that I've visited around our globe. And the only two reasons that we are not universally reviewed as nations is that first, for several centuries, the othering by others narrative, and then sometimes we have bought onto some of these narratives ourselves. And then second is, of course, our physical presence or location inside the borders of the United States that were drawn around us with or without requisite legal or otherwise consent. And so there's a real misconception that this type of nationhood that I speak of for Indigenous peoples inside the United States is because of a treaty framework. But I want to make it clear that it's actually the minority of Indigenous nations inside the United States that have ever entered into a treaty relationship with the United States. The majority of Indigenous peoples inside of the United States have no history of treaties with the United States. And yet the concept that tribes, even very small ones, possess the power of local governance extends to most, but not all, of the Indigenous communities that now find themselves inside the United States. There are populations such as the Hawaiian people that may have to choose a different framework or a different advocacy strategy, as I would championing their rights, of course, to chart their own future, just as I today stand in solidarity with the Indigenous peoples here inside Brazil. And now I know that Indigenous communities all over the globe are very diverse, and they come in all shapes and sizes, and they come in very different views of property ownership or dominion or stewardship or autonomy or relationship with the land. And all of that, of course, is best described in their own languages. I think the single biggest misconception about Indigenous peoples is the simplicity of thought that suggests that Indigenous peoples are a monolith under international law. And when we think about international law of or international law over Indigenous peoples, please always keep this wide diversity of experiences in mind. Every Indigenous community has experienced or is still experiencing colonization in a different time and in a very unique way. I know that many Indigenous communities share with the Cherokee Nation a very clear pronouncement akin to nationhood, but that they go even further than the Cherokee Nation. And at this point, there are several Indigenous nations around the globe that issue their own passports for international travel. And there's a growing view that the international definition of Indigenous peoples, while an important first step, does not adequately capture who we are, and in fact, it likely devalues who we are and what we are. And it can also delegitimize our own governing institutions and our laws and our history or political and cultural realities, and also our current stature among all the world's nation states. The framework of international Indigenous rights should be thought of as a simple threshold of minimum rights and as establishing norms for engaging with Indigenous communities. Please do not fall into this trap of thinking that the United Nations Declaration on the Rights of Indigenous People is merely aspirational, or that it's a box to be checked before a country can proceed with what they want to do. The Declaration is very modest, yet very hard-fought beginning, and it's not at all an end or a ceiling for possibilities. The stories of the Cherokee Nation, although very unique, they do track on to what we've heard here over the last 2 days. A colonial past of violence, of forced removal, of uncompensated land theft, of boarding schools, and sometimes even forced adoptions, and certainly attack on language and cultural lifeways. Today's ongoing colonization is more subtle now when it comes to Cherokee Nation, but it still falls in 4 important categories that I'll highlight. First is the ongoing land insecurity due to federal decisions that unilaterally delegate real property decisions over Cherokee lands to state courts rather than having the tribal courts make those decisions. Second, environmental insecurity due to a lack of federal recognition of tribal power to regulate water quality of the waters that flow through our territory. Third, economic insecurity as a result of coercive tax laws that prohibit tribes from being able to maintain a sustainable tax base so that tribes can fund their own government functions. And then fourth, ongoing struggle for full criminal jurisdiction and autonomy to tribal courts to be the exclusive venue for adjudication of violent crimes that occur inside Indigenous territories. Now, in Cherokee culture, we recognize that the world has 7 different directions: north, south, east, west, up, down, and the place where we are now. And so right now, in the present, And we know that we're in an amazing and important time and place. And yesterday, Professor Torres mentioned yesterday this moment that we're in. We are in an indigenous moment worldwide. And I think the moment has three parts to it. First, there is an awareness that indigenous knowledge on how to steward the lands and the ecosystems can be employed and maybe must be employed for the good of the planet. Second, there have also been important moments of indigenous justice with some very important legal and judicial advances around the world. And yet, third, there still are countless indigenous communities that are waiting on very basic external validation of what they already know to be their land demarcation, so that this concept of free, prior, and informed consent can even begin to scratch the surface. And I remind us, as we all go back to our classrooms and our courts and our communities, that the rights of indigenous people need not be stagnant, and most importantly, need not only be heading in a negative trajectory. There are so many more choices and mechanisms as we move forward than these single black and white choices between extinguishment of rights on one hand and affirmation of rights on the other. And as we heard this afternoon in the panels, we are daily identifying new governance frameworks and readjusting the balance of power based on new experiences and circumstances. So there's not a one-size-fits-all approach that holds indigenous people and autonomy to some single fixed time. And as we leave to continue our own work, I urge you all to find your optimism and recommit your duties of the small victories that are emerging all around the globe, and know that there is so much more possible. I want to applaud the fact of this gathering. In many national judiciaries, erasure of indigenous histories and realities is often the norm. And absent some court case that comes to the judicial tribunal just by the initiations of really narrow litigants that have standing before the court, it takes real leadership and courage to do what's been done here over these last 2 days. The Cherokee Nation story has been one where our political power and our legal status has been both constricted and expanded over time. And therefore, we are always cautiously optimistic of indigenous affairs within the United States because our story has been one of inconsistency and a lot of whiplash cycles. We have learned over time that we must advance our rights in very different ways across time and space. Sometimes it's in the media or the press, and then sometimes it's in the court systems. And sometimes it's just turning all of the noise around us off so that we can laser focus on our own nation rebuilding. And oftentimes from learning just from the outside world with an open mind. And that's why for the past couple of days, for me, it's just been such an honor and a real intellectual feast. And I am so grateful for the new relationships and the potential for new partnerships that has been forged. It's also important to remember that within each of these international frameworks that we have discussed, the rights of indigenous people are not new rights, but that they are rights that have already been there. Instead, central governments come to their power and assume their sovereignty, subject to the pre-existing property rights and other pre-existing rights of the indigenous peoples who are already there. Indigenous nations, whether they are big or small, already have lived their pre-existing law and self-governance, whether or not the outside world could see or identify it or not. I want to talk about the importance of various judiciaries today, tribal courts, state and federal courts, but also international forums. Domestic courts in particular have played very big roles historically in the modern sense, positive roles and negative roles. But I want to think the courts are oftentimes left out of these international indigenous dialogues, particularly given the immense power that they hold in this space. Where countries have failed to protect or uphold indigenous rights, sometimes it's the domestic courts that have stepped in to make very big decisions and become the catalyst to get those countries to resolve issues that could not be resolved in the typical diplomatic or political process. It's very hard, as you all know, to ensure, much less expand Indigenous rights or by constitutional amendments or federal legislation, because Indigenous populations usually account for 3% or less of the overall population. And recognition and enforcement of Indigenous rights is typically presented as a win-lose proposition. If Indigenous rights are recognized, then someone else must lose their perceived rights as part of that pie. Independent judiciaries that uphold the rule of law can speak power, truth, in ways that are very difficult for a populist-based or majority governance structure to speak. And we have seen this in recent decades in Belize with the claims of the Mayan people in the Toledo district out in the south, where their national Supreme Court deferred to local Indigenous laws on substantive property rights definitions. And we also saw this recently in the decision of the United States Supreme Court involving the Muskogee Creek Nation, and then by consequence, similarly situated Indigenous nations in Oklahoma that had their territorial boundaries reaffirmed, even after a 113-year gap where the United States refused to recognize the existence of those territorial sovereign boundaries. It was one of those legal cases where the law on the books did not match up at all with the law on the ground, and the United States Supreme Court, by a precarious 5-4 decision, corrected that mismatch. But there are also times where the domestic courts can assume a position that is colonial and take Indigenous rights away where those rights had previously been recognized by either Congress or by an executive branch. And one of the most important topics in the world seen today with respect to Indigenous peoples is, of course, what is the best way to engage with a modern Indigenous peoples or Indigenous nations? The United Nations, the Organization of American States, and other entities have all coalesced around this concept of free, prior, and informed consent as a standard to be applied. It's a very simple and straightforward concept, right? In advance of any action, Indigenous people need to be presented with all the facts so that they can objectively weigh both the positive and the negative impacts of these proposed actions, and then their consent or their objection can be registered to that action. And with the understanding, of course, that consent is a fluid concept and that there is the duty of transparency and free-flowing communication, and that throughout an action, consent can be ultimately withdrawn. Now, many governments have gone down this path in various ways, creating executive policy departments within central governments to implement this type of protocol, even though some in governments call this consultation instead of free, prior, and informed consent. But practices also provide for judicial forum to enforce these protocols. And usually this is found in the judicial remedy of injunctive relief, to preserve the status quo on the theory that once environmental damage is done, it cannot be reversed. But in some countries, there is a different dynamic at play. And that is, Indigenous people and Indigenous nations can also be business partners in joint ventures. Indigenous peoples and their communities are in different ways people who have different wants and needs, and they may reach different decisions once they are afforded the grace of their own decision-making process so that they can make decisions without their conclusions being presumed. Often governments are afraid of consultation because they presume that the decision of a local community will always be anti-development, and that's not true at all. And it's very patriarchal to substitute mainstream predictions for actual Indigenous deliberations or Indigenous governance. And as I talk with Indigenous populations all over the world, what Indigenous people want is often what everyone else wants: education, healthy environment, care for the most vulnerable in their community, children and elders, and the agency to make decisions for themselves. And there are sometimes important factors that become deal breakers in the communities, but oftentimes that community wants to just make sure that their voice is heard and that they are the decision makers, and that development, if it moves forward, is done in a sustainable way where there's not severe harm, while others take extractive gain by leaving behind poverty and environmental cleanup in the wake. Indigenous people have always been traders and have engaged in commerce. It's why we have regional trade languages in this hemisphere. We've done this for centuries. And as I conclude, I want to introduce one additional angle, that sometimes where governments cannot get things right, private actors can sometimes step in and do the right thing in their own private regulation of their own industries. We've seen this with several sustainability initiatives across the globe. Concepts such as sustainability consortia set forth best practices for industry, and they subscribe onto these plans by incorporating free, prior, and conformed assent, even where the government fails to do so or fails to require that. For them, it's a basic long-term business calculation of the risk. And companies know that if they respect tribal consent, they will be a known entity and they will be a preferred partner with other indigenous communities. And perhaps there can be economic pressures within the industries that turn up the pressure or force some action. And I'll give one example of how this played out in a context in corporate America. For decades, indigenous peoples have been very much bothered by the use in the United States and elsewhere of the names, image, and likeness and racial stereotypes of indigenous peoples in sports mascots. Most notably in the United States, in Washington, D.C., the American National Football League, there was the head of an indigenous man with a dictionary-defined racial slur attached to it as a sports name. And although Native people had objected for decades, there was no solution in the intellectual property law to stop it. There was no way that the indigenous people themselves could stop it on their own, and there was not the political will that the US government or any other government was going to do anything about it. But certain corporations, as part of their corporate responsibility plans, said enough is enough. It's inappropriate. We will not support that kind of discrimination any further. And so it didn't align with their, at that time, inclusive efforts. So it was eventually stopped and a new mascot was named. But in the end, what really caused it was the financial pressure to do so. So I end with this. Don't minimize or give up on the role of domestic courts in upholding the rule of law. More indigenous lawyers and clerks and judges will help make that judicial education process possible. Judges who proceed with open hearts and minds can make all the difference in the world. Don't forget or completely dismiss the role of private actors in this space. Keep pressing those central governments and international bodies. Indigenous peoples, keep your strength and amplify your voices and be willing to be partners with each other. We are living in this place that we are in right now, and may we all hold each other's existence as sacred. If we do that, and we internalize that in the spirit of our laws, we can all make a profound difference in whatever role, big or small, that we play. So with that, Wado, thank you for having me. Obrigado. Donadago oi.
Vamos passar a palavra de imediato, Dr. Cláudio.
Let us pass the floor immediately to Dr. Claudio Providas, the UNDP representative in Brazil, for his reflections.
Não, funciona.
Funciona. Bueno, boas noites a todos, excelentíssimo senhor ministro.
Good evening, everyone.
Hernan Benjamin,
Hernan Benjamin,
Superior Tribunal de Justiça,
Chief Justice of the National High Court, Chair of the National Justice Council, Justice Benedito Gonçalves, Justice Teixeira, Professor Leeds. Pleasure to have you here. I'd just like to ask a few minutes to recognize you because I was thinking about some of the words that Justice mentioned and the professor spoke.
I have to say welcome to Brazil. You are in an amazing place that allows to have a vibrant democracy where you can scream, yell, look at change, enact change, effect change. And before coming to Brazil, I knew about Minister and Judge, Supreme Judge Benjamin, and it's because of people like him, and we have many in Brazil where change happens. So you have stewardship, you have sponsorship, and you have leadership. And I want to join that with what Professor Leeds she was highlighting the importance of talking, of education. I happen, as Mr. Benjamin mentioned, in a very Socratic principle, I try to accept my ignorance and learn from my mistakes. But I worked in a couple of neighboring countries that have, one of them a very large, almost 80% indigenous population, and in two constituent assemblies, and then designing and implementing new laws. And what Brazil has made is not only have a rich constitutional text and laws, but it's making sure that those can be applied. If you don't have the means to make those rights effective, there's actually no rights or no justice. And they're working on both, making sure that those rights can be enacted, but also that the justice is being more transparent, effective, and can reach the ones usually left behind. But the continent is in an historical struggle, and what I want to acknowledge is the concrete steps. And then the maturity. Again, Mr. Benjamin was talking why the UN in middle-income, upper middle-income countries like Brazil. And it's a question of navigating some of the hurdles, and Brazil has and does use the multilateral. It critiques and needs criticism, but use it in a very intelligent way to make sure that there's effective progress. Current minister and former governor of a very poor state, when I arrived, told me if I had to choose an international standard, and was the Human Development Index, because I knew that eradicating poverty or reducing poverty and inequality in my state would take me 15, 20 years. And in political cycles, there's no minister or state official that can survive, usually before 5 or 10 years. The plans tend to be polarized and politicized. Anyway, welcome. It's really a pleasure. I want to switch now to Portuguese, and I hope the interpreters can bear with me. I'm stronger in Portuñol than Portuguese, but I will try to follow the script. También quiero reconocer a todas las demás autoridades, lideranzas indígenas, representantes de las comunidades internacionales, académicos, magistrados, gestores públicos y miembros de la sociedad civil y de prensa. Es una honra estar en nuestra herramienta y le agradezco una vez más.
In the closing, I'd like to once again thank Chief Justice Herman Benjamin for being here, for the invitation to be here. And above all, this is a theme that we could always keep on talking about and discussing. And it's an integral, it's something that's holistic. We need to think about social cultural aspects, and this is the second international symposium on Indigenous Peoples Law that is focused exactly on this issue of increasing knowledge and sharing experiences. Throughout these 2 days, the National High Court, which is the maximum guardian of the application of infraconstitutional law in Brazil, has opened its doors to a dialogue that transcends geographical borders and institutional borders. Here we gathered academic, traditional knowledge, experiences of courts and indigenous communities, of public administrators and civil society organizations. We approach critical issues that shape the life and future of indigenous communities in Brazil. The discussions encompassed 4 interconnected pillars, each of them essential for the understanding of the complexities and challenges faced by these vibrant cultures. I'd like to start with the essential. The symposium only makes sense because it's centered on the voices of indigenous peoples. And as as Justice Benjamin mentioned, it's fundamental not only to lend voice to indigenous people, but to lend voice to the rights of indigenous people. Justice, in his extensive contribution to environmental and constitutional law, that we have the rights of nature and the rights of human rights are indissociable. They must be associated. So protecting indigenous rights means protecting ecological balance that all of our society depends on. Vico Penawa said that the forest in the world is getting sick, and reinforced that the forest death would also mean the end of humanity. This vision summons us to an ethics of interdependence. It's not about protecting indigenous people only in the name of indigenous people, rather of recognizing that everyone's destiny is intrinsically connected to the preservation of indigenous culture, of indigenous land, and indigenous languages. President Joinel Wapichana Fanai showed that Brazilian democratic institutionality is strengthened when indigenous people are ahead of development of policies and that they deserve respect. Her life path is the final proof of full democracy, showing that without full autonomous indigenous participation guarantees not just legitimacy, but also effectiveness of rights. Among the themes that were debated, I'd like to especially highlight the demarcation of indigenous lands, the federal constitution of '88, which has set in stone the right of indigenous people to land. And as we know, they have an original right that came even before the formation of the state. However, its implementation has faced various obstacles, historical, political, and legal obstacles. The demarcation and protection of land is central to guarantee that indigenous people can live according to their ancestral knowledge and that they can teach everyone the way of living that respects the planet, and to teach current and future generations about the importance of all beings. And here the contribution of Professor João Torres reminds us of the right to property and the legal, Western legal tradition was based on individuality and property. However, for indigenous people, land is not an asset that is negotiable. It's a collective good with a spiritual, cultural, and material extension of their existence. When defending the idea of collective property and community management, Torres invites us to envision the classical legal concepts in a consistent manner, including ethical and moral dimensions as they are necessary for historical reparation for colonial periods. He argues that recognizing collective rights of land and not as a generous concession of the state, but rather as a way to correct structural historical injustice. That is the central point for justice to stop only be formal and to actually promote justice and to guarantee dignity to all communities as the law should ensure. In this sense, the process of demarcation is not just administrative or notarial, it is an act of civilizational recognition and affirming that the diversity of ways of living and of relating with land enriches society and strengthens democracy. UNDP is proud to have seen to be with the Brazilian state and its indigenous people in decisive moments of its history, such as the national policy of lands and land management and indigenous land management, and various struggles regarding COP30 that has to do with a fair energy transition and climate justice, inclusive bioeconomy, and directly promoting dialogues with indigenous cosmovisions or worldviews. We also joined the first, we also were part of the first payment for forest environmental services, which is an advancement in institutional mechanisms institutionalized in bioeconomy. We'd like to wrap up with the symposium with a renewed commitment to turn debate into action, dialogue into public policies, and principles into concrete decisions. UNDP would like to reaffirm its partnership with Brazil, its justice system, and National High Court with FUNAI, and above all with indigenous peoples who should be protagonists in a more democratic, more sustainable, more inclusive future. May the strength of cultural, linguistic, and territorial diversity celebrated here, may it echo, and may this encounter inspire judges, legislators, managers to recognize that the protection of indigenous people is also our protection of our common humanity. We hope that these discussions lead to a larger understanding and inspire collaborative actions and contribute to a future in which rights and cultures of indigenous lands in Brazil and the world are fully respected and protected. Thank you very much. Our Chief Justice could not finish. Well, we're going to leave here with a renewed spirit with the words of Professor Claudio. When we're talking about the rights of indigenous people, this constitutes a borderless dialogue, a permanent dialogue. And when listening to the words of our esteemed Professor Stacy Leeds, and I read about her life and her love for the Amazon and for all indigenous people. She came here, she slept in a hammock, she went to the river, she spoke not only with the mind but the soul of the Amazon. And here she spoke about the protection and the indigenous rights. In the name of our organization, I'd like to greet these two great speakers that finish our symposium. Now I'll pass the floor to our Chief Justice, Herman Benjamin. Well, I believe everyone is very tired indeed. And tomorrow is the day for a special court. Special court is when the 15 senior justices gather once every 15 days to decide on conflicts between the jurisprudence of various grand chambers of our court. Therefore, it's a day that for me at least as president or as the Chief Justice, I need to prepare and I need to be rested because it's not an easy day. Not easy to debate these big themes with 14 of my colleagues. Having said that, I'd like to once again thank each and every one of you, and especially to thank our foreign guests and representatives of indigenous people who are here with us, who came to our conference. We judges have a permanent risk in what we do. We decide on concrete cases, and concrete cases can bring us to isolationism in relation to the whole. In academia, the risk is quite the opposite. Through abstraction, we may lose contact with each concrete case and with reality itself. Of course, there are legal disciplines that have in their very structure and in its goals the most profound abstraction philosophy of law, for instance, or general theory of law. But generally speaking, legal disciplines must find this balance between reality and abstraction. And for us, judges, it's fundamental that we are able to see the forest, not just the trees, the concrete cases, because if we don't reach the forest, the whole holistic vision, the risk, and I'd like to repeat this using this word, the risk is quite large, rather of injustices or of incomplete or partial justice. In environmental law, we've been carrying out this permanent exercise here in the National High Court, the STJ. My colleagues know this. We have training, theoreticians coming in, practical courses, comparative law courses with the UN, without the UN, with all the different stakeholders in this mosaic that we call the environment. And it's necessary for us to do the same regarding Indigenous Peoples Law. First, because law is not just rights. We need to seek in law the formulations, the abstract, oftentimes formulations, so that we may apply and interpret the legal formulae which describe in constitutions and laws the rights. In relation to Indigenous Peoples Law, it's fundamental for us judges that we have at least some clarity regarding the reasons why we protect Indigenous people. I said reasons, plural. It's not enough to just tell us, judges, I mean, that's always the easiest formula. It's not enough to just say, oh, we protect them because that's what the Constitution determines and the laws determine. It's easy to explain it like that. But what is behind the Constitution and the laws? Is it simply an exercise of protection? We've debated this in various seminars of minorities. Would it be a protection of those who are vulnerable, of weaker parties? Would it be facing a historical injustice, as was mentioned here by a variety of our speakers? For me, and the beginning of it all is that we should understand that today's minority was once a majority, and that this majority became a minority through violence and genocide. I think that is our starting point. Not only that, but we must recognize that this majority, or rather this minority today, currently a minority, used to own, quote unquote, the land, all of this land. They lost this land through invasion. It's an invasion based on religious theories and legal theories as well. Terra incognita, unknown lands, for instance. Not only that, but we must understand that this minority past majority used to own the land in a manner that was and still is quite different from the understanding we have in our law, because it's a reciprocal relationship between humans and the earth, the land itself. The land also owned the humans. As a non-indigenous person, that's how I interpret it, at least. That's the reading I have of the relationship of the different indigenous peoples and the land. Before they owned, quote unquote, the land, the indigenous people are owned by the land. It's a reciprocal relationship, which is not strictly one of subject on the one hand and object on the other. Going further, it seems to me that this majority, now minority, was forced, and we cannot forget this. They were forced to learn the conqueror's language. Worse, to forget their own. Two violences in one. I need to learn the language of those that conquered me, and at the same time be forced to forget my own tongue. If you want to go further, we judges also need to think, and here we need to go a little bit further in depth. We need to think that the past majority, current minority, was invaded, was conquered physically. But the worst part is that this conquest needed to be spiritual. The soul needed to be conquered. Evidently, if the soul needed to be conquered, the relationship of the soul with the divine itself needed to be conquered and destroyed. Gods and goddesses started to be seen as the worst enemy of the conquerors, and this enemy led to the destruction of indigenous cosmologies. I could go on and on, but I'm going to be stopping here. In a final aspect that I believe is quite important, this exercise of understanding that we judges need to carry out the very foundations, the pillars of indigenous peoples' laws and rights. It's the relations of indigenous people with nature. Here, this is not a relationship between strangers. What we now call something holistic. This isn't law. This is not jurisprudence in the National High Court. Justice Benedito has precedents, beautiful precedents on this holistic view of environmental law. And the integration of the physical and the intangible, of the man-made and the nature, is complete. That does not mean an utopian vision of Shangri-La, of a Rousseau-like vision of the indigenous people. Rather, the important is the context in which all of this occurs. Believe that we Brazilian judges have a long and tough road ahead of us. It's a road that is made difficult by the law and the Constitution itself. Sometimes laws, and this is a home where we interpret the laws, the Constitution is interpreted by that other court, the Supreme Court. But laws oftentimes contradict themselves. They use different terminologies. And we need to have a vision of the forest, this whole forest, to give an adequate interpretation of these norms. So many that we have in Brazil. My last note, Justice Daniela, Justice Benedito, and I always say this, I'm sure you've heard me say this, that Brazil, we don't need activist judges, because activism in our country is in the Constitution and in the laws. We don't know up until when, because there are movements, permanent movements of erosion of the protection of fundamental rights, of human rights, of the environment, and of indigenous people. But we ourselves have applied here in our House of Justice the principle of non-regression. And the principle of non-regression applies specifically to the rights and law of indigenous people, and evidently also to the protection of nature. We also do not accept that the legislation is altered to allow torture. Clear indication that progress is forwards, never backwards. No steps back. Non-regression. It's the same for Indigenous Peoples Law or environmental law. Approved norms, in their essence, gain a life of their own. That's almost revolutionary. We weren't the ones who made this up. The Belgians did this. You're half Belgian, right?
The principle of agora me esqueci.
Now I forgot the name.
Non-regression, mas
Principle of non-regression, something like that, but
esqueci a
I
denominação.
forgot the name they gave in Belgium. Anyway, today in Brazil and other countries in Latin America, we adopt this principle in courts, the principle of non-regression. It's quite hard to do because we need to have the limitations. We can't delegitimize the legislative branch, but evidently this is a form of control, maybe sometimes against the majorities that we judges have in the Brazilian Constitution. We have the power and the duty to do this. Thank you so much, all of you. And see you in the third International Symposium of Indigenous Peoples Law. I see Giovanna almost despairing because she told me that she would not survive the second symposium. She survived and is happy. Minister Arnaldo as well. And all of you who are here, thank you so much. We close this event. Thank you.